Next matter is 2012 TRC 11530, 2012 TRC 10480, State of Ohio versus Angela Ferris. Ms. Ferris is present with counsel, Mr. Dawson. Mr. King's here on behalf of the Law Director's Office. We're scheduled for a change of plea in these matters today. Ms. Ferris, is it your wish to change your plea to guilty here today?
Yes, Your Honor.
Okay. Mr. King, you're dismissing two of the charges.
In case number 11530, I'm not sure what the one is, seems duplicative, and the other one shouldn't be on a traffic citation. And in the 10480, I'm dismissing the 4511 194.
194, okay. Is there... So there's two charges on that case.
Yes.
Yeah.
The A1A and the parking in a roadway would remain.
Okay, Ms. First, you understand that a guilty plea is a complete admission of your guilt?
Yes, Your Honor.
You understand your, well, did you sign these change of plea forms?
Yes, Your Honor.
Did you understand them?
Yes, Your Honor.
You understand by pleading guilty today, you're waiving your right to a trial, either to a jury or to the court.
Yes, Your Honor.
And did you sign these waiver of jury trial forms?
Yes, Your Honor.
At a trial, you'll be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today?
Yes, Your Honor.
You understand you're giving up the right to question any witnesses the state would have against you.
Yes, Your Honor.
And finally, you understand you're giving up the right to have the state prove beyond a reasonable doubt you did in fact commit these offenses.
Yes, Your Honor.
Mr. Dawson, you and Mr. King recount the facts today.
No, Your Honor.
Based on that, I'll accept Ms. Ferris' guilty plea, being voluntarily and intelligently made, knowing what her rights are. Find her guilty of operating a vehicle under the influence of alcohol, the .179 breath test, a red light violation, and operating a vehicle under the influence of alcohol or drugs, and a parking on a roadway violation. Mr. King, I assumed the code section was different in 2012.
That I don't know. The F, it should be an H in today's world.
Right.
But,
See if I can pull up the old statute here.
and the other thing, and for reasons I'm not real sure, when I went to print off the driving record, it just printed black. I don't know what was going on. That's important because of the 2002. I don't know when the conviction date was.
Mm-hmm.
So this would have either been her second or third within 10 years.
Possibly a second. Possibly. So October 27 and September 20. Is that
Yes,
correct? Okay.
correct.
All right. Prior conviction was February of 02, so that one would be outside of 10.
Okay, but the
And then
09
There's
is.
an 09, yeah. Okay. 2009. So 2 seconds, is that what you have, Mr. Dawson?
Right, yes, Your Honor.
Okay.
Do you want us to change the plea forms to that? Because I wrote them down as third. Is that
Oh,
what the-
did you? Okay.
That's what the
Yeah,
computer
well,
said.
I imagine the penalties weren't the same either.
Right,
So I'm going to look up, see if I can get the old statute up here.
thanks, sir.
2018, 21, 19. Effective September 11, 23. Okay. Yeah, it should be an H, I think, Mr. King.
Still an H. You want me to do the formal?
I think so, yeah, if you want to
Okay.
fix that.
No, that's a dismissal. I need an amendment.
F was a blood test. It looks like to me back in 20.
Yeah.
11.
It wasn't blood, so.
Yeah.
And I will get that done.
One second. 'Kay, so the statute was a 6-year look back, looks like back then, which would it still be inside the 2009?
Oh, that is true. It was a 6-year look-back period.
I forgot all about that.
I did
Yeah,
too,
it's-
until he
it's-
mentioned it. I went, wait a minute.
So the 2000, it would still be a second offense. So let's see.
Sorry, Your Honor, for the bad attorney.
It's an old
I
case.
forgot all about the 6 years.
Okay. And the minimum jail term is the same. Be 10 and 20. $525 fine minimum, so it's the same there as well as the previous prior to this year. Okay. All right, we have an amendment then
I'm working on it right now, Judge.
to a A1H.
Yes.
of 2019, and you missed your court date. So there was a warrant issued for your arrest. That warrant just happened to be out there all of this time until I see that you posted a bond here recently. Did you get arrested and go to jail last week? All right, so I do see that you posted a bond. I do see that you paid a cash bond and were released. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. Anthony, do you see this one, Travion Barnes?
Yes, Your Honor.
Give a PC real quick on this one.
Yes, Judge. On 8/3/2019, officer responded to a theft at Target. Officer met with LPO, who stated that the LPO observed defendant through surveillance selecting movies from electronics department. Defendant was observed passing all points of sale without paying.
All right, so, Mr. Barnes, the court's going to order some conditions regarding your bond. And Ms. Garcia, this on page 1, Barnes. Mr. Barnes, the court's going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. There's an allegation that this offense occurred at a Target, so the court's also going to order that you'll be prohibited from going to any Target store in Harris County. These conditions of bond are going to remain until this case is over with. I'm going to ask you, sir, to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, Mr. Barnes, you're going to need an attorney to represent you on this case. Are you working right now, sir?
Yes, sir.
What type of work do you do?
Do solar panels, make solar panels.
And how long have you been doing that?
I just started,
Okay.
the day that I was released, I'm paying the.
Okay, so you start, okay. Mr. Barnes, there's 2 options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you an attorney this morning?
Right now.
Yeah, I'll appoint you an attorney this morning if you want one.
Yes, sir.
Would you like a court appointment? Okay, so what I'm going to do then is I'm going to appoint you an attorney. There will be an attorney who's going to talk to you this morning about your case, okay? All right, sir, do you have any questions on anything that I mentioned to you, sir?
Yes, sir. Would this have anything to do with me missing work or anything?
What do you mean?
Like, or the conditions of which.
No, all you have to do is don't have any weapons on you and don't go to any Target store. That shouldn't cause you to miss any work. And there will be a lawyer that's going to talk to you this morning about what all your options are, okay?
And well, I'm in the middle of fighting with the kids back and everything, so I can't do none of them things anyway.
No worries. All right, so right behind you, sir, is my pretrial officer at the table. Go with her, sounds conditions, have a seat, I'll appoint you a lawyer. Okay, Millie, on page 1, Barnes Court appoint. Yes, ma'am, good morning, how are you?
How are you today?
I'm good, thanks. What you got this morning?
Good. I have Palacios, first name Gabriel.
Palacios?
It's spelled Gabriel, but it's Gabriel.
Oh, okay.
There's a little-
Oh, yeah, I see it. Okay, he's here?
Yeah, he's.
All right, let's call him up. Yep, Gabriel Palacios and Miss Anthony. This is on Palacios. I haven't heard probable cause in this case. Would you like the court to hear it?
Judge will actually be waiving
Okay.
probable cause on this one.
All right, no worries. Thank you. All right, sir. You are Gabriel Palacios. Mr. Palacios, you're here with your attorney. You're being charged with the offense of racing on a highway. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. I see that this was an offense that was alleged to have occurred on May the 2nd of this year. You were arrested on this charge. You did go to jail. You were released on a bond. So what we're going to do this morning, sir, is the court is going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense to determine the type of conditions of bond that the court is going to impose. So, Ms. Anthony, do you see this case? This is Gabriel Palacios.
Yes, Judge.
Let me hear probable cause real quick on this one.
Yes, Judge. On May 3rd, 2025, officer observed a gray Ford Mustang, a gray Pontiac, and a white Toyota Camry All three vehicles were traveling at high rates of speed on the main lanes of King Freeway. Officer was traveling over 100 miles per hour in an attempt to catch the vehicles and keep the vehicles in sight. Speed limit was 65 miles per hour. All three vehicles were in a clear racing competition side by side at points, accelerating at high rates of speed, attempting to outdistance and outgain each other. Traffic stop was conducted. Defendant admitted he was racing with other vehicles. Defendant had dash camera mounted and was activated during investigation.
All right, Ms. Palacios, the court's going to order some conditions of bond. So, Ms. Garcia, this is on page 8, Palacios. Mr. Palacios, the court's going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. This condition of bond, sir, is going to remain until this case is over with. I am going to ask you, sir, to sign this condition of bond. You will be given a copy of this condition. If you violate this condition of bond, sir, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. We are going to reschedule your case to allow time for your attorney to gather all the evidence that she needs. On your next court date, sir, you do not have to come to court. You let your attorney take care of your case. She will let you know if and when it's necessary for you to return to court. All right, sir, do you have any questions on anything that I mentioned to you? Any questions? All right. Right behind you, the table. Please also go with her, signs conditions, have a seat, and just reset the case.
Thank you.
Thank you. You're welcome. Yes, ma'am. Good morning, sir. Come on up. Yes, sir. How are you?
Doing great.
Good, good. What you got this morning?
Called newly cockstrap, new case.
Is that with a C?
Yes, sir.
All right, 1 second.
DWS.
What's the last name?
Cox, seal.
Okay. Oh, yeah. I have it right here. All right. Is he here?
Yes,
Oh,
sir.
let's bring him up. Newly Cox and Miss Anthony. This is on Cox.
Yes, Judge.
And counsel, I haven't heard probable cause on this case yet. Would you like the court to hear it?
Yes, we'll wait for it.
Okay. All right. Good morning, sir. You are Newly Cox? Mr. Cox, you're here with your attorney. I just wanted to inform you, sir, of what you are being charged with. You're being charged with the offense of driving while intoxicated. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. I see that this was an offense that was alleged to have occurred May the 3rd of this year. I see that you were arrested on this charge. I see that you did go to jail, and I do see that you were released on a bond. So what we're going to do this morning, sir, is the court is going to order some conditions regarding your bond. I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense to determine the conditions of bond the court may impose. So, Ms. Anthony, if you would, let me hear probable cause on Mr. Cox.
Yes, Judge. On 5/3/2025, officer was dispatched to a crash on a roadway in Harris County, Texas. Officer observed defendant's vehicle rolled over several times and upright. Defendant is registered owner of vehicle and was next to vehicle with no other occupants. Witness stated defendant's vehicle passed her up and almost crashed into her. Defendant had strong odor of alcoholic beverage and bloodshot eyes. Defendant stated he had 3 beers. HDN was 4 out of 6. Defendant had injured ankle from the crash and could not perform walk and turn or one-leg stand. DIC was read, breath was refused, and a blood warrant was signed.
All right, Mr. Cox, the court's going to order the following conditions of bond. And Ms. Garcia, this is on page 3, Cox. Mr. Cox, the court's going to order that while you're on bond, you will be prohibited from possessing any firearms or any weapons. The court is also going to order that while you're on bond, you'll be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you, sir, to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. We are going to reschedule your case to allow time for your attorney to gather all the evidence that he needs. On your next court date, sir, you do not have to come to court. You let your attorney take care of your case. He will let you know if and when it's necessary for you to return to court. All right, sir, do you have any questions on anything that I mentioned to you, sir?
He's asking you if there's a way to resolve it, but none of the blood is like.
Yes, they're probably going to analyze you. I believe that blood was drawn and they have to analyze that and they will, usually it takes a little while for the results to get back, but your attorney will get access to those results. Okay, anything else, sir? And you're Mr. Singleton, right?
Yes.
Okay, all right, so do you have any questions, Mr. Singleton? All right, right behind you, sit at the table, my pretrial officer, go with her to sign those bond conditions. Have a seat and we all going to reschedule your case, okay? Thank you. And just get my court, Mr. Singleton, and we'll reset the case. Thank you, sir. Good to see you. Okay, all right, Miss Anthony.
Yes,
Okay, it's the same effect, pretty much.
as well.
It's the same effect as the verdict program.
As the one
That's the verdict, like.
Oh, yes, it's the same.
Okay.
It just depends on what his blood comes back as. And there was an accident, maybe sounds, or he rolled.
It's the one we done last year. So the accident, it's about.
Candace May?
She gets married. She was in traffic and she wanted not that. So if we can get that.
What are the intersections?
So I'm trying 69 going south. 16 is here, gallery here.
Okay.
And she's to get off.
Yes, ma'am. Good morning, ma'am. You are Candace May? All right, Miss May, you don't have an attorney this morning, is that right? All right, Miss May, I just wanted to inform you of what you are being charged with. You are being charged with the offense of assault of a family member. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. And Miss Anthony, this is on Candace May.
Yes.
Miss May, I noticed that this was an offense that was alleged to have occurred on May the 4th of this year. There's an individual by the name of Adrian Howard that's accusing you of this offense. I see that you were arrested on this charge. You did go to jail. I see that you went before a magistrate judge at the jail. You were released on a personal bond, but I noticed that you were given some conditions. Actually, you were given 2 court orders by the magistrate judge. The first court order that I see is a protective order, which I have to believe you have a copy of. Do you remember getting a copy of protective order? Okay. I just want to remind you that that is a court order.
I have some comments.
All right, hang on. I'll let you make a comment. I just need to explain a couple of things, okay? On that protective order, I just do want to remind you that that is a court order. If you violate any of the conditions of that protective order, the state may file an additional charge, which carries a 1-year jail sentence. Now, I also noticed that the magistrate judge issued some conditions regarding your bond, which I also have to believe you have a copy of. And I want to remind you that that is also a court order, which if you violate any of the conditions of that bond, you're subject to having the bond that you're currently on revoked and you can be taken to custody. Now, Miss Anthony, do you see this case, Candace May?
Yes, Judge.
Do you know if anyone from the state has had any contact with the complaining witness, Ms. Howard?
They have not yet, Judge.
Okay. All right, Ms. May, you had a question regarding one of the orders?
So, Your Honor, I have paperwork here from my landlord stating that this person does not live in my house. She broke in my house, and prior to the incident that occurred before my arrest, she assaulted me and.
All right, hang on. All right, hang on. Hang on. Hang on.
I have.
Man, stop. Let me speak, okay? I know that you want to talk about your case, but right now is not the time to talk. So just relax. Hang on, okay? I just need to explain to you some certain things. First of all, this is an allegation. You are presumed innocent under the laws of our state and under the Constitution of the United States. Secondly, I have a prosecutor that's standing right here that is listening to everything that you're saying. I don't want you to say anything regarding what happened because I don't want something that you may say to be used against you.
That's fine.
If you say something that could be used against you, you cannot take it back.
I understand.
I would like and prefer that you exercise your Fifth Amendment constitutional right and remain silent. Okay? Every citizen and every person that lives in this country has a constitutional Fifth Amendment right to remain silent, okay, on anything that happened on a criminal matter. I would like for you to exercise that right.
You had a right to speak to.
Well, let's do this. I would prefer that you do this. You're going to need an attorney to represent you on this case. Okay.
I am on a restraining order from my own home that she broke into, and I have evidence right
All
here.
right, ma'am. We are not going to fight this case today. You are not here to fight this case.
I can't go to my home
Hey,
and
ma'am,
pay bills on.
ma'am, stop. All right, just hang on a second. The protective order that I see says that you're prohibited from going to a residence in Chicago.
In my home.
Ma'am, will you please listen to me? Okay, listen to me. The protective order indicates that you are prohibited from going to her residence in Chicago, Illinois, whatever residence that is. Secondly, I see that you are prohibited from going anywhere near any residence where Adrienne Howard may reside, may live. Okay. Now, I don't know all the information about where she lives, that she's living in your home, anything like that. Okay. I don't know any of that stuff. Okay. And unfortunately, I can't deal with that. I am just letting you know what your rights are, what you're being charged with, etc. Okay. What you're going to need is to have an attorney fight for you. That's what you're going to need. You're going to need an attorney to represent you on this case so that attorney can be able to fight for you. Now, there's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or you qualify for the court to appoint you an attorney this morning.
Okay. I haven't found an attorney because I'm not from the state.
Okay.
So I will take the attorney that's available currently, and I will search for an attorney.
All right, that's no problem. I don't have any problem with that. You say you're not living here?
I just moved here from a different state.
Okay.
Not from my
All right, because I do see that you listed your address at 10611 Crookrent in Houston.
Yes.
Okay. All right, so here's what I'm going to do. I'm going to appoint you an attorney this morning. There's going to be a lawyer who's going to talk to you.
Go to my home because.
Ma'am, stop. I'm going to appoint you an attorney this morning. That attorney is going to meet and speak with you this morning. You tell that attorney what it is that you are asking to do, what it is that you want to do. You tell that attorney that, okay? Let that attorney advise you. That's what attorneys do. They're here to help you on the situation that you're involved here. Let that attorney give you some advice as to what you can do in reference to what it is that you're asking. Okay? If that necessitates the attorney talking to the prosecutor in this case, they're going to do that. Hopefully we can figure something out this morning. Okay?
I need to go home.
Ma'am.
I can't go to my home.
Ma'am, will you please allow this attorney who's appointed to you handle your case? And you let that lawyer know what it is that you're asking. And let that attorney advise you. And hopefully we can resolve the issues that you're wanting to resolve today. I don't know because I cannot talk to you about your case. I cannot represent you. I cannot give you any legal advice. That is something that an attorney is going to do. So there will be a lawyer who's going to talk to you about that. And that attorney will go over all of your options and just tell that attorney exactly what it is that you're asking or wanting to do, and let that attorney give you some advice. Okay? All right, ma'am. In the meantime, you do have those court orders. They are valid for today. If we need to change those court orders, your attorney can come to me and make a request that they want to change the court orders. I will have to ask also the prosecutor about it, and those orders may be changed. All right, so just be patient, okay? Just be patient. This is something that's not going to usually resolve right away. Please be patient. All right. Any questions, ma'am?
Is there anything that could possibly be done today to escort her from my home?
Ma'am, you're asking me to give you legal advice, which I cannot do. I just told you, talk to your lawyer. Your lawyer will ask, or your lawyer will give you legal advice. I cannot give you legal advice. You're asking me to give you legal advice. I cannot do that. Do you understand that? Do you understand that I cannot give you legal advice? I don't represent you. I cannot give you legal advice. That is for your attorney to do. Okay? There's going to be a lawyer who's going to talk to you this morning. Ask them. Okay?
Okay.
All right, man, just have a seat. We'll appoint you a lawyer. Millie, page 6, Candace May, court appoint. Just have a seat. Yes, ma'am. Okay, I have some Spanish speakers. Yes, I see them. I have 2 Spanish speakers, I think.
Page 6, Joe.
Yeah, I see you on page. Good morning. This is Irma Horton. Page 6, on page 6. Irma Horton. Yes. Yes, ma'am. Okay. Take this. Thank you. Okay, ma'am. You speak English? Okay. I was told that you speak Spanish. Who's the other Spanish speaker, Lopez? Caballero? Oh, yeah. Okay, let's do this. Just have a seat for a second. I'll call you in a minute, okay? So just have a seat, okay? Jesus Caballero? I know. Okay, so this is Caballero on page 2. All right, and Miss Anthony, this is Jesus Caballero.
Yes.
Ms. Garcia is on page 2, Caballero. Okay, so you're Jesus Caballero? Mr. Caballero, you don't have a lawyer this morning, is that right? All right, Mr. Caballero, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the reasons why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, let's see. This is on Caballero. You may proceed.
On May 1st, officers were conducting surveillance of a group of car owners known to conduct hostile street takeovers in a safekeeping self-storage parking lot. Officers observed a 2007 Chevy Colorado with a retrieved Texas license plate to around 4 to 5 donuts in a pit
of 8 to 10 vehicles, getting within 15 to 20 feet of striking vehicles forming the pit. Officers observed a male and female passengers hanging outside of the windows. The male was 14 years old, the female 17 years old. The defendant was observed operating the vehicle in the driver's seat. The vehicle rear end whipped around wildly, nearly striking people spectating in their vehicles, and a spectator who was on foot recording. And this was an action capable of causing serious bodily injury. Traffic stop conducted.
All right, Mr. Cabello, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of reckless driving. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. You are 17, is that right? Are you here by yourself?
17. No, with my mom.
Is your mom here? Let's bring her up. Come. Do you live with your mom?
Yes.
Okay. I ma'am, you are Jesus Caballero's mother? Does he live with you?
Yes.
Are you aware of what he's being charged with? He's being charged with the offense of reckless driving. All right, let's do this, Miss Anthony. I'm sorry, I didn't realize that he was 17. If you can just do a small little summary of the probable cause for mom to hear.
Yes, Judge. On May 1st, 2025, officer was conducting surveillance of a group of car owners known to conduct hostile street takeovers. Officer observed in a parking lot group of vehicles doing donuts in a pit and getting within 15 to 20 feet of striking other vehicles. Officer observed female and male passengers hanging outside of the windows of vehicle, aged 14 and 17 years old during the donuts. Defendant was operating the vehicle and rear-ended another vehicle while nearly striking other people spectating.
Did your son tell you about this?
No, él acaba de salir de nosotros, vamos a una iglesia y en el caso de nosotros, ese día hubo, sí, pero él.
All right, so he didn't tell you why he got arrested.
No.
And he didn't. Okay, did he tell you what happened before he got arrested?
A él le pregunté cuando él salió y pues y él iba a comprar comida.
I asked him because he went out and wanted me to buy some groceries.
The allegation is that he was in a vehicle doing donuts with two people in the vehicle, minors, 14 and 17, and they were hanging out the window while he was doing donuts, allegedly. And this caused him to hit another car. Okay. Did he tell you all of that?
No.
Okay. All right, so. All right, man. Shh, man. Don't say anything. I'm just letting you know what he's being charged with and why he is here. Okay. There are witnesses. There are witnesses, okay. There are witnesses that are saying he committed this offense. And that is why he was arrested and charged, and that is why he went to jail. Okay? Now, he's 17, but under the laws of our state, he is considered an adult. And this type of offense has a punishment of up to 6 months in the county jail and up to a $2,000 fine. Okay? Now, Mr. Caballero, whose vehicle was it that you were driving? Was that your vehicle?
No, my mother,
Who is what? I'm sorry?
my mother.
Your mother-in-law. Are you married?
No, they're different.
Okay. So whose vehicle was this?
¿De quién era el vehículo?
De la mamá de la muchacha.
Okay.
They're friends.
Okay. Did she know what happened?
¿Tú sabes lo que pasó? Sí. Yes.
She knows. The mother-in-law knows what happened.
La señora sabe que pasó eso. Yes.
All right. Do you have a Texas driver's license, a valid Texas driver's license?
¿Hay la licencia de manejar de Texas?
No.
No.
The court's going to order some conditions regarding your bond.
Para operarte ciertas
And
condiciones.
did I give this, Ms. Garcia? Okay. Mr. Caballero, the court's going to order that you will be prohibited from driving any motor vehicle
De manejar cualquier vehículo.
unless you have a valid Texas driver's license.
Texas.
If you do not have a valid Texas driver's license
Texas.
or cannot get one, you cannot drive any motor vehicle. Do you understand? All right. Because of your age, the court is also going to order that you will be prohibited from possessing any firearms or any weapons. The court is going to order that you will be prohibited from drinking any alcohol or any controlled substances that you do not have a prescription for. No illegal drugs. Okay. Are you in school, sir?
Yes.
What school are you going to? Okay. What grade are you in?
9.
Okay. You're 17 years old and you're in the 9th grade. And it's pretty old to be in the 9th grade, isn't it? All right.
You understand my legal facts.
All right. Ma'am, I have the authority to issue additional bond conditions on your son. One of the conditions of bond that I have ordered before is a curfew where he stays at home after a certain hour. And do you see the time that this alleged offense occurred, like a time of arrest? What time did it happen?
Yes, let me check the OR, Judge. It looks like this was around 11:30 p.m., Judge.
So, Mom, the allegation is that this happened at 11:30 p.m. Let's see the date on this. What was the date of the offense? Let me see.
5/1, May 1st.
First. So that was Thursday night. Thursday night at 11:30 p.m. So, Mom, did you know that your son was not home Thursday night at 11:30?
Sí, y acabamos de terminar el culto y se fue a traer una comida.
Yes, we came back with the church and he went out to buy some groceries.
He told you he was going to go out and buy some groceries
He was taking things.
when this happened.
Primero que no fue en el primer momento porque era
So it was late. It was late.
We didn't come home, did we?
They call it.
He didn't come home, right? He didn't come home.
No, me di cuenta que sí, no, se tardó, se fue a 11, y a las 11:15 lo empecé a llamar y me di cuenta que el teléfono estaba.
So you did not know what happened to him, right? You didn't know he went to jail.
No, me avisaron con el monstruo para el clínico.
And then, okay. All right, Mr. Caballero, do you see what you did to your mother? She was very worried about you. She had no idea where you were. Okay. All right. One of the conditions that I can issue is a curfew. You know your son better than I do. Do you want me to order a curfew for your son?
Nosotros vamos a regresar de veces y no sé qué poniendo la consulta, pero pues él no sale.
How late do you get home from church? During the week?
Sí, vamos martes, jueves
And the church lasts till 11:30?
sí, de 8 a 11. Sí.
It's kind of late, isn't it?
Sí, se veía que iba a ir.
All right, well, I just need to know, do you want me to issue a curfew for your son?
Por ejemplo, la iglesia, la iba por la iglesia, la empresa.
Very complicated.
All right, then I won't do it. I'm not going to do it. It's okay. All right, Mr. Caballero, these conditions of bond, I'm going to ask you to sign. You will be given a copy of these conditions. If you violate any of the conditions of this bond, this court can revoke your bond and put you in custody. Do you understand? Okay. You're going to need an attorney to represent you on this case. Do you want me to appoint you an attorney this morning to represent you on this case?
Y sería hasta, pues, hasta cuándo sería
When is gonna be the court that we fight?
I don't know, but there'll be a lawyer who's going to talk to you today. Do you want me to appoint you a lawyer? Or do you want to find and hire your own attorney? I'll appoint you an attorney this morning. There'll be an attorney that's going to meet with you and speak to you this morning. All right. Mr. Caballero, do you have any questions on anything that I mentioned to you?
Sí, como ese del golpe que dicen que en el que yo andaba ahí,
Okay. Do not talk about what happened.
Okay.
Okay. All Any questions? Right behind you at the table is my pretrial officer. I don't know. You're going to meet with a lawyer today. Your lawyer will tell you what's going to happen. Okay, so right behind you, my pretrial officer, go with her. Sounds conditions. Have a seat. Millie, on page 2, Jesus Caballero, court appointed, Spanish speaking. Japala Kemp. Ms. Kim, can you hear me?
Yes, Judge, trying to
How are
get
you?
my camera and I'm good. How are you,
Oh,
Judge?
it's okay. I know who you are. What you got this
Thank
morning?
you.
There you go.
I have Ms. Duracell. Ms. Duracell has a DWI judge and we just need a trial date. I've spoken with her. It's a 0.79. I've spoken with her about it. They did offer us PTI. She cannot afford the PTI and
Okay.
we'd rather just set it for trial, Judge.
I believe she's here.
Yes, she's here.
Let me bring up Elizabeth Durisic. I don't know. I'm not.
Duracell.
Duracell. Okay. I know I was butchering that name. And Miss Anthony, well, good morning, ma'am. How do you pronounce your last name? Durso? Durso? I figured it's French because the last letters. All right, here's your lawyer. She's on Zoom. There she is. Okay, ma'am, you're here because you're charged with the offense of driving while intoxicated. It's a Class B misdemeanor, which means that you can get up to 6 months in the county jail, up to $2,000 fine. Your attorney has mentioned to me that you would like to have your case set for a jury trial. Now, Miss Anthony, on this case, I'm assuming that all offers have been made.
Yes, Judge.
And you received the offers, Miss Kemp?
Yes, Judge.
Okay, and one of the offers was a PTI,
Yes.
but your client says that she can't afford the fee or whatever?
Everything, Judge. The total amount, I told her, it'd be on a payment plan, but she said she can't afford it.
All right, Mr. Russell, I don't mind setting your case for trial if that is what you want. But I do need to let you know that if you do go to trial and you are found guilty, you are subject to being incarcerated for a period up to 6 months in the county jail and up to a $2,000 fine. So I just want to make sure that you're aware of that. Okay. So what I'm going to do, and Miss Anthony,
Yes.
is this a breath or blood test?
This was a breath, Judge.
And what was the results of the breath test?
0.079 and 0.079.
Oh, that's a decent tribal case. Sounds like, right, Mr. Mayor, 0.07? All right. All right, Judge Kemp, let me look at my calendar here. And let's see what day I can set you for trial. It's probably not going to be until sometime in August.
Okay, thank you, Judge.
That looks like it's the earliest I can squeeze you in.
That's fine.
Let me look at my calendar here. Okay, let me see. All right, I have available for trial Tuesday, August 19th. How does that day sound for you?
That works, Judge.
I'm sorry? I
Yes.
can't hear you.
That's like you a Wednesday or Thursday.
No, man, all my trials are Tuesdays. Sorry. Every single trial that we have are set on Tuesdays. Sorry. All right, so you said it's okay, right, Ms. Kemp, 8/19?
Yes,
All right.
Judge.
We'll set it for trial for 8/19 is a Tuesday. We are going to have a pretrial conference the week before, August the 14th. And that is only
Judge, can
for
we
the
make
attorney.
that one on a Monday just because she'll need to take off work?
Well,
so
she
can we
doesn't,
make
she
that
does
one
not
on-
have to be here at the pretrial conference. It's
Okay,
just for the,
perfect.
it's just for the attorneys.
Okay, thank you, Judge.
You're welcome. So we're going to set your case for what's called a pretrial conference, August 14th. You do not have to be here at that date, that court date, unless you want to. It's only for the attorneys to let me know if everybody's ready to go to trial and they have all their evidence, everything is ready to go. So I usually ask a week before if everybody's ready to go. And if they are ready to go, then we'll probably try your case on Tuesday, August the 19th. Okay? All right. So you got it, Ms. Kim, Tuesday, August the 19th. Is that all you have this morning?
That's it. Thank you, Judge.
Okay. Do you need a copy of the reset form, or do you want to just go ahead and just talk to your lawyer about that?
I need a copy.
All right.
Is it possible I need like a copy too, so I go to work?
Oh, yeah, I can give an excuse. So, yes.
Thank you, Judge.
Yeah, I can get you excuse. So on page 4, Durasek. Durso. Jury trial 819, pretrial conference 814. If you can give her a copy, and can we give her a work excuse? Okay, just step right over here and we'll give you a work excuse. Thank you. Mr. Mayor, good morning. Oh, is that what you have, Kim? Oh,
Yes,
good to
Judge,
see you.
thank you.
Your excuse. Thank
You
you.
too. Thank you.
Thank you. See you. Yes, ma'am. Come on up. I'm sorry.
Judge,
Good morning. How are you?
good.
What you got this morning?
Wanted to come talk to you about something quickly off docket.
Look quickly, because I
Okay, I just
docket here.
got a message yesterday from Stephanie. I just wanted to just kind of, the case number is 233
Huh?
6893.
Prater?
Yes, Judge. So we were told that he could do the Meals on Wheels community service. She said that you don't want him to do it. He has completed 5 hours. He does not have a car or anywhere to get anywhere. That's really what the holdup has been. His probation officer is trying to find him somewhere that was close to his house, like walking distance, because he doesn't have a car.
Okay.
So I offered him to do that and he was supposed to drop the bags off to the Meals on Wheels, which is a nonprofit.
Right.
And so I was just seeing if she said that she didn't want him to do that.
Stephanie didn't want him to do that.
Oh, she said she spoke to you and you said you didn't want him to do the Meals on Wheels. You wanted him to do another community, a nonprofit.
I'll be honest with you, I don't remember.
Okay.
She must have talked to me because she had a bunch of cases that she was talking to me, so I don't remember this one. I do see that he's got, 22 hours of community service he's got to
He's
do?
completed 5. He's completed 5 already with that. So even if you didn't want him to do it, I was seeing if he can get the credit for that. But he doesn't have a car or any way really to get around to get to these other locations.
Well, I know that the probation office has a set of nonprofit places to do community service.
And he was waiting for the one that was in his location, I think at the police station, and that's what the holdup has been on that. They haven't got it set up.
Okay.
So I was trying not to have it just keep going on for months and months for him to wait for that community service. So even if you don't want me to do it, just we could see if they can get the one with the police station. Can he get the credit for the 5 hours he's done?
As long as he provides some type of proof, does he have some type, okay.
They'll give him a letter.
Oh, yeah, that's not that. And then, so if he has the 5 hours proof and he has to do 22, so that means he's got 17 left.
And then I'll see if they can get him at the police station for the
Okay.
17.
That's fine. So he's on probation right now?
He is, Judge.
Okay. And did it get extended? I'm assuming it got extended.
We're just trying to complete the classes and the community service hours.
Okay, and then once he does that, then he can, his probation can be terminated?
Right, Judge.
Okay,
Okay, thank you.
you're very welcome. Okay, let's see who we have. Okay, all right. Luis Cortez Montellano. And Ms. Anthony, this is Cortez Montellano
Yes, Judge.
for PC. And Ms. Garcia is on page 2, Cortez Montellano.
Yes, Your Honor.
All right, sir, good morning. You're Luis Cortez Montellano? Mr. Montellano, you don't have a lawyer today, right? All right, I just wanted to inform you, sir, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. May 2nd, 2025, complainant stated that the defendant entered the convenience store and told the cashier he wanted to look at a pair of earrings. Complainant stated that defendant grabbed 2 sets of earrings and attempted to steal those earrings. Complainant confronted defendant and defendant got angry. Complainant told defendant that his business was no longer welcome at the location and that he had to leave. Defendant began shouting, "Do you want to fight? Come fight me. I will kill you. Come outside. I'm waiting." When defendant was told complainant was calling police, defendant left but went to a nearby location. Complainant showed CCTV of the incident and defendant is seen waving his arms in surveillance in a come here motion.
All right, Mr. Montellano, the court's going to find that there is sufficient probable cause to continue with your case. You're being charged with the offense of terroristic threat. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. So, Mr. Montellano, the individual that's accusing you of this offense is a person by the name of Imran Ali. I have to believe you do not know who that person is. Okay, no worries. So the court's going to order, sir, that you do not have any contact with that individual, and you are prohibited from going back to that store on Fondren. Do not go back over there. Secondly, you are also going to be prohibited from possessing any firearms or any weapons. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney, sir, to represent you on this case. Are you working right now, sir? You are? What type of work do you do?
Doing things.
Okay, how long you been doing that? All right, so there's 2 options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one this morning? Appointed? I'll appoint you an attorney this morning, sir. All right, Mr. Montellano, do you have any questions on anything that I mentioned to you, sir? All right, right behind you, the table. I'm free to also go with her. Sounds conditions. Have a seat. I'll appoint you a lawyer. Millie, page 2, Cortez Montellano, court appoint. Let's see here. Jonathan Ramirez. I'm sending this on Jonathan Ramirez.
Yes.
All right, sir. You are Jonathan Ramirez? Mr. Ramirez, you don't have a lawyer today, is that right? No. All right, Mr. Ramirez, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/2/2025, officer observed vehicle having an expired license plate as of 9/2024 and unconfirmed/expired insurance as of 2/25. Traffic stop was conducted. Officer smells a very strong odor of marijuana emitting from inside of the vehicle. Defendant admitted that he possessed marijuana inside of the vehicle underneath the driver's seat. Officer searched and found the bag containing marijuana where defendant stated it would be found. Weight of marijuana was 0.381 ounces. Officer ran defendant and found active warrants issued with the South Houston Police Department.
Okay, Mr. Ramirez, the court's going to find that there is sufficient probable cause to continue with your case. You're being charged with the offense of possession of marijuana. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. And Ms. Garcia, this is on page 9. Ramirez, okay, Mr. Ramirez, the court's going to order that while you're on bond, you will be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from consuming or possessing any controlled substance that you do not have a prescription for. No illegal drugs. These 2 conditions of bond are going to remain until this case is over. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, Mr. Ramirez, you're going to need an attorney to represent you on this case. Are you working right now, sir?
Yes, Your Honor.
What type of work do you do?
I do industrial.
Windows
Industrial,
Industrial? How long have you been doing that?
8 years.
Oh, okay. All right, Mr. Ramirez, since you've had steady employment for at least 1 year, the court's going to require you to hire your own lawyer. We're going to reschedule your case to allow you time to hire an attorney of your own choice. If you do hire an attorney, just have that attorney contact this court before your next court date. You do not have to come to court as long as you have an attorney representing you. However, if you do not have an attorney representing you on the next court date, you will have to return to court. All right, sir, do you have any questions on anything that I mentioned to you, sir?
How much is 0.8?
I'll be honest with you, I don't know. It's not,
How much?
I don't know. I don't know how much is 0.08. But I'll tell you what, when you get your lawyer, ask him. Ask your lawyer. But any amount is illegal. All right, any other questions? All right, right behind you at the table. Please also go with her. Sounds conditions. Have a seat. We'll reset your case. Millie? Jonathan Ramirez on page 9, THA. And I have another one for PC. Anthony Rowe. This is Rowe, ROWE for PC.
Yes, Judge, thank you.
I will let you know.
Good morning, sir. All right, you are Anthony Rowe?
Yes, sir.
All right, Mr. Rowe, you don't have a lawyer today, right?
I do not.
All right, Mr. Rowe, I just wanted to inform you, sir, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, may proceed.
Yes, Judge. On May 3rd, 2025, officer was entering the main lanes of East Texas Freeway when he observed 2 vehicles traveling at a high rate of speed in a competition to outdistance and outgain each other. Both vehicles were traveling at speeds over 100 miles per hour and continued to split around several vehicles in moderate traffic while chasing each other around. Officer observed vehicles launch around other vehicles at very close proximity, attempting to get back side by side with other vehicles. Traffic stop was conducted. Officer asked defendant why he was being reckless. Defendant stated he was just being ignorant.
All right, so the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of reckless driving. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning, sir, is of course going to order some conditions regarding your bond. And Ms. Garcia, this is on page 9, Rowe.
Yes, Your Honor.
All right, Mr. Rowe, I see in my system that you're 19, is that right?
Yes, sir.
All right, Mr. Rowe, the court's going to order them while you're on bond, you'll be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited because of your age from possessing or consuming any controlled substance that you do not have a prescription for. No illegal drugs. And because also of your age, the court's going to also order that you do not possess or consume any alcohol. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, Mr. Rowe, you're going to need an attorney to represent you on this case. Are you working right now, sir?
I am, sir.
What type of work do you do?
I work for a marketing company.
And how long have you been doing that?
We're for like 5.5, 6 months.
All right. I'm going to give you two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you an attorney this morning?
I'd like to appoint me a lawyer, sir.
All right. I'll appoint you an attorney this morning, Mr. Rowe. All right, Mr. Rowe, do you have any questions on anything I mentioned to you, sir?
No, sir.
All right. Right behind you, the table. Please also go with her. Sounds good. Just have a seat. I'll appoint you a lawyer. Millie? Page 9, Rowe, court appoint. All right, let's see who's next.
Waive your attorney, but you know.
Okay. Ian Davis and Miss Anthony, this is Ian Davis for PC.
I was going before that.
So you are Ian Davis. Mr. Davis, you don't have a lawyer today, right?
Yes, sir.
All right, Mr. Davis, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I am going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We'll talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, may proceed.
Yes, Judge. On 5/3/2025, officer was dispatched to an apartment in Harris County, Texas for a disturbance. Defendant was banging on the door and attempting to kick the door in. Complainant advised defendant does not live at the apartment, but has been allowed to stay occasionally. Defendant hit the door with a metal baton and used a knife to strike the porch ceiling. Damage was approximately $1,000.
All right, Mr. Davis, we're going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of criminal mischief, damaging some property. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So what we're going to do this morning is, of course, going to order some conditions regarding your bond. Now, Ms. Anthony, the complaining witness, is that individual, or is that like the manager of this apartment complex? Do you know?
It is an individual, Judge.
So it's a person by the name of Cassell Monroe,
Yes, Judge.
and that person lives at that location.
Yes, Judge. And I did speak to her this morning.
Okay.
I believe defendant is her mother's friend, but she would like no contact.
All right, Mr. Davis, do you know this person, Cassell Monroe? Your niece, okay. You don't live with her, do you?
Live with,
But you don't live with her. All right. There's no reason for you to have any contact with her at this time, right? All right. So the court's going to order, sir, as a condition of bond, that you have no contact with Miss Monroe. Do not call her, text her, email her, no contact whatsoever. And since you do not live also with her, the court's going to order that you do not go over to her residence. So don't go over to her residence. And the court is also going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, sir, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, Mr. Davis, you're going to need an attorney to represent you on this case. There's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one? I'll appoint you one this morning, sir. All right, Mr. Davis, you have any questions on anything I mentioned to you, sir?
Sir.
All right, right behind you at the table. And please also go with her, signs conditions, and have a seat. Millie, page 4, Eon Davis, court appoint. Okay, let's see who's next. Okay, the next person that I have, Miss Anthony, for PC is Perez, George Perez. George Perez! Coming up, sir. Good morning, sir. You're George Perez? Mr. Perez, you don't have a lawyer today, right? All right, Mr. Perez, I just wanted to inform you, sir, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we'll talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/3/2025, traffic stop was conducted on defendant's vehicle for failing to dim high beams. Upon approaching defendant, he was in the driver's seat. Officer observed odor of alcoholic beverage emitting from his breath. Officer observed 2 pills laying in plain view of the floorboard of the driver's compartment of the vehicle. 6 out of 6 HGM, 2 out of 8 walk and turn, 0 out of 4 one-leg stand. The IC was red and breath was consented. Breath was 0.086 and 0.083.
All right, Mr. Perez, the court is going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of driving while intoxicated. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. It also means, sir, that if you had a valid Texas driver's license at the time of your arrest, DPS may suspend your license as a result of this arrest. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. And Ms. Garcia, this is on page 8, Perez. Mr. Perez, the court's going to order that while you're in bond, you'll be prohibited from possessing any firearms or any weapons. While you're in bond, you will also be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. Okay, no illegal drugs. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you are going to need an attorney, sir, to represent you on this case. Are you working right now, sir? All right, there's 2 options regarding a lawyer. I can reschedule your case to allow you time to hire your own attorney, or would you like the court to appoint you an attorney this morning?
I would like the court to appoint an attorney.
I'll appoint you an attorney this morning, sir. All right, Mr. Perez, do you have any questions on anything that I mentioned to you, sir?
Yeah, as of right now, my license is suspended.
I don't believe so, because I see that this was an offense that was alleged to have occurred on May the 3rd. Looks like this was Harris County Constable Precinct 4. Did they confiscate your driver's license? Did they take it? No? Did they give you any documentation regarding your possible suspension of your license?
It just said that it was suspended We're not suspending that. It was temporary. It's just like suspended until this board did.
Well, no, I don't believe that's true. That's why I was asking if they gave you any documentation either when you got released from jail or anything. The law in Texas says that if you're charged with the offense of driving while intoxicated, DPS can suspend your license, but they're not going to suspend it yet. They will hold off for 15 days before they decide to suspend it. And then talk to your lawyer about this because your lawyer will tell you this. But you can request a hearing to try to fight to keep DPS from suspending your license. Okay. So since this happened May the 3rd, I don't believe that your license is suspended yet. It may be suspended, but once you talk to an attorney, just ask that attorney specifically about what you can do, what is your options regarding your license, etc. Your attorney will be able to talk to you and give you advice. But from what I can tell, just by looking at the paperwork in this, it does not look like your license is suspended yet. Okay. All right. Any other questions, sir? All right. Right behind you, the table. Please also go with her. Silence conditions. Have a seat. I'll appoint your lawyer. Millie? Page 8, George Pettis, court appoint. Irma Horton. And Miss Anthony. This is on Hortnung, Hornung. Irma.
Nice.
Okay. How do you pronounce your last name?
Harden.
Harnan? Harnan. Okay, Miss Harnan. All right. We don't have a lawyer today, right? All right. I just wanted to inform you, Miss Harnan, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you are being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Miss Anthony, whenever you're ready, you may proceed.
Yes, Judge. On May 3rd, 2025, officer responded to an accident involving a parked sedan and a Corvette that drove into it. Upon arrival, officers saw defendant wearing a multicolored dress standing right next to the driver's side of the Corvette. Defendant admitted to driving. Officer could smell a strong odor of alcoholic beverage, red bloodshot eyes, and slurred speech. Defendant advised officer that she was driving home when she struck the parked sedan. 6 out of 6 HGN, 5 out of 8 walk and turn, 4 out of 4 one leg stand. DIC was read and blood was consented to.
All right, Ms. Horton, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of driving while intoxicated. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do this morning is the court's going to order some conditions regarding your bond. So the court is going to order, ma'am, and Ms. Garcia, this is on page 6. Court's going to order, ma'am, that while you're on bond, you will be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. These conditions of bond are going to remain until this case is over with. I am going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, you are going to need an attorney, ma'am, to represent you on this case. Are you working right now, ma'am? What type of work do you do?
I'm doing English teaching.
Doing what?
Doing English teaching.
Doing.
Teacher.
Oh, teacher, I see. I'm sorry. How long have you been teaching?
20 years.
Okay. Well, I appreciate the hard work. Teachers is not easy. Because you have had steady employment for at least 1 year, the court's going to require for you to hire your own lawyer. We're going to reschedule this case to allow you time to hire your own attorney. Now, if you do hire a lawyer, ma'am, just have that attorney contact this court before the next court date. You do not have to come back to court as long as you have an attorney representing you. However, if you don't have an attorney representing you on the next court date, you will have to return to court. All right, ma'am. Do you have any questions on anything that I mentioned to you? No? Okay. Right behind you, the table. Please also go with her sounds conditions. Have a seat. I'll reset your case. Millie, page 6, Irma 14, THA. Let's see who's next. They said hopefully by the next week, Eric, who's the IT guy, said they're waiting for a part or something. So I know I've been, trust me, I've been talking to him about it, and they're working on it, but they don't have the part to that thing anymore because it's so old. That's the problem. So, it's not going to work. No, whatever it is zapped it, and they need to replace it, and it's a part, but they don't have that part anymore. Okay. All right, Ms. Anthony. Next person I have is an Earl Green. Earl Green. It's for PC.
And go right behind me, then we'll leave the next word.
All right, sir. Good morning. You're Earl Green. Mr. Green, you don't have a lawyer today, right? All right, Mr. Green, I just wanted to inform you that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we'll talk about what you're being charged with. We'll talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/1/2025, officer is dispatched to residence in Harris County, Texas for trespass. Complainant is renovating the property and currently not living there. Complainant stated that no one should be inside the property. Officer observed defendant on the property. Defendant admitted he knew he did not have permission to be inside of it.
The court is going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of criminal trespass. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So what we're going to do this morning, sir, is the court's going to order some conditions regarding your bond. So, Ms. Garcia, this is on page 5, Green. All right, Mr. Green, there is an individual by the name of Sherry Morissette that's accusing you of this offense, and she is the owner of this property. I have to believe you do not know who that person is. All right. Mr. Green, the court's going to order that while you're on bond, you will be prohibited from having any contact with her. Do not call her. I know you don't. So it shouldn't be a problem, but I had to put it in paper. Do not contact her. Do not call, text, email, Facebook, no contact whatsoever. And do not go over to that residence. Okay. And the court is also going to order as a condition of bond that you'll be prohibited from possessing any firearms or any weapons. These two conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You will be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, Mr. Green, you're going to need an attorney to represent you on this case. there's two options regarding a lawyer. I can reschedule your case to allow you time to hire your own lawyer, or would you like the court to appoint you an attorney this morning? I will appoint you an attorney this morning, sir. All right, Mr. Green, do you have any questions on anything that I mentioned to you, sir? All right, right behind you, sir, at the table, my pretrial officer, go with her, sign those conditions, have a seat, I'll appoint you a lawyer. Millie, page 5, Green, court appoint.
Thank you.
Jalen Hawkins and Naya. This is Hawkins, it's an MAJ. You okay, Mr.? This is not a PC one.
Oh, okay.
All right, so you are Jalen Hawkins. All right, Mr. Hawkins, you don't have a lawyer today, right? All right, Mr. Hawkins. I see that you are currently on probation out of this court. It looks like you're on probation for probation back in March of 2023. And I see that you were given a probation for a period of 1 year, and you were given conditions to complete your probation. I see that on March 31st of this year, it states out a motion to adjudicate guilt. What they're saying is that you have not completed your conditions of probation, and if you violated a couple of conditions of probation. Specifically, what I see is that you were ordered to undergo urine test. And the allegation, sir, is that when you did these urine tests, on multiple occasions, you kept testing positive for marijuana. I see the first urine test that you were given was May 31st of 2023. You were given a test in May of 2023, June of 2023, August 2023, December 2023, all positive for marijuana. You were given urine tests May of 2024, September 2024, December 2024, positive for marijuana. You were given urine tests January of 2025, February 2025, March of 2025, positive for marijuana. So this resulted in the state filing a motion to adjudicate guilt. They want to take away your probation. Now, because of this allegation, sir, you're going to need an attorney to represent you on this case. Are you working right now, sir? What type of work do you do? Where? At the airport. What do you do there at the airport? And how long have you been doing that? All right. You're gonna need a lawyer. I'll give you two options. I can reset your case to allow you time to hire your own attorney, or would you like the court to appoint you an attorney this morning? I'll appoint you an attorney. Now, you're still on probation. And now you need to see him, right? Do you need to see him this morning or no? You don't need to see him? Okay. Are you, have you been in contact with your probation officer lately? To probation? And did your probation officer tell you that you need to report back to probation or not? Or they tell you got to go to court? Okay. All right, let's do this. I'm going to appoint you a lawyer this morning. Your lawyer's going to go ahead and tell you what's going on in reference to your case, okay? All right, so just have a seat. I'll appoint you a lawyer. Millie, page 5, Jalen Hawkins, court appoint. It's an MAJ, Millie. Oh, yes, sir. Coming up, Mr. Acevedo. What's happening?
Okay, got it.
Good morning.
Happy Friday to you.
Happy Friday. Thank you. What you got this morning?
Yeah, so I know that Miss May Candace, I was just recently appointed on her. She was up here earlier this morning. And you've already read PC, but if I could have a chance to question the PC.
Sure. This is on, what's the last name? Sorry?
May, M-A.
Oh, okay.
Miss Candace May.
Oh, yeah, I see it right here. All right. So if you would, Miss Anthony, let's see. Pull this case up.
Yes, Judge.
Because I didn't hear PC. It looks like the magistrate heard PC. So I was just going with what the magistrate ruled. So since I haven't heard it, you're more than welcome to request it. So I don't mind hearing probable cause. So if you would, Ms. Anthony, let me hear PC on Candace May.
Yes, Judge. On May 4th, 2025, officer was dispatched to a family disturbance call in Harris County, Texas. Officer observed a verbal altercation between complainant and defendant and separated the parties. Taking statements from both, officer observed a fresh small knot on the top of complainant's left eye. Complainant stated she had video of the altercation. Officer observed video that showed defendant as the aggressor. Complainant stated defendant struck her 4 times, either with a fist or with her cell phone.
The reason I'm raising a PC concern.
Yes, sir.
Because nowhere in the statement is it established what the relationship is between them. It doesn't say specifically if they're sisters and if they're mother and daughter. It doesn't really say what the relationship is, and that's an essential element of the charge that she's been.
Yeah, I do see the charging instrument does say that, let's see, the complaining witness is a member of the defendant's family. All right, do you see anywhere on there, Ms. Anthony, what the possible relationship is between the complaining witness and Ms. May?
Let me check the DIMS, Judge.
Okay. Now, I believe that Ms. May had mentioned something to the fact that they were living together, but I'm not sure.
That's not stated in the probable cause.
Yeah, now I didn't hear that, I know. So that's what
It does say that it's called regarding the family
disturbance, correct.
But that's a conclusory statement.
No, I know. I understand.
That's not a fact. That's just a.
I agree. It's just a conclusory statement, but in order for someone to be charged with assault of a family member, there has to be some type of establishment of what that member of the family is.
Investigation needed to at least, if you have that question, need to be stated in there.
Correct.
Yes, Judge, it is stated in the OR. It says that complainant advised the deputies that she lives there. So it looks like they live together.
So the complainant advised the deputy that she resides at this residence with Miss May. Is that what it says?
Yes, at Kerwin Drive, Houston 10611 Kerwin Drive.
Say it again, I'm sorry.
Oh, yes. Complainant advised deputies that she lives there, and the address was the Kerwin Drive address, Judge.
10611 Kerwin Drive.
Yes.
That's the address listed for Miss May on the charging instrument.
Yes.
Okay, so the allegation is that this individual lived at this location along with Miss May. Is that right, Ms. Anthony?
Yes, Your Honor.
Now, it doesn't say anything about a particular relationship like, within, I guess, 2 or 3 degrees of consanguinity, like cousins, I don't know, any type of family. It's just saying that they just live together.
Yes, Judge. I'm looking at the OR right now. This is a DVD case, but let me see if there's any other information.
The thing is, I've already seen a document that shows that this lady's not on the lease.
Okay.
She apparently was a guest that day. So again, that would be a conclusory statement too.
Correct.
So we would question that as well.
Okay.
Although I know you're not reviewing evidence at this time.
Correct.
I think the statement is really thin at this point as to.
According to case law, a individual that resides with someone can be considered a member of the family household. Now, I don't know exactly the time period, though, that someone has to, I guess, reside. I don't know if it could be just one day. I don't know.
Just spent the night.
Yeah.
That's a guest. That's not a.
Yeah, well,
right.
And I'm not sure if the case law says a specific time period. Yeah.
I'd be a family member of Hyatt and Hilton. And all.
Oh, I know. Well, me too. Okay. Well, in terms of the charging instrument, let's just hypothetically say it's not a member of the family. She still could be charged with the offense of assault. Yeah.
I don't disagree with that.
Yeah. So, I mean, they can easily, if that's the case, and they determine that it's not a member of the family, the state can easily amend the information to remove that part and then just have a charge of assault.
And that's important to me.
Yes.
Because That's her home.
Yes, I
The guest
understand.
doesn't live there.
No, I understand that.
My client has protective order. She can't go back home.
Yeah, in fact, the
And
protective
have
order,
some freeloader living in her
Well,
home who's just a guest.
I know. The protective order specifically says an address in Chicago, Illinois, because I'm looking at the protective order. And it also says at any address the individual may reside. Now, do you happen to know if this complaining witness is still, I guess, at that location?
We believe she is. She is from Chicago.
Okay.
Then she was just a guest.
Okay.
Now my client's prohibited from even going back to her house where her children live with her because this lady is staying in her home as a freeloader, 19-year-old freeloader.
Okay. I hear what you're saying. I hear what you're saying. Unfortunately, I don't have any jurisdiction in terms of determining, residency or anything like that.
But if you determine there was no probable cause for the actual charge and they have to amend it to an assault, which I acknowledge that may be possible, that may change the dynamic of her being able to get back into.
I understand. However, I don't know whether or not there exists a family member relationship, because it's possible that even if the report says that she was living there. Now, the issue is the time frame. Now, it's a fact issue. So as a fact issue, I cannot take that into consideration for purposes of probable cause. The only thing that the court determines in probable cause is reasonable suspicion. That's it. So if there's a reasonable suspicion to believe that the complaining witness lived at that residence, and that there's reasonable suspicion to believe that there was an assault that was committed, then probable cause could exist for the charge of assault of a family member. So unfortunately, I cannot find no PC. I do have to find PC, and you would have to fight the fact of whether it's a family member or not. Now, in terms of her situation, I empathize. Trust me, I really do empathize of the possibility that this person does not reside there and she's maybe taken advantage and staying there. And now she's prohibited, your client prohibited from returning to that residence. I do sympathize, but unfortunately, I can't prohibit, I can't change the fact that she's prohibited from going over to a residence. Now, I guess, here's what you can fall on. The bond conditions and the MOAB do not specifically have that address where your client resides. Does not specifically say 10611 Crook Rin Drive. There's nothing in the protective order that has that address. There's nothing in the bond conditions that have that address. All it says is she's prohibited from going over to any residence that the complaining witness may reside. So now, what does that mean?
This is the first for me.
Yeah.
Being in a situation like this, I believe what I'm trying to get to is, would it be okay if the court put some language somewhere that would say that she's allowed to evict this person on the civil side, and that would not be considered harassing? Because
I can't, because I don't have jurisdiction over that. I don't have jurisdiction to order someone to leave a residence, a home, what have you. I don't have that authority.
I know you're not the judge for eviction cases.
Correct.
Get that, and you don't have that authority.
Correct.
But I don't want the state to come back and rearrest her if she tries to evict this person from her own home. If she's got the evidence to go to a municipal, do that, and that not be considered harassing.
Well, I don't see, let's see, the bond conditions say no contact. That's what it says. Bond conditions says you shall have no contact with the complaining witness.
If she goes to municipal court, stands in front of a municipal judge.
Yes.
And has the sheriff or the constable.
Yes.
Give a citation to this person to come and show why she has a right to be in her home.
Yeah.
I'm just hopeful the state does not consider that harassing. And she needs to get back into her home. That's what
I agree with you. I agree with you there. And I don't know whether the state's going to consider that a harassment. I mean, that's just a legal challenge. I mean, I guess any type of lawsuit file, whether it be eviction or whatever, I guess you can consider that harassment, but it's really not. It's just a legal challenge to.
Right.
Exactly. There's a legal right and there's a legal challenge. So I don't anticipate the state's going to say that's a harassment because it's a legal document, it's a legal finding, and it's up to whatever the court who has jurisdiction to hear that. I would not consider that harassment. I would just consider that a legal, binding, authorized filing. And I would not necessarily consider that a harassment.
Okay.
So yes, you would probably have to go to and this was, I think, Constable Precinct
Constable Precinct 2, I think.
yeah, Constable Precinct 2. So she would probably have to go to Precinct 2, Justice of the Peace Court. Yeah, now there's two places, there's two Justice of the Peace Courts in Precinct 2. And I don't know specifically where this particular address lies. But just looking at the zip code, because I'm familiar with that zip code, I'm not sure if you're familiar with it.
No,
77009. That is in the Scarsdale area. It's over there off of 45 South. You could exit Scarsdale. You
Near
could
the
exit,
Beltway, that area?
it's past the Beltway.
Well,
Well, no, it's not that far. It's probably 45 South. Probably one exit before the Beltway, which is Fuqua, or an exit or two after the Beltway, which is Scarsdale, and I believe it's 1959.
I've been to the Perry's Lake with Stars.
Okay, so that area right there is zip code 89. Okay, so that's where I believe that area is located, and the precinct constable in that area is on Beamer. I believe it's Beamer Road, yes.
Almost in Paradise.
Well, no, it's not quite. So if you go down, let's see, I'm trying to think.
I'm
of
just saying it's
Beamer.
in the direction.
It's in that area. And that is, and I know that particular JP very well. So that is precinct 2. And that's probably the JP that she needs to go. Yes. To file any type of eviction process.
Okay.
So, I mean, and I'm just saying that because based on just the zip code, because I'm familiar a little bit. Hi, Ms. Pierce, how are you?
Your Honor, I respect your decision on
Yeah.
PC. I just want to have this conversation.
Yeah.
Because she has rights. And
No, I know.
I want her
We're
to
talking about Ms.
exercise
May.
civil rights
Yes.
without them being misinterpreted.
So, yes.
The complaint with.
So we've attempted to, I called her last night, another colleague called her this morning, no answer. So what I was about to do was text her and ask her, like, because I think that the other ADA that was working on it had texted her, but I'm just going to text her right now and say, please call me. Hopefully we can figure.
I'm not going to show the state her entitlement to this home.
Yes.
She's got,
Yeah.
and she's have landlord statement saying this is her home, not.
No, I understand that. I understand that. And like I said, the bond conditions or the MOAB do not specifically have that address. Okay. So, I mean, if she tries to attempt to go back, I mean, the bond conditions and the MOAB did not say that address. However, if she is staying there, then she could be in violation of the
But I
MOAB.
think she should do, I'm not saying I'm
Yeah.
getting, she should go through the legal process.
Correct.
Civil process. If she has the right to her home, then
Correct.
the civil process should allow her to get back in her. home.
Correct. I agree
Not
with you.
that being considered harassment in this point.
Yeah, and like I mentioned, that should not be because she's got a legal right to file, legal documents, lawsuit against someone that should not be
This is
considered.
not her
harassment.
husband that lives there,
No.
he's under the lease, he's not, this is not that
Right.
situation.
Right. Yes. So see if you can try it just by any chance.
And I'll show the dates her documents so that they're aware of the
Okay.
situation as well.
Yes, of course. And yeah, I have, I don't doubt like her, entitlements of property. It's just trying to figure out who's, yeah.
Yeah, no, I agree with you. I have no doubt that that's her residence at all. And I don't necessarily want to prohibit her from going back to the residence. Unfortunately, I don't have the authority or jurisdiction to make that decision. So yeah, she'll have to go to another court that has that jurisdiction. That would probably be JP Precinct 2
Okay.
in that area.
Okay, thank you
Okay.
for your time.
You're welcome.
Let's step out on the phone call.
Yeah, thank you. I appreciate it. Thank you.
Can you come over real quick?
All right, let's see.
That document.
Let's see what I have next, Miss Anthony. Okay, Zachary Morgan. Good morning, sir. You are Zachary Morgan?
Yes, sir.
Mr. Morgan, you don't have a lawyer today, is that right?
Okay.
All right, Mr. Morgan, I just wanted to inform you, sir, of what you are being charged with. You are being charged with the offense of criminal trespass. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. I see that this was an offense that was alleged to have occurred a long time ago, December 10th of 2023. I see that you were arrested on this case back in 2023. You were released on bond and you were required to come to court December the 18th of 2023, and you missed your court date. So there was a warrant issued for your arrest. Then afterwards, I do see that you eventually got arrested again back in March of 2024, got released on bond again. You did come to court on that particular occasion, but then your case was rescheduled to May the 6th, and you missed your court date on May the 6th. So there was a warrant issued for your arrest. Then I see that it looks like you got detained in Travis County, and you posted a bond in Travis County. And then once you posted that bond, you were required to come back to court in reference to that case, and you missed your court date once again. So there's a warrant issued for your arrest back in April of this year. And then I see now that you looks like you got detained again in Harris County, went to jail, you posted a bond, is that right?
Yeah, I tried to come up to reset my court, to get a new date.
Okay. Because you had a warrant.
Yeah.
Okay, no worries. You posted a cash bond. I do see that you went before a magistrate judge while you were in custody. I do see that the magistrate judge went ahead and issued some conditions regarding your bond, which I have to believe you have a copy of. I want to remind you, sir, that that is a court order. If you violate any of the conditions of that bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, Mr. Morgan, you're going to need an attorney to represent you on this case. There's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you one this morning?
So appoint me a lawyer.
I'll appoint you an attorney this morning, sir. All right, Mr. Morgan, do you have any questions on anything that I mentioned to you, sir? All right, if you would just have a seat, I will appoint you an attorney this morning. Millie, on page 7, Zachary Morgan, court appoint. All right, I have one more PC to hear, Miss Anthony. And I'll have, oh yeah. Where's Tin Santana? Thank you. All right. So this one is, I have to spell the last name.
Okay.
Z is in zebra. ZHERNAKOV.
Got it.
Natalia Zernakova. I believe that's how you pronounce it. Good morning, ma'am. How do you pronounce your last name?
Zernakova.
Zernakova. Zer, okay. And is it Natalia? Zernakova. Okay, Ms. Zernakova. You don't have a lawyer today, right? All right. I just wanted to inform you, ma'am, of what you're being charged with. You're being charged with 2 offenses. You're being charged with the offense of failure to stop and give information, and you're being charged with the offense of driving while intoxicated. Now, there has not been a judge that has heard probable cause on your failure to stop and give information case. So I'm going to ask the assistant district attorney to read to me the facts surrounding why you were arrested and charged with that offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We're going to talk about any conditions of bond the court may impose, and then we're going to talk about an attorney. All right, Ms. Anthony, so let me hear PC on the FSGI, but I think it's out of the same transaction as the DWI.
Yes, Judge, it is.
So let me just hear PC on it.
Yes, Judge. On 5/1/2025, officer was dispatched to a crash in Harris County, Texas. Officer observed a white Chevrolet being blocked by the complainant's vehicle from fleeing. Upon making contact with defendant, officer observed strong odor of alcoholic beverage, glassy eyes, and unsteadiness. Complainant stated to officer that they observed defendant run a red light, turning left, striking the vehicle at the intersection. Defendant fled the scene without attempting to stop and exchange information. Complainant followed for 3.5 miles and was able to pass defendant and block her from fleeing. Complainant noted that defendant was intoxicated and removed the key from defendant's ignition. Defendant admitted to drinking a glass of wine and half a glass of whiskey before driving. 6 out of 6 HGN, 8 out of 8 walk and turn, 3 out of 4 one-leg stand. DIC was read, breath was refused, and a blood warrant was signed.
All right, Mr. Nicole, the court is going to find that there is sufficient probable cause to continue with your case. You're being charged with the offense of failure to stop and give information. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. And Ms. Garcia, it's on page 14. All right, so Mr. Nakova, I do see that you are also charged with the offense of driving while intoxicated. And I see that you were convicted of the offense of driving while intoxicated March of this year out of this court. So this is a driving while intoxicated as a second offender. Now, that particular case is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So what we're going to do this morning, ma'am, is the court is going to issue some conditions regarding your bond. The court is going to order, ma'am, that while you're on bond, on your failure to stop and give information, you will be ordered that you will be ordered or prohibited from possessing any firearms or any weapons. You're also going to be ordered to prohibited from drinking any alcohol or any controlled substance that you do not have a prescription for. Ms. Garcia, do you see the bond conditions on the DWI? Do you want to mirror that on this one? Is it
One here, but I see that she called pre-trial saying she doesn't own a vehicle.
Oh, so we have
And she was
to,
ordered an interlock device.
so we have to amend them.
I don't know if you would like to ask her.
I noticed that they checked off both of them.
Yes.
So we have to amend that anyway to remove one.
Yes, and then she was ordered no driving with the interlock device. so
Yes.
It would make sense.
Yeah, we'll figure it out. Okay. All right, ma'am. Are you wanting to drive a motor vehicle after today?
No, my vehicle is not functional, right?
Okay.
So I order portable device.
All right.
And I will.
All right, so let's do this. So let's amend the conditions and put a portable device and let's waive the fee, agency pay. All right, so here's what we're gonna do.
My device will be ready on Monday. I pick up on Monday.
Oh, great, I appreciate it.
I already did.
Thank you. The original bond conditions that the magistrate judge ordered has the interlock in your vehicle and the portable. We cannot have both of them. So I'm going to take away the interlock on the vehicle and just have the portable device. Now, you also are going to have to undergo random urine test. We're going to test your urine to make sure you have no alcohol or any illegal drugs in your system. And since you're amending, let's go ahead and add no weapons.
Yes, Your Honor.
Okay, so you're also going to be ordered not to possess any firearms or any weapons. And because we are ordering a portable device, you're not allowed to drive a motor vehicle. No driving, okay? Now, these conditions of bond are going to remain until this case is over. I am going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney to represent you on this case. There's two options regarding a lawyer. I can reschedule your case to allow you time to hire your own attorney, or would you like the court to appoint you an attorney this morning? I'll appoint you an attorney this morning, ma'am. All right, Ms. Zornikova, do you have any questions on anything that I mentioned to you, ma'am? All right, right behind you at the table, my pre-toss will go with her. Silence conditions, have a seat, I'll appoint your lawyer. Millie, page 14, two cases. Zornikova, court appoint.
Same conditions. You should appear in court each time they require you to do it.
Okay, let's see who's next. Kenneth Starling.
It's agency based, so you don't have to pay any. You undergo the job now for testing. These are the data. We're not allowed to drive by the permission of the court, so we're not seeing it. Drinking and alcohol. These are not.
Okay, so you are Kenneth Starling?
Yes, sir.
Mr. Starling, you don't have a lawyer today, right? All right, Mr. Starling, I just wanted to inform you, sir, of what you're being charged with. You're being charged with two offenses. You're being charged with the offense of driving while intoxicated, and you're being charged with the offense of failure to stop and give information. Both of these cases, sir, are Class A misdemeanors. I'm sorry. Both of these cases are Class B misdemeanors, which means that you can get up to 180 days in the county jail and up to a $2,000 fine on each case. I do see that you, let me see, these were offenses that were alleged to have occurred on May the 3rd of this year. It looks like you got involved in an accident, and the allegation is that you fled from that accident. You did not stop to give information such as your insurance, etc. And you are also being charged with the offense of driving while intoxicated. You were arrested on both of these charges. You did go to jail. You went before a magistrate judge, a judge at the jail. I do see that you were released on a personal bond on both your cases. I also see that the magistrate judge went ahead and issued and ordered some conditions of bond that I have to believe you have a copy of. I want to remind you, sir, that that is a court order. If you violate any of the conditions of that bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Let's see something. Miss Anthony, on this case, Starling,
Yes, Judge.
do you see if anyone from the state has had any contact with the complaining witness?
Not
Is
yet,
it- okay.
Judge.
All right, Mr. Starling, there's an individual that's accusing you of having this accident and leaving. That person's name, John Piles. I have to believe you don't know who that is. All right, so Ms. Garcia, this is on page, this is going to be on page 11, the FSGI. All right, sir, the court's going to have to order some conditions on bond on your failure to stop and give information because you weren't given those conditions. The court's going to order that you be prohibited from having any contact with this individual that's accusing you of this offense, John Piles. Do not call him, text him, email, no contact whatsoever, okay? The court is also going to order that you be prohibited from possessing any firearms or any weapons. These conditions of bond, sir, are going to remain until this case is over with. I'm going to ask you, sir, to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. Now, you are going to need an attorney, sir, to represent you on both these cases. Are you working right now, sir?
Yes, sir.
What type of work do you do?
I'm a inventory specialist for the city of Houston Health Department.
How long have you been doing that?
Prior to now, 2 years, I laid it off for about 4 months and they hired me back. So I've been back since February.
February this year? Oh, so you just got hired back? Okay. All right, I'll give you two options, sir. I can reschedule your case to allow you time to hire an attorney of your own choice, or would you like the court to appoint you an attorney this morning?
I would like for y'all to get a time.
I'll appoint you an attorney this morning, Mr. Starling. All right, Mr. Starling, do you have any questions on anything that I mentioned to you, sir? All right behind you to your right at the table, my pretrial officer. Go with her, signs conditions, have a seat. We'll reset, we can appoint you.
Regarding the DWI.
Yes.
He has a no driving petition.
Let me see. Hang on.
I don't know if he's aware of that.
Well, he wasn't given a monitor or anything.
No, but he's not allowed to drive for long conditions.
Mr. Starling, do you have a valid Texas driver's license?
Yes, sir, I do.
And it looks like this is his first DWI. Okay. I do see that you were given conditions of bond of no driving. All right. Let's remove that. I'm going to allow you to drive, Mr. Starling, as long as you have a valid Texas driver's license. Now, I do have to tell you, and you can talk to your attorney that's going to be appointed this morning, DPS may suspend your license as a result of this driving while intoxicated case. Talk to your lawyer about that. If your license gets suspended, you can't drive. Okay, but talk to your lawyer because there's a possibility that you can fight from keeping your license being suspended. But your attorney's going to have to tell you what they need to do. Okay.
Yes.
All right. So let's amend the conditions then.
Yes, Your Honor.
And remove the no driving and add no weapons.
Yes, Your Honor.
Okay.
There's a no threatening or harassing with an officer.
Just remove that too.
Yes, Your Honor.
We don't need that.
Yes.
Okay. All right, sir. Then right behind you is my preacher. Also go with her. Sounds conditions. Have a seat. I'll appoint you a lawyer. Okay. Thank you. Millie, on page 10 and 11, Kenneth Starling, court appoint. Okay. Christopher Santana.
Your attorney's position, no? No legal violations?
I think that's the last one
Yes, Judge.
on my docket. I do? Oh, God. Oh, no, I appointed him a lawyer already. Anthony Rowe. Okay. All right, so you're Kenneth Santana?
Yes, sir.
Mr. Santana, you don't have a lawyer today, right?
No, I don't.
All right, Mr. Santana, I just wanted to inform you, sir, of what you're being charged with. Actually, let me take it back. Ms. Anthony, this is Kenneth Santana for PC.
Yes, Judge.
I just wanted to inform you, sir, that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your, didn't say anything, I just want you to listen. The facts of your case determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with, what conditions of bond the court may impose, and then we'll talk about an attorney. All right, Ms. Anthony, whenever you're ready, you may proceed.
Yes, Judge. On 5/2/2025, officer observed defendant driving on a roadway in Harris County, Texas. Defendant was traveling at a high rate of speed and making unsafe lane changes without signaling. Vehicle registration was also expired. Traffic stop was initiated. There was a passenger in the vehicle. Officer observed strong odor of marijuana and a PC search was conducted. Officer located a plastic bag with marijuana in the driver's side footwell. Officer also located alprazolam on passenger side. Passenger denied it was his. Defendant suggested that it was his girlfriend who uses alprazolam who may have left it. Defendant admitted to each door his girlfriend had a prescription. Alprazolam weighed 0.5 grams for a single pill.
All right, Mr. Santana, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of possession of a controlled substance. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. So, Ms. Garcia, this is on page 10, Santana. So, Mr. Santana, the court's going to order some conditions regarding your bond. The court's going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. While you're on bond, you will also be prohibited from consuming or possessing any controlled substance that you do not have a prescription for, okay? These conditions of bond are going to remain until this case is over with. I'm going to ask you to sign these conditions of bond. You'll be given a copy of these conditions. If you violate any of the conditions of this bond, you're subject to having the bond that you're currently on revoked, and you can be taken to custody. Now, I do see that you were also arrested for the offense of possession of marijuana, and that is a felony. I see that you've already gone to court, and that case was rescheduled to July the 10th. All right, so Mr. Santana, regarding this case, you are going to need an attorney to represent you on this case. There's two options regarding a lawyer. I can reschedule your case to allow you time to hire your own attorney, or would you like the court to appoint you one this morning?
If you could appoint me one.
I'll appoint you an attorney this morning, sir. All right, sir, do you have any questions on anything that I mentioned to you? All right, right behind you, the table. My preacher also go with her, signs conditions. Have a seat, I'll appoint you a lawyer. Millie? Page 10, Santana, court appoint. Ms. Bridges? Cindy Bridges?
Yes, can you see me?
No, but I can hear you. There you are. How are you?
Hi, Judge, how are you?
I'm good, thanks. Okay, are you approaching on Mosqueda?
Yes, Your Honor, Nancy Mosqueda.
Okay, I believe she's here. Nancy Mosqueda? Come on up, ma'am.
Your Honor, she is a Spanish speaker.
Oh, she is? Oh, okay. Are you sure? I mean, I don't mind. Te conseguimos un intérprete si quiere.
No, it's okay.
okay.
It's okay?
Yes.
Okay. All right, now, Ms. Bridges,
Yes, Your
I
Honor.
haven't heard PC on this case. Would you like the court to hear it?
Yes, Your Honor.
All right, so Ms. Anthony, this is on Nancy Mosqueda. All right, Ms. Mosqueda, you Nancy Mosqueda? Okay, there's your lawyer right here, Ms. Bridges. All right, Ms. Mosqueda, I see that there has not been a judge that has heard probable cause on your case yet. So I'm going to ask the Assistant District Attorney to read to me the facts surrounding why you were arrested and charged with this offense. When she's reading the facts of your case, I don't want you to say anything. I just want you to listen. You have your attorney present, Ms. Bridges. She can respond for you. After I hear the facts of your case, the court is going to determine whether there exists enough probable cause to continue with your case. If the court does find probable cause, then what we're going to do is we're going to talk about what you're being charged with. We'll talk about any conditions of bond that the court may impose, and then we're going to reschedule your case. All right, Ms. Anthony, whenever you're ready, you may proceed.
On May 4th, officers observed verbal disturbance at a restaurant in Harris County. Officers began to handcuff the defendant's husband when the defendant got in between, preventing the officer from handcuffing. Another officer grabbed the defendant and pulled the defendant away. The defendant then attempted to walk away from the officer when she heard the officer ask for another pair of handcuffs. Defendant continued to resist and walked away.
All right, Ms. Bridges, any response to the PC that you've heard?
Yes, Your Honor. The summary and facts in the Harris County summary in there, when the officer gives the PC, what happened was there was an officer in the girls' bathroom, and she went into the bathroom, felt extremely uncomfortable, went and told her husband. The husband was griping with the manager about the fact that there's a male in the female's bathroom. And the police went and got into that situation. She was pulling her husband back, trying to get her husband to, you know what, that's their job, their business, whatever, we're leaving, trying to pull her husband back. She never interfered with their public duties. That argument is between the husband and the officer. But the facts that was shown in the summary of facts that is provided to the defense, she was simply putting her hands on her husband, trying to get her husband pulled away and pulled back to protect her husband. I mean, she just got into a bathroom with a male in there. So she was in a trauma type thing. So I do not believe they had the PC to charge her with interference in public duties.
All right, so Ms. Anthony, do you have the OR on this one?
Yes, sir.
Oh, I'm sorry, Miss. I didn't see you there. All right, Ms. Siegler, this is the Harris County Sheriff's Department. And if you can pull the OR, let me hear the facts in the offense report.
So interestingly enough, Your Honor, I pulled up the OR. For some reason, it is pulling up blank. We did just get the OR today, this morning.
Okay.
So maybe there was some sort of a system error. So we do not have it
All right,
yet.
so what does the dim summary specifically
Yes.
say? That were officers dispatched to a disturbance?
Officers one was working an extra job,
Okay,
observed and was advising patrons to exit the building due to closing hours, observed a male at a disturbance with the business owner's wife near the restroom. And then that male was upset because he observed the deputy inside of the women's restroom. The deputy was advised that a female wasn't feeling well inside the restroom and was throwing up. Deputy went to the restroom to investigate, located the female not feeling well. Defendant's husband appeared to have been offended in some way that a male deputy was inside the restroom. Deputy tried to explain why I was in the restroom. The defendant approached her husband, attempting to pull him away, but the defendant's husband did not, continue to argue.
Sorry. I'm sorry, Ms. Siegler.
Go ahead. So the defendant did not continue to argue, you said?
Yes, sir.
Okay.
Officers got in between defendant's husband and defendant and attempts to diffuse the situation, telling defendant's husband he needed to exit the building, business was closed. And then defendant's husband slapped officer on the left side of the face with the left hand, causing pain. Officer placed him on the ground while attempting to do so. Officer was able to grab defendant and pull her away so that he could place defendant's husband in handcuffs. And then defendant attempted to walk away when she heard deputies ask for another pair of handcuffs. Continued to resist and tried to walk away, placed in handcuffs, and they detained defendant and defendant's husband.
Now, the defendant's husband was charged with what?
One moment.
Because I do see that it's a co-defendant. And was he also charged with interference?
Assault public servant.
Okay, so that's a felony.
Yes, sir.
Okay, so husband was charged with assault public servant. Miss Nancy Mosqueda was charged with interference with public duties.
Yes.
Okay, so what I heard, Miss Bridges, is basically what you told me. There was a deputy that entered the women's restroom, according to the report, to check on someone that wasn't feeling good. Miss Mosqueda's husband approached and he was upset as to why the male officer was inside the women's restroom. I did hear that Miss Mosqueda approached her husband to kind of diffuse it and basically kind of stop what's going on. And then apparently I heard that there was some type of an altercation, which led the officers to try to detain Mr. Mosqueda. Did you say, Ms. Ziegler, that he was taken to the ground?
Yes, sir.
So he was taken to the ground and he was being detained?
Yes, sir.
And did the officer put in his report the reason that Mr. Mosqueda was being detained?
It appears he attempted to pull away and continue to argue with the deputy. And he slapped the officer on the left side of his face.
Okay, so that was Mr. Mosqueda allegedly.
Yes,
and so that is what caused the officer to detain and possibly arrest Mr. Mosqueda with the offense of assault of a peace officer. And then in terms of Miss Mosqueda, I heard something to the effect that they were asking her, I guess, to leave or what have you.
So while they were placing him.
Handcuffs?
Yes, sir.
Okay.
Defendant gets in between her husband and the deputy, preventing deputy from handcuffing her husband. And the defendant was attempting to grab someone's hands. Then deputies were able to grab defendant, pulling her away so they could place her defendant's husband in handcuffs.
All right, so I have Ms. Bridges from what the state said. I heard that officers were trying to detain and possibly arrest Mr. Mosqueda, the husband. And then I hear that Mrs. Mosqueda, the wife, was trying to prevent that from happening by grabbing or getting in between her husband and the officer. And then eventually Mr. Mosqueda was detained, and then the officer wanted to detain Mrs. Mosqueda, and she was refusing to get detained. That's what I heard. Now, I also see in the charging instrument, Ms. Bridges, the charging instrument says Nancy Mosqueda on or about May 4th, 2025, did then and there unlawfully with criminal negligence, namely physically place herself between Deputy Cayo and suspect in Mosqueda, which I have to believe is the husband, preventing Deputy Cayo from handcuffing suspect Mosqueda, interfere, disrupt, impede, and interfere with Deputy Cayo, a peace officer, while Deputy Cayo was performing a duty and exercising authority imposed and granted by law. So the facts that I heard on the probable cause is that the officer wanted to detain and arrest Mr. Mosqueda, and that Mrs. Mosqueda got in between trying to prevent that from happening. Now, what is your argument in reference to those facts? Ms.
Yeah,
Tracy?
my argument is that there has to be a mens rea, intentionally, knowingly interfere, interrupt. When she was trying to diffuse the situation, the police officers were fine with it. And just to make sure the court knows, my client is not the intoxicated female in the bathroom. She was going to the bathroom when a male deputy entered the bathroom. So I wanted the court to know that she's not the highly.
Right, she was not she was not the person that they said was, I guess, ill in the women's bathroom.
Right. She's the one she was using the bathroom when he went.
Correct.
She went out and told her husband. She wasn't intending to interfere, interrupt, anything like that. As the facts went on, the state is saying that she's trying to defuse the situation, which is what she's trying to do.
Correct.
It all is going in a flash, it's really fast. When they have him in handcuffs, she realizes what's going on and she's walking away. So she is not intentionally or knowingly trying to cause an interruption of public duties. She's trying to diffuse the situation so they can go home. So the mens rea is the issue here.
Well, what I heard is that they were trying to detain Mr. Mosqueda, and they were trying to handcuff him, and they took him to the ground because there's an allegation that Mr. Mosqueda hit an officer. And then what I heard is that Mrs. Mosqueda, once that happened, got in between her husband and the deputy. Now, if you don't mind, Ms. Silo, can you read that part where the allegation is that Mrs. Mosqueda got in between the officer and the deputy when her husband was, I guess, detained or on the ground?
Mr. Mosqueda then slapped officer on the left side of the face with the left hand. Officer used force against Mr. Mosqueda, placing him on the ground while attempting to place handcuffs on Mr. Mosqueda. Ms. Mosqueda got in between officer and Mr. Mosqueda, preventing officer from handcuffing Mr. Mosqueda as defendant was attempting to grab hands. Officer was able to grab Ms. Mosqueda and pulled her away, said he could place Mr. Mosqueda in handcuffs. Ms. Mosqueda then attempted to walk away from officer, and she heard officer ask another officer for handcuffs. They grabbed Ms. Mosqueda. She continued to resist and tried to walk away from officers. She was then placed in handcuffs without further incident.
That's what I heard, Ms. Bridges, is that once Mr. Mosqueda was being detained and attempted to be handcuffed, because the allegation was that he hit this officer, Mrs. Mosqueda got in between the officer and her husband, trying to prevent the officer from handcuffing her husband. Now, the charging instrument says that that she on May 4th did then and there unlawfully with criminal negligence. Criminal negligence doesn't necessarily mean that you have to have mens rea. Physically placed herself between Deputy Cayo and suspect in Mosqueda, which is her husband, preventing Deputy Cayo from handcuffing suspect in Mosqueda. Interrupt, disrupt, impede, and interfere with Deputy Cayo, a peace officer, while he was performing the duty and exercising authority imposed and granted by law. So what I heard is that Mrs. Mosqueda got in between the deputy and her husband, trying to prevent her husband from being handcuffed. Now, as you're well aware, Ms. Bridges, the court just needs reasonable suspicion, which is a very low bar.
Yes, sir.
And the court needs is to take the totality of the circumstances into consideration to believe whether or not there was a criminal offense that took place.
Yes, sir.
So based on everything that I've heard, the court's going to find that there does exist sufficient probable cause to continue with this case. All right, so Ms. Mosqueda, the court's going to find that there is sufficient probable cause to continue with your case. You are being charged with the offense of interference with the duties of a public servant. That is a Class B misdemeanor, which means that you can get up to 6 months in the county jail and up to a $2,000 fine. So what we're going to do is we are going to issue some conditions regarding your bond. And Ms. Garcia, this is on page 7, Mosqueda. Ms. Mosqueda, the court's going to order while you're in bond, you'll be prohibited from possessing any firearms or any weapons. This condition of bond is going to remain until this case is over with. I'm going to ask you to sign this condition of bond. You will be given a copy of this condition. If you violate any of this condition of bond, you're subject to having the bond that you're currently on revoked, and you can be taken into custody. We are going to reschedule your case to allow time for your attorney to gather all the evidence that she needs. On your next court date, ma'am, you do not have to come to court. You let your attorney take care of your case. She will let you know if and when it's necessary for you to return to court. All right, Ms. Mosqueda, do you have any questions on anything that I mentioned? Do you have any questions, Ms. Bridges?
No, Your Honor.
Are y'all representing the husband too up in district court?
Mr. Reyes, I
Mr. Reyes.
represent Ms. Mosqueda under my law firm.
Okay, no worries. All right, so Ms. Mosqueda, right behind you is my pretrial officer. Go with her, silence conditions, have a seat. We're going to reschedule your case, okay? All right, thank you. And Millie, this is on page 7, Mosqueda. I just need a date for discovery for Ms. Bridges. Ms. Bridges, July 16th, is that a good day for you?
It is, Your Honor.
All right, we're going to reset this case for July 16th, and we're going to go ahead and give a copy of the reset form to your client.
Thank you, Your Honor.
You're welcome. Is that all you have?
That's all I have.
All right, thank you. Good to see you. You're
Thank you.
excused.
You too.
You're welcome. Give her a copy, please. Thank you. Mr. Darvishi. Yes, sir. How are you?
Not too bad. How are you doing?
I'm good. What's happening?
Oh, I've got a new client I'm going to, Mr. What was that again?
Oh, so you're doing court appointments now? Oh, really? I didn't know that.
I do one.
Maybe once in a while?
Maybe once every 2 or 3 weeks.
Oh, really?
So
now you're handling the criminal trespass.
yeah, just any kind off it I take and put a little work up on, you know?
Yeah, I hear you.
I saw with some of those.
I heard you hired a new associate too. Congrats. Good. Right out of law school, huh?
Yeah, she graduated last night, actually.
Oh, is that right?
She had taken the February bar and passed while she was still in school.
Oh, nice.
So I think she will be licensed officially today.
So she took her commencement yesterday. We had commencement.
Yeah.
Oh, nice.
I haven't had to take off today so that she could
Yeah, get all that.
probably, do all that. So.
Well, good. I mean, it's funny. My wife also she got licensed too.
Yeah.
She took the July bar, but she didn't graduate until December.
Yeah.
So she took the bar before she graduated.
Yeah.
So,
I knew I had like 4 classmates, I think, that did that back in the day. I was just like, that's nuts. But I know they got our results the day of our final exam. I remember telling one of my friends, I go, hey, bar results just posted, before they sent the email.
Right.
It's just a list. I was like, you passed. And we were going into a 3-hour exam. I got finished in like 20 minutes.
Well, I did the same thing. I took the bar exam before I graduated too. I took the July bar and I didn't graduate till December. And same thing, I found out that I passed before I even took my last final. And I was basically the same way.
Yeah.
They told Mr. Controversy, no, we're not gonna hire
I was
you.
a spiteful person. I framed that letter in my office and used to be like that.
It's okay, I'll show you, huh?
You know, I mean, definitely all worked out.
Yeah, it works out. Yeah, things work out for a reason.
Yeah, I had a friend get arrested a couple weeks later and he's like, can you represent me? I'm like, sure. Yes. Yeah. Ended up being kind of fun.
And the rest is history now. All right, so Mr. Morgan, yes.
So he has a bond condition in place to stay within Harris County and contiguous counties on a trespass.
Yeah, I mean,
And,
I didn't even look at what the bond conditions were. I just saw you had bond conditions.
Yeah, and he lives in Austin. So,
Oh, is that right? Okay, I do see that he has travel restrictions. Okay, well, it is in Austin now. Okay. All right, so let's amend the conditions. I don't mind amending the conditions. I'll remove that part of the travel restrictions. So I'll remove that. So you won't have any issue whatsoever, as far as restrictions within travel within the state. And he can reside anywhere he wants to. And I'll keep the rest of them in place.
Perfect.
Okay, all right, good. As soon as my pretrial officer gets here, I think she went to another court real quick.
Okay.
I'll let her know. I'll amend it, have your client sign it, give him a copy. Just get with my coordinator Millie to reset it. And if you have any other place to go, just take off and we'll make sure that we give a copy to your client and we'll excuse him as soon as he gets copies.
Works for me.
All right, good to see you.
Good to see you too.
All right, take care. Oh, by the way,
That's all we do every time I'm in that court. So much that, I mean, pleasant reasons for talking everything.
oh yeah, I know, right?
Before I got this.
I know.
He's judges, he's on the message boards and all that stuff, just like me and stuff. So,
When they played tech here in basketball,
yeah.
I have season 2. and we're gonna remove the restriction to the county. He has to remain in Harrison and surrounding. We're gonna remove that.
Would you like to keep, in the other section what the magistrate judge?
Let's see. Which one was that? The possession? Which one?
No, in the other section, like right at the bottom, he needs to provide, that he needs to check in.
Oh, no, he lives in Austin. No, let's remove that too.
Okay, yeah.
And he's here, and then so whenever you're ready, just call him up and he can sign the conditions, and then we can release him. Case has already been reset. Thank you. Okay, I think that's all we have. Oh, we do? Who's that? Oh. Robert Thompson? Come on up.
Yeah, something like the last,
I looked at it on the all the stuff. It seems like he goes to this actual play. Spitting lots. Where there's a lot getting those.
All right, so you are Robert Thompson? Mr. Thompson, you don't have a lawyer today, right? No, sir. I'm Mr. Thompson. I just want to inform you, sir, what you're being charged with. You're being charged with the offense of unlawfully carrying a weapon. That is a Class A misdemeanor, which means that you can get up to 1 year in the county jail and up to a $4,000 fine. I see that this was an offense that was alleged to have occurred February 14th of this year. It looks like that there was an investigation that was being done by the Harris County Sheriff's Department. It looks like they conducted a traffic stop on a Black Ford Expedition on Veterans Memorial Drive. Let's see here. They said that while they were searching the vehicle, they're conducting a search for firearms. They found one under the driver's seat with ammunition in the chamber. Then he also said that the officer found a bag containing a green leafy substance in the middle console. Says here that you told the officer you claimed ownership of both the marijuana and the gun, and that the vehicle was towed and you were transported to LBJ Hospital. And then while you were there, apparently you got released from the hospital, but they contacted the district attorney's office and they filed charges against you back on February 25th. And there was a warrant issued for your arrest. It looks like you got detained and went to jail last week. Is that right? Okay. You were released on bond. So now what we're going to do this morning, sir, the court's going to order some conditions regarding your bond. So, Ms. Garcia, this is on page 11, Thompson.
Yes, sir.
So, Mr. Thompson, the court's going to order that while you're on bond, you'll be prohibited from possessing any firearms or any weapons. This condition of bond, sir, is going to remain until this case is over with. I'm going to ask you, sir, to sign this condition of bond. You'll be given a copy of this condition. If you violate any of the condition of this bond, sir, you're subject to having the bond that you're currently on revoked and you can be taken to custody. Now, Mr. Thompson, you're going to need an attorney to represent you on this case. Are you working right now, sir?
No, sir.
All right, Mr. Thompson, there's two options regarding a lawyer. I can reschedule your case to allow you time to hire an attorney. Would you like the court to appoint you one this morning? Okay. All right. So what we're going to do then is we're going to reschedule your case to allow you time to hire an attorney. Now, Mr. Thompson, if you do hire an attorney, just have that attorney contact this court before the next court date. You, sir, do not have to come back to court as long as you have an attorney representing you. However, if you do not have an attorney representing you on the next court date, you will have to return to court. All right, sir. Do you have any questions on anything I mentioned to you, sir? All right, right behind your table, and preach officer, go with her, signs conditions. Have a seat. We reset your case. Thank you. Millie, page 11, Robert Thompson, THA. Yes, sir. Good morning. I'm good. How are you? What you got this morning? Hawkins, all right, let's see. Yeah, it's just like. Oh, yes, it's a MAJ. He's on probation for theft. And there was an MAJ file, I believe, March of this year. I don't know if you had a chance to look at the motion to adjudicate.
I have, Your Honor, I've looked at the allegations. I see there's outstanding restitutions to be paid and there's quite a bit of marijuana.
Yeah.
Positive UAs.
In fact, that's what caused the MAJ is all the positive tests on his UAs. So eventually they decided to make it. Sir.
I believe my client would be, since the motion has been filed, he has been absent. I believe if another test were done, he would be next.
Okay. Have you talked to the state about this case yet? Or not?
And I just, in the nature of the case, I don't, I'm sorry, because the nature of the case, I don't really want the court to see if he's addressing the marijuana by abstaining, then, and he just recently had a $640 pre-owned payment.
Oh, good. All right, let me look at, because he was given, let's see how long. He was given a 1-year probation back in March of 2023, which meant that he expired March of 2024. He must have been given an extension. Okay, Nyla, can you check this case, Hawkins? It's on page 5. Do you see, has he been extended? Has his probation been extended?
His probation was extended
For a year? When does it terminate? So September of this year, it terminates, okay. Let's see, I do see the positive test for marijuana. I'm looking at the conditions to see what other conditions that he was given. Okay, he's got to pay restitution. And that's the one that you're mentioning he's making payments on?
Yes, sir. He did make a $640 payment. He showed me the receipt for it, maybe very recently, so it might not be on the system yet.
Naya, do you know if you know what his balance is on his restitution, if you know it?
I have the previous balance.
Okay, what's the previous balance?
$720 delinquent restitution.
All right, so if he made a $600 payment, then it'll eventually get credited because that hasn't hit the system yet. So then he owes a little bit more. For sure, I would like for him to pay his entire restitution.
Yes, sir.
And this is a theft case, and let me see what other conditions besides restitution, UAs, just kind of standard stuff. Okay, all right, so he is eligible to terminate September. All right. I would like to see several negative UAs before I can consider terminating this probation. You said that he can do a UA today and that he anticipates that that's going to be negative.
I believe it should be based on the amount of days that he's going to spend. It should be.
Okay. Naya, do you know if he is scheduled or not scheduled to report to his PO? Or can we set it up for him to report to his PO?
Judge, his next office visit is on the 15th.
This month? Next week, okay.
So your application.
Can we do a UA today over at 49? But you won't get the results for a few days, right? And then when he reports to probation, I guess I want him to do another UA. And then is he reporting once a month?
From what I see, it's almost monthly.
Monthly, and monthly UAs. Okay. Here's what I would like to see. I want him to do a UA today. He's going to probably do a UA when he reports to his probation officer next week. He's going to be doing monthly UAs when he reports. I would like to see a consistent amount of negative UAs. His probation doesn't terminate till September. So if he can show me 4, maybe, I don't know, depends, negative UAs, then I could probably consider, and he has to pay his restitution. I will probably consider either reinstating him or terminating him. Let me see what his MHA also alleges. Let me see here. I know his UAs. I know that he fell behind on supervisory fees. Hasn't paid his drug fee test, court cost. Let's see. His failure to submit an evaluation of education skill. Do you still see that? Ms. Nye, this is on his conditions of probation. The MAJ list, it lists that he failed to submit an evaluation of his education skills. I'm sorry?
I see it as of June of 2020.
Right, he hasn't done it yet, right? Okay, so I need for him to do that too.
Yes.
And the rest of it is just really fees, which, you know, he can terminate owing fees, but I do want him to pay his restitution, negative UAs, and he's got to do he has to submit an evaluation of his education skill level. That's done in probation, right, Naya? That is done at the probation?
Yeah.
And his officer can go ahead and, can you note that?
Yes.
Can you put on there, you don't know if they can do it when he reports next week, you know?
I'm sure they probably could.
All right. If you don't mind putting that note, so tell him he's going to do a evaluation when he reports next week, negative UAs, and pay off his restitution. If he does that consistently, then I will consider either terminating his probation, or just putting him back until he finishes in September, one of the two.
Okay.
And where does he need to go, Knight, for his UA to 49th City Center where?
To the 5th floor.
Okay. All right. Can you let him know? 5th floor. You know where it is, right next door?
Yes, sir.
5th floor. Does he have to tell anybody, alert anybody that's going to do UA?
I have to.
All right. Can you just let somebody know that Mr. Hawkins, Jalen Hawkins is going to go over there to do UA. He doesn't have to come back to court, and we'll just wait for the results. We should get it back. I'm sure Stephanie will get it back, and then he'll report next week and continue reporting. And I want him tested every time he reports to probation. Now, it'll help his cause if he voluntarily tests on his own without having to wait every time he goes to probation.
Sure.
I mean, don't know if they can test them at the region where he reports. Now, do you know if he wants to do a voluntary test for UA, can he do it at the region? You know?
I don't know. I can find out.
And he has to pay for that test though, right?
Let me find out.
Okay, because I want him to voluntarily do a UA. But he has to pay for it.
Yes, sir. Okay.
All right, let's do this. Let's set him for about a month.
Okay.
And let's see how he's doing between now and June. And let's just monitor him.
Sounds good.
And then if he's doing well, then eventually the state can file a motion to dismiss his MAJ, and we can make a decision as to terminate him or just wait till he finishes in September.
Sounds good.
Okay? You got it. You're very welcome. Yeah, just let me know, Naya, if you can do that.
Okay.
Thanks. Yes, sir. Hey, what's up? How are you?
Morning, Judge.
Glenn, how are you?
Doing okay. How about yourself?
I'm good, thanks. What you got this morning? Gano, happy Friday.
Judge, approaching on, he's in custody of Jesse Haddon.
Okay, let me see. Haddon?
Yes, we're set for an arraignment.
Oh, yes, it's a failure to ID, but I'm sure that's not keeping him in custody.
No,
It must be the felony that he's in custody for.
Yes,
Okay.
I'm going to direct the court's attention, Judge, to a felony in the 178. That is the reason why he's,
Oh, he's on a deferred. And they filed a motion to adjudicate?
Yes.
Oh, yeah.
Yeah.
I see it.
So I'm going to have a conversation with Ms. Anthony here to see how we can possibly resolve this case. But for the schedule today, Judge, I've already had a conversation with my client. What we're going to do right now is we're going to waive the arraignment, but I just need to set bond conditions.
Well, we anticipate that he can bond that, but he's got a zero bond.
Yes, on that note, he informed me that on the 6th of this month, they had set a $100,000 bond for that felony, and he is expecting to bond out.
Really? He can post $100,000 bond?
He came to an agreement with the bail bonds company, and they agreed to sponsor his bond.
That costs him some money, though, right? When you have to pay some money to the bond company? I'm assuming.
He shared with me that they came to an agreement whereby he pays $3,500 and they sponsor the rest. So.
All right, he's 35 years old.
Yeah.
He's gotta be working then.
Yes.
All right, so here's the other thing. If he's if he can afford to pay that kind of money to a bondsman to be released on custody from his deferred,
Yes.
then I'm going to require him to hire a lawyer. There's no reason for him to have a court-appointed lawyer if he can make those kind of funds.
Now, I'm not sure if that's going to be him paying for the family stuff.
I know. But he has access. I mean, the law says if you have access to funds, then I don't necessarily have to appoint him one. I mean, he's 35 years old. He's not a kid.
Yeah.
Yeah, I know. And so if he's going to be doing that, I'm going to request that he hire his own lawyer.
Okay.
Just let him know that, hey, if you're going to post a bond and if he's released,
Yeah.
you know, and then if not, then of course, well.
Yeah.
And even, let's just say the failure to ID, I don't think will cause his probation to be revoked because I'm looking at the motion to adjudicate. And the motion to adjudicate was filed in 2023.
Yes.
So.
And Judge, he was, man, just short of completing that deferred adjudication.
Man.
So it's unfortunate that we're here, but my bigger concern is helping him to resolve what he's got going on in 178.
Yeah.
As opposed to what he has here.
Yeah, and I agree with you there. The only problem is this. Once again, I think that's just Johnson.
Johnson. Yeah.
Okay. She's probably gonna say, hey, I'm not reinstating. He's an absconder.
And
you know, for 2 years.
Could be the case.
Yeah, he's been gone for 2 years, and let me tell you, because I kind of know how she thinks. I guess we kind of think alike. She's gonna want to know, why should I reinstate him? Why should I put him back on probation? He would not be here if it wasn't for the misdemeanor. So he got caught somehow or another, and apparently he must have known he had a warrant because the allegation, he gave a false name.
Yeah. We shared the facts of, I guess, this charge.
Yeah.
I mean, on their face, they're not good.
I know. And so I know that Johnson's going to think, she's going to say, if it wasn't for that, you wouldn't have reported. You wouldn't have done anything to resolve your probation, your MHA.
Yeah.
And you would have still been out. So that's going to probably make her hesitant to, reinstate him. And it's possession 1 gram. I think that's a 3rd degree, if I remember correctly. My memory serves me right. I don't know for sure, but I think it's a 3rd degree felony.
Yes.
Okay. All right. Well, he's on bond on this case, so I'm not too concerned with it. And honestly, let's see.
My request at this point is if they
Yes.
help him get his arrears in order.
Yeah.
Whatever he has to do with setting up his family to handle what's going on there. But currently, if he can maintain me as an appointed attorney, if he needs to, I mean.
I'll leave it alone. You can stay on. But I do want to do bond conditions.
Yeah, that's fine.
So, Ms. Garcia, this is on page 16. Hayden, let's go ahead and put no weapons and no controlled substances.
Yes, Your Honor.
Because he's on probation for possessing controlled substance. So tell him no illegal drugs, no weapons in the event that he bonds out. And in a couple of minutes when she's ready, when Camila's ready, we'll ask Deputy Lopez to bring him out to sign the bond conditions. Just get with Millie, we'll reset it. He doesn't have a court date on his felony yet, but I anticipate he's gonna go sometime next week.
Yeah, from what I see here, Judge, he said for the 24th of June.
Yeah, but that sounds a lot,
But yeah, that's way off.
Yeah, especially if he doesn't have a bond. Does have a court appointed attorney. Thomas Abadi, I don't know who that is. That's a long time to sit in jail.
So I'm of the same opinion, Judge. They are probably going to move sooner.
Yeah.
But I guess we're just going to find out here shortly.
Yeah, well, he's on bond out of this case, so I'm not too concerned with it. So we'll just have him sign bond conditions. If you want to set him past the 24th of June, that's fine with me.
Yeah, that'd be great.
And we'll take it from there.
Okay.
Okay.
Judge. I appreciate you.
You're welcome.
Thank you.
Yes, sir.
Thank you.
Thank you.
So,
Yes. It's on 26/7. What happened?
yeah.
These are the conditions of bond for your misdemeanor case. If you base your bond out, you are to follow the conditions, appear in court each time they require you to be here, unless your presence is waived, your attorney will let you know. No other violations. You must not use, possess, or consume any legal drugs or controlled substances that you do not have a prescription for, and you must not use or possess any firearms and weapons. I will have to stand over there.
Glasses right away. They're not going. Yeah. For these.
Yeah, speaking my son's case.
Welcome.
Daniel.
Yes, ma'am.
Your time to go?
No, not yet.
Not yet?
My seat.
Okay.
Thank you for listening. You got it.
Okay.
Lie.
She let me try these delicious chips. And they're Costco, and I don't do that.
So many, Senator Cova waiting for a lawyer? Like, oh, is that okay?
Yes.
You can write on it. Wait, you just magneted it on there?
It's total?
No, you just had it on the screen. I thought it magneted it on the screen.
with your lawyer. All right, be seated, please. Sorry, folks, I don't usually get out here this late. I got in a meeting with the court administrator and Mr. Apollos. All right. Here we go. I'm sorry. 19309 Allen Road, L, T, 25BA 2553. Mr. Kassab?
Not here, Judge. Caitlin just sent those in as a dismissal.
Oh.
She sent them earlier in the week.
Good enough. She sent in a slip here moving to dismiss this per the ordinance officer. The failure to register rental property apparently has been resolved. That case is dismissed. People against Fears, Jacqueline Fears, 25BA 2548. Again, defendant apparently has complied. The prosecutor moves to dismiss. That's a failure to register rental property. Matthew James Chokes, Kazmarek, 25I414924. Come on up to the podium, please, sir. Could I have Stefan Markin, if you're in here, seated at the table, my right, your left, sir, your name? All right, you're charged with failure to report a property damage accident. You have the right to a lawyer here today. If you want one, I'm going to give you one. Do you want a lawyer?
Yeah.
Okay, we're going to go set you up with an attorney, and then either way, you're going to come back in front of me after you've spoken with your lawyer, okay? Good luck. Stephen Thomas Markin, 25B 148 364 A and B. Morning, Mr. Weinberg. How are you?
Good, Your Honor. How are you today?
Nice to see you. Your appearance?
Darren Weinberg on behalf of Mr. Markin, who sits to my left, Your Honor.
Good morning, Mr. Markin. Your name?
Stephen Markin. Good morning.
All right, so I've got a super drunk with a .175, leave the scene of a property damage accident. For purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
Okay, so I'm going to enter a not guilty plea. Does he have any prior alcohol-related convictions or actually convictions of any kind?
It's my understanding he has no convictions for anything, Your Honor. He's 35 years of age. He's married, 2 children, works full-time at Ford Motor Company, has a second job at a security company on the weekends, lives in Romulus, and has voluntarily started attending AA once a week.
Okay, good enough. Is he going in person, I hope?
Yes, he goes after, he works for Ford, so at the end of one of the shifts, I think it's on Tuesday.
Okay, good enough. I'll give him a personal bond. I'll enter not guilty pleas, $1,000 personal bond. Sir, you cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. No alcohol, no illegal controlled substances, no marijuana. You're not to purchase, possess, or consume any one of those, and you're to attend AA at least one time a week, okay? I'll need you to bring that if you're going to meet with your lawyer in the office when we're handling this. Then that's not a problem. You can just show it to him. I'll give you a pretrial date. And who is that? Henry Ehring behind you there, Mr. Weinberg?
It is, Your Honor.
I could tell, number 44. Anyway, okay, so what day we doing here, Lisa?
May 21st at 10 o'clock.
Is that good with you?
Your Honor, I haven't received discovery yet. I know they've ordered it, so I haven't received, I don't know how long it's going to take. I don't know if I could have maybe another week, if that's possible. Is it possible to do that? The only thing I'm asking is that his vacation time he just whispered to me is available in June. I don't know if we can do the very beginning of June.
I'm off on the 3rd, which is a Wednesday, and I only do these every other week. How about if we do this? We'll put it on the 21st at 10. If you don't have discovery, you just submit a stip in order, and we'll have to put it out to somewhere around the 17th. How's that?
Okay.
tell me what my next docket day would be, Lisa, after, so let's see, 28th, so I should be on the 4th and then the 18th?
June 2nd in the afternoon.
Oh,
Did we do that, Your Honor?
June 2nd is what day of the week?
It's a Monday. We had to move your Wednesday to a Monday.
Beautifully. Can you do that, Counsel?
Yes, that would work better. And you said the afternoon?
I think so. What time are we doing it that day, Lisa?
1 o'clock.
Huh?
1 o'clock.
At 1 p.m., okay? June 2nd, 1 p.m.
Thank you very much. Have a good day, Your Honor.
You too. Good to see you, Counsel.
See you soon.
Good luck, sir.
Thank you.
Thompson, Anthony Wayne Thompson.
Yes, sir, you're out here at the podium.
Come on to the podium, sir. 25B1460828 A, B, and C. I have a defective equipment charge. I have a no insurance and a driving an unregistered vehicle. Your name?
Anthony Wayne Thompson, sir.
Okay, so you have the right to a lawyer if you want one. I have you have one misdemeanor here. If you want one, I'll give you one. Do you want one?
No, thank you, Your Honor.
On April 14 of 25, it is alleged that you did operate a motor vehicle on eastbound Sibley near Dixon, Brownstown at 3:44 p.m. They think you had an unregistered vehicle. That's count 3. That's a misdemeanor punishable by up to $100 in fines, 90 days jail. Costs are all of those. You also have no proof of insurance. You also have defective equipment. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, I did.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes, sir.
I'm entering a not guilty plea for you. I'm giving you a $100 personal bond. I'm gonna let you go talk to the prosecutor. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, go out, talk to the Brownstown Township attorney, and then you'll come back in here, okay?
Okay, thank you, Your Honor.
Have a good day. Good luck, John.
Why is that today?
Yeah, you're coming back and forth.
Okay.
Sure.
Thank you, Your Honor.
You're welcome. So these are all going to
Just while you're in the hallway, sir?
Yes, sir.
Thank you.
These are all going to Lisa. Those are going to probation. This is the Brownstown prosecutor. And then that one's setting up with a word. Robert Dickinson. 25I, 2566A, B, and C. Call in Miss Amame, will you? She's in 237. Your name?
Robert Dickinson.
I cannot keep adjourning this, sir. I want you to understand that. Okay?
I don't understand it, but yes.
Well, let me explain something to you. I don't make rules here. I just work here. Okay? I got my bosses too. That's the Michigan Supreme Court. And here's what they tell me. This is a civil infraction. The citation was issued April 1. I'm supposed to have 95% of my cases done within 35 days. Okay? This is May 7th. That means I'm already.
Mr. Wright, you can leave the breakout room, sir.
That means I'm already past the 90% time. Your name?
Good morning, Your Honor. Lisa Amami on behalf of Roseville Town.
If I adjourn this 2 weeks, that means I'm going to be up to 37, 44, 51. I'm supposed to have 98% done within 56 days. That's what they tell me. They didn't ask my input. Okay? These are guidelines. Nobody called me up. Hey, Mike, what do you think? So I followed. I'm only telling everybody, I'm setting this for a formal hearing. I'm setting it for a formal hearing. I'll give you your 2 weeks. There's no more adjournments. Okay? So that's it. I'll adjourn it. Lisa, give me May 21 then. Is that my next day with Rose Hill?
Yes, 8:30.
At 8:30. Okay? So that's what I'm doing. May 21, 8:30. Sorry, folks, but no more adjournments. Okay? So, sir, you can go down the hall. You'll get your notice. We're setting this for a formal lease and not a pre-formal, May 21 at 8:30. All right? Good luck. Go down the hall, get your notice. Thank you both. Have a good day. Boyd, Robert Thomas Boyd, 25B82557. Could I have Andrea Brewer seated at the table, my right, your left? Alyssa Jones seated at the table, my right, your left. Come on to the podium, sir, and tell me your name.
Robert Thomas Boyd.
Good morning to you. You're charged with property maintenance code violation. It's a blight charge. You have the right to a lawyer. It says inoperable vehicles and trailers in an unsafe structure. You have the right to a lawyer. It's a misdemeanor. If you want a lawyer, I'll give you one. Do you want one?
No.
You're charged with blight at 31430 West Jefferson in Brownstown. This allegedly occurred April 11 of 25 at 8 a.m. That is a misdemeanor punishable by up to $500 in fines, 90 days jail costs, or all of those. Do you understand that?
Yes, sir.
Did you sign and read and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a trial. Do you understand that?
Not guilty.
I know. Do you understand what I said, though? If at any time in this case you plead guilty, we're not going to have a trial. You're waiving your right to a trial. Do you understand that?
Yes.
Okay. You still wish to waive your right to a lawyer?
Yes.
I'll let a not guilty plea. I'm giving you a $500 personal bond. This is the prosecutor that's going to Lisa. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand all that?
I do, but what about my job? I deliver cars.
Where do you go?
Buffalo, New York.
Okay.
Rockford.
Fine. Listen, no problem.
Okay.
Can leave state for employment without consent. Can leave state for employment purposes without consent. Okay, so if you're driving to any of those places and it's part of your employment, no problem.
Thank you.
And either way, you're coming back in front of me after you talk to her, okay? Thank you. Andrea Brewer. Andrea Lynn Brewer, 25B48214. Where's Ms. Brewer?
Right here.
Come up to the podium, please. Your name?
Andrea Brewer.
You're charged with possession of crack cocaine, and then it also says no scripts with a Xanax. You have the right to a lawyer here today. Would you like a lawyer?
Yes.
Okay, we'll give you a lawyer. And you go out in the hallway. He will set you up with the Brownstown Township Attorney. Any questions?
No, sir.
Okay, you can go right out there and he'll set you up and just be patient. Well,
Thank you.
this one wants a lawyer. Jones? Alyssa? Christine Jones, 258148251. I'm sorry, I didn't know this was yours. Your name?
Good morning, Your Honor. Leslie Academy, we have Alyssa Jones, who's present to my right. Can you please state your name for the court this morning? Alyssa Jones.
All right. For purposes of arraignment,
Stand mute, wait for the reading, Your Honor.
not guilty pleas entered. I'll give you a $500 personal bond. You cannot leave the state without the consent of the court or violate any law. Must appear in court as directed. No contact with the victim. It says she assaulted. That's one. So whoever that officer is, no contact with him except through your lawyer. No contact with prosecution witnesses. Okay? So I'll give you.
I would just like to point out to the court that the person, one of the prosecution witnesses she does share a child with, they do a court order parenting pen exchange.
Who's that? One of the prosecution witnesses.
It would be her. This occurred at the residence of a personal friend, the child's father. The police were called to the home of her child's father. So I just want to point out to the court that they do exchange a child. And I would anticipate he would be a prosecution witness. However, the exchanges do occur through the child.
Well, I'll just indicate no contact with victim or prosecution witnesses. What's the gentleman's name?
Thomas. Okay.
How do you spell that, man?
Last name,
Yeah.
Michetti.
Geez, I butchered this, Lisa. Maybe you can make this a little better. With child's founder, Thomas McKetty. So no contact with victim or prosecution witnesses except to exchange custody/visitation with the child's father, Thomas McKetty, but you cannot discuss the case with him. You cannot leave the state without consent or violate a law. You must appear in court as directed. Lisa, give me a date on this, please.
May 21st at 10.
Good for you, Ms. Holmberg. I mean, Ms. Aycock. My apologies.
Actually, I'm scheduled to be in trial on a felony matter starting that day. It's a jury trial as of now.
Okay.
I think it might settle, but we're not there yet.
What's the other one, Lisa? June 2nd?
June 2nd at 1.
How about June 2nd, 1 o'clock?
Perfect.
It'll be very easy to get in and out of here that day.
Thank you.
It's a Monday and afternoon.
Thank you very much, John.
Okay, have a great day. Ma'am, do you have any questions for me?
I do not. Thank you.
All right, good luck. Counsel, one thing. Yeah, I have to ever go get printed, so that's a condition of your bond too. Were you, come on back up here.
I was fingerprinted.
You were fingerprinted that night? I don't have your, let me see. Yes, she was. Good enough. Thank you. Thank you. Lucero. Jose Maria Lucero. 25B1484148 A and B. Come on up to the podium, sir, and tell me your name, please.
Jose Maria Lucero.
You're charged with commercial vehicle yield, failure to yield to emergency responder. You have the right to a lawyer here. I'll be happy to give you one at public expense if you want one. Would you like a lawyer?
No, I think.
All right, so on April 16 of 25, at 9 p.m., it is alleged that you were operating a commercial vehicle on Pennsylvania near Telegraph in Brownstown and that you failed to yield to an emergency responder. That's one count punishable by up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, John.
Count 2 alleges a civil infraction of driving left of center. That is a 2-point civil infraction. You understand that?
Yes, John.
Did you sign the advice of rights?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor, but now that you're saying all the, I didn't know it was,
Okay, you want a lawyer?
yeah.
Good enough. We'll give you a lawyer. No problem. You just go out in the hallway. We will set you up with a lawyer and we'll go from there, okay?
Yes, John.
He wants a lawyer. And then either way, you're coming back in front of me today, okay? Good luck. Joseph William Wynn II, 25B147843, A, B, and C.
Good morning, Your Honor. GM Patillo P82378 on behalf of Mr. Joseph Wynn.
You know, I prefer you come in when you
Mr. Wynn,
have.
can you state your full name for the court?
I prefer
Oh, I
you
can
come
come
in.
in.
You're in the courthouse, right?
Yes, I'm here. I can come.
Yeah,
in.
he's here.
Okay, thanks.
Your name, sir? Joseph. Good morning, Ms. Patillo. Your appearance?
Yeah, Patillo on behalf of Mr. Joseph Wynn, Judge.
Is he didn't sign an advice of rights form?
He did not, Judge.
Okay, I want to make sure he does that. Did any plea?
Okay.
So can you sign this, sir? I'm going to go off the record, take your time. And you go over that with your lawyer. You can have a seat right there or stand at the podium, whatever you want. We'll go off the record. On this case, I'll go on to another, okay? People against Hamada Tahir Naji El Riyashi, 25B1484, I'm sorry, 25B148412. Good morning, Mr. Werbling. How are you?
Good morning to you and your staff, Judge. I'm doing very well. Hope you and your staff are well, Judge. Thanks for asking. Ben Werbling, P64889 on behalf of Mr. Al Riyashi.
All right, he's going to plead to, you're going to plead on his behalf to distracted driving, correct?
That's correct, Your Honor.
And you're authorized to enter that plea?
I am, Your Honor.
And that will then result in the dismissal of the 5 over to the charge distracted driving on behalf of Mr. El Riyashi.
Responsible, Judge.
Responsible or not responsible?
We're going to plead responsible, Your Honor.
I'll accept the plea, dismiss the original charge, 160, that's due by May the 14th, okay?
Thank you, Judge. Good seeing you and your staff.
Have a good day, thanks.
Thank you, sir. Thank you.
Do you have any sentencing?
Miss Melton is ready.
All right, who's on Ms. Melton's case again?
Spazio.
Okay, well, that's all right. We'll take that one after this one.
We're ready, Judge. We went over the rights and
Okay, good enough. No. When?
Okay, that's.
And if somebody can hand me Melton's file, Joseph William Wynn II, 25D1478843, A, B, and C. Your name, sir? Joseph. All right, he's going to plead to allowing unlicensed driver to drive. The drive while license not valid will be dismissed. He's also going to plead responsible to PPT refusal, and the disobey a stop sign will be dismissed. Correct, counsel?
Correct, Your Honor.
Is that what you want to do, sir?
Yes, sir.
Okay, just keep your voice up for me. If you plead to allowing unlicensed driver to drive, the possible penalties are up to $500 in fines, 90 days jail, costs are all those. If you plead responsible to PBT refusal, I'm going to fine you on that charge, and I'm going to dismiss the drive while license not valid. I'm going to also dismiss the disobey stop sign. You understand that?
Yes, Your Honor.
If you plead to allowing an unlicensed driver to drive, again, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand an advice or rights form here today?
Okay, Your Honor.
If you plead guilty, you'll be giving up all those rights on the advice of rights, and there will not be a trial. Do you understand that?
Yes, Your Honor.
To the charge, allowing an unlicensed driver to drive, how do you plead? To the charge, PBT refusal, responsible or not responsible? Were you in control of a 2007 Dodge that was being operated in the township of Brownstown on March 20 of 25 at 2:28 in the morning on Telegraph near Pennsylvania?
Yes, Your Honor.
Did you allow somebody to drive that was suspended?
Yes, Your Honor.
And that was you, true?
Correct.
Or with an invalid license, is that true?
That's true.
Anybody force you to plead guilty?
No, sir.
Are you on probation or parole?
I'm on probation through South Lyon, but I found it out, and it's just pretty much the same thing as driving.
Well, I'm just telling you, if you are on probation to another court, and we're on probation to another court on March 20 of 25, this would be deemed a violation of your probation. Your probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that?
Yes, sir.
You still wish to plead guilty?
Yes, sir.
Anybody force you to plead guilty?
No, Your Honor.
I'll accept your plea to that charge, allowing an unlicensed driver to drive. I find it has been made voluntarily and understandingly and is accurate. The drive while license not valid is dismissed. The disobey stop sign is dismissed. I'm also accepting your plea to PBT refusal. All right, counsel, I'm ready for sentence. Are you? Anything you'd like to say on his behalf?
Your Honor, I would just ask any fines and costs that the court has discretion to reduce if the court could do so. He is gainfully employed. He's helping with the ice storm cleanup and what city is that?
So I'm up in Lewiston. I've been up there for about 5 weeks now. I'm going back up there to record. I'll be up there.
Is that for your work?
Yes, sir.
Who do you work for?
treesandstones.com to do storm damage, large tree removal.
Yeah, it's pretty bad out here, isn't it?
Yeah, it's we still got steady work up there. Like I said, I've been up there for 5 weeks now.
How are you getting around if you don't have a valid license?
My boss, he's been taking care of me.
I'm just telling you, you can't be doing that, okay?
Yes, sir.
And Your Honor, he does have children, and his wife is in the courtroom. She's actually expecting.
Well, congratulations.
Thank you.
What number is this?
3.
What are you gonna have? Do you know yet?
1.
Congratulations.
Appreciate it.
What else do you have?
2 girls.
Perfect. Girls are easier. You should always want 2 girls and 1 boy if given the chance as opposed to the opposite. Hunter, anything, did I let everybody finish?
Yes, Judge, thank you.
$100 fines. $125 cost, 75 victims' rights, $50 justice assessment. $350 attorney fees of $40, $390 or 60 days, $205 on the PBT refusal. You owe $595. Can you pay all that?
He can pay $100 today, Judge.
He's making all that money working on that.
I actually spent all the paying on my tickets on my next check. I'm gonna clear you guys up.
Pay $100 today. I'll have you pay that on the civil infraction. When do you get paid next?
The 16th, Your Honor.
Balance on that one by May the 19th. So you know, after you pays the 100 on PBT, you'll have to pay 105 on that. Then you can pay on that same day, pay $100 by May the 19th. And then I'm just going to give you until June the 2nd to pay the rest, okay?
Thank you, Your Honor.
If you need more time, you call the court, we'll go on Zoom, I'll give you an extension, no problem. Just don't ignore me,
Thank you, sir.
all right? You can pay this as outlined though, you think, right? Okay, best of luck to you, thank you.
Thank you.
Thank you, Judge.
Where's Ms. Melton's file?
I have it. I can go get it, Judge.
People against Thompson, Anthony Wayne Thompson. 25-14608, 2A, B, and C. Your name, sir?
Anthony Thompson.
So you should have been a lawyer. You did a good job for yourself here.
Well, I got a really spotless driving record.
Good.
I drove and I knew I shouldn't have drove that car, but they were gonna tow it if I didn't drive it. It ultimately got towed anyway. And I still owe $3,000 on that car and I can't get it out of the impound, so it's a costly experience to me.
So you have an unregistered vehicle charge, and they're gonna have to plead the driving without valid registration, civil infraction. They're gonna dismiss the misdemeanor, and then they're also going to dismiss the equipment violation and no insurance.
Yeah.
Right?
Yeah, that's what she said she should do.
All right, to that charge. Is that what you want to do?
Well, I think that'd probably be my best interest.
To that charge of no registration, responsible or not responsible?
I am 100% responsible, Your Honor.
Jeez, I haven't heard anybody say that in a while. 120 is your total. I'm dismissing the driving an unregistered vehicle. I'm also dismissing the 2 civil infraction charges here of defective equipment and no insurance. Can you pay that today, sir?
If you give me, I'm on a disability.
That's fine. Just
Give me
tell
a little bit of time.
Yeah, how much time do you need?
Well, can we start payments next month? I get my checks on the 3rd of the month.
Absolutely. How much can you pay that day?
Well, I guess, how much is it?
120.
I can't promise you I'll try to pay it off, but if I can't, can I give you $50 then?
You pay 50 per month. And I'll start that beginning June the 5th. How's that?
Thank you.
And if you don't have the money at any time, don't be scared.
No, I ain't scared. I'm not scared. I'm a pretty good citizen.
Okay, I'm just saying, if you don't have the money, just call the court. We'll go on Zoom, or you can walk in here.
Okay.
On or before the due date. I'll give you an extension. I don't care how many times we have to do that, okay?
Thank you so much, Your Honor. You have a wonderful day, sir.
Yeah, I wish you well. Good luck to you, sir.
Thank you very much. You all have a good day.
Thanks. You're very respectful.
Thank you.
It's nice to see
People
you.
should be that way. It ain't that way anymore.
Bobby Melton. People against Bobby Nicole Melton, 215-235-006.
Good morning, Judge Dion, Castillo on behalf of Bobby Melton, who was present. Melton, can you state your full name for the court?
Bobby Nicole Melton.
Well, Defendant pled guilty to possession of drug paraphernalia. They're just outright recommending jail. Are you aware of that, Ms. Melton?
I didn't,
They do that. They don't usually recommend jail. Go ahead. Have you reviewed the pre-sentence report with it, and are there any material additions, corrections, or deletions?
I did, Your Honor, there are no.
How long has she been in custody on this?
How long have you been in custody? No.
Are you
I've been here 2 weeks.
Yeah, you've been in here since the 24th, right?
Yes,
Is that true?
yes.
What are you gonna do to straighten out your life?
I'm trying to get this together. I am.
So, Your Honor, she wants to do inpatient treatment. She did,
Yes.
a reference number from Sacred Heart so that she could. So I would just be asking in lieu of jail time if the court would order inpatient.
Yeah.
And she also.
Ms. Mountain, why are you saying yeah?
I'm listening. That's all. It's helping me focus.
I'm sorry, Ms. Patillo, go ahead. You're asking for patient treatment in lieu of jail.
Yes, Your Honor. She had that reference number set up through Sacred Heart, but she's been in custody, so she missed the time to set up the interview. Once she's released, though, if released, she does want to start inpatient treatment.
Why you been playing with us? This should have been done with a long time ago. This is from 2021. Are you aware of that?
Yes.
And you live in Flat Rock, right?
Yeah, we just moved back about a year ago.
And where were you before that?
Taylor.
Taylor, okay. So you weren't in Iron Mountain or Juneau, Alaska or San Diego?
No.
So you were within 20 minutes of here. Why haven't you been showing up, man?
I've been in and out of my dad's. It's a lot. It's a lot.
What's a lot?
I've been in and out of my dad's. We had a house in Taylor, like I was saying.
Wait a minute, I lost what you said. You've been in and out of your dad's, you said,
In
right?
Taylor,
Then I missed what you said next.
And I've been in and out of my father's.
You said that 3 times. What else? I don't know what that means.
Me and him fight a lot.
Okay, well, maybe you should be more respectful to him. He's giving you a place to stay. Maybe you should be doing things. All right, go ahead. What else?
I've just been struggling with this addiction. That's it. I'm struggling, and it's hard. And I do want to help.
She also has a warrant out of the 34th District Court for DOUIL. I mean,
I've been struggling with addiction a long time.
I don't really think jail is really at this point. She needs help. She doesn't really jail sentence because once she's released from jail, if she's not rehabilitated, she's gonna be they're back before Your Honor.
You have insurance, ma'am?
Yes, I have Molina. I have Medicaid through the state.
Calling Jessica. You got everything going on here. Habitual, meth, crack, amphetamines. I mean, what?
I'm sorry, what?
You're using drugs like you're jelly beans. I mean, you got every color going on.
I need help.
All right, well, you should get yourself help. You're 33 years old, right? Or 30, you'll be 32 in November, right?
Yes.
Come on.
I'm ready.
You're ready.
It's not because I'm in here. I'm tired.
I'm tired. Tired too.
You teach me enough.
You don't really
I relapsed. I was in Sacred Heart 2 years ago. And I relapsed when I came home for Christmas, and I never should have came home.
You don't really want help, I don't think. You just don't want to be in the jail there.
No, that has nothing to do with it.
Well, Your Honor, she did have that reference number.
I really did. Before this.
So to get an interview, you have to call and get a reference.
Except for Pioneer.
Yeah, wait a minute, let me listen to your lawyer for a second.
Sorry.
To have an interview, you have to call and get a reference number from Sacred Heart, and then that reference number is the interview. She did do that before she was.
Your name?
That's what I'll have Probation.
So she's been 14 days. She says she's on okay.
Okay, I don't know for other cases, Judge Hassan is holding her up though, I don't think she can release on that.
Tell me she made, I'm not sure, but I don't know what the bond is.
Yeah, she's scheduled for a probable exam, I believe on, yesterday was a probable exam, then she's scheduled for an exam on the 13th.
The bond. What's that? Can you pull her up to please?
Yeah, she also has a pretrial with Judge Hessen today.
So she's got a felony and a misdemeanor going on?
I'm gonna look right now. I just know she was on the docket for Judge Hessen today. I don't see a felony case. Oh, it was waived yesterday.
Is that the 25F 709020?
Yes.
Why does it, non-public? Okay.
But Ms. Melton did indicate that she waived the exam. I don't know what the AOI and the circuit, what that date is yet.
What's the bond on that, Ms. Melton? Can you tell me?
15,000, 10%.
Do you have any thoughts?
I mean, if she can't get out on that bond, I don't think there's a reason to
I know.
give her time served, just to give her time turned on this if she's not able to get out.
What's the charge on that?
Jaywalking and meth.
Jaywalking?
I got caught with meth.
I mean, it doesn't sound like she's gonna be able to post on it, so there's nothing I can do. I'm gonna simply do this. Ms. Melton, you need to get yourself some help.
Yes.
And judges really tend to not think people are sincere about getting themselves help when they don't show up for years. And then they pick up other cases, then all of a sudden, they want to get themselves some help. I'm going to give you 21 days jail credit, 14 serves, 7 more. No fines, no costs. I wish you well. It sounds like you got bigger fish to fry. I sincerely wish you well. Thank you.
Miss Melton, will you remind the deputy that you need to go to Judge Hessen's courtroom?
Jacob Robert Zrebick, 25B1481318 and B.
Good morning, Judge. Yeah, Priscilla on behalf of Mr.
Jacob Zrebick.
Zrebick.
All right, sir, tell me your name again.
My name is Jacob Robert Zrebick.
You're another one that's got a lot going on here. So he's pled guilty to operating while in 4 on the alcohol use portion. 4 on the alcohol use portion. I mean, you got shooters. You were drinking in a parking lot, right?
Yes, sir.
And you had cocaine on you. What are you doing?
It was a bad day.
A bad day.
Not like me.
Pardon?
Not like me.
That's not like you?
No, sir.
So this day, something happened that just caused you to pull into a parking lot, start doing shooters, you got cocaine, you got all kinds of things in your system here. And then you're out driving.
Was my fiance, her car broken down on, I want to say Sibley, and I was waiting for her and her father, driving down Van Horn. I was gonna get in the car with her, she was gonna drive me, and her father was gonna follow us, just to get her car back home.
Yeah?
And that's when I got pulled over. They said that somebody had called that I was taking shooters in the parking lot.
Right.
And they said my tag was expired as well. And I had an appointment. That was
taken care of right away.
All right, counsel, have you reviewed this report? Are there any material additions, corrections, or deletions? And by the way, on the cocaine or the 7411 file B, there was an agreement between you and the prosecutor, or the defense and the prosecutor, that the case be taken under section 7411. So you're subject to having that case dismissed. He doesn't have a criminal history. Have you reviewed the report, and are there any material additions, corrections, or deletions?
We did review the report, Your Honor. The only correction is that he doesn't live with his grandmother. He cares for his grandmother 2 to 3 days a week. He actually lives in Flat Rock.
Okay.
So that would be the only correction.
Okay. Lisa, I'm going to have her give you the address. Can you give us the address, please?
26277.
Wait a minute, you got to speak loud.
26277 East Aztec Circle. That's Flat Rock, Michigan.
48134.
Yes, sir.
Did you get that, Lisa?
Yep, I got it.
All right. What else would you like to say, counsel?
He is employed. He's been employed at Ford for 12 years. He has a minor 6-year-old child.
How much you make per hour?
$32 an hour.
That's great work. You're gonna lose that if you keep this up. Go ahead. I'm sorry, Ms. Patillo.
No worries, Judge. He also has a 6-year-old child. He is engaged to be married. His last drink was April 1st, 2025. And as already mentioned, he does care for his grandmother 2 to 3 days a week. So I would ask if the court would adopt probation's recommendation for the probation.
Sir, is there anything that you would like to tell me before I sentence you?
This won't happen again. I'm already in Alcoholics Anonymous. I've gone almost 6 or 7 times the last 2 weeks.
Good.
I've seen you last.
Good.
I am making steps to improve, and his drinking was the main issue in my life. And I'm trying to cut that out as we speak, and I've been doing really well with it.
Good.
Yes, Judge. Lastly, he is in a 12-step program. I know that is one of the conditions.
I already have a sponsor and a home group already.
All right. So you think this might help you? Maybe it's a wake-up call, huh?
Oh, it absolutely was a wake-up call. It was the second I was handcuffed or put on me, sir.
You have some work to do, though. I mean, you really do.
Yes, Your Honor.
You got all kinds of things going on here. So I'm going to place you on probation for 13 months. I'm going to take file B under 7411. The terms will run concurrent. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation after a court is directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. Kratom, poppy, CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. I'm going to order chemical tests, PBTs and ETGs, weekly for 3 months. If you're clean, I'll make it bi-weekly for 2. If you're clean, I'll make it monthly. You're to attend AA twice a week until you're in an intensive outpatient treatment program. Once you get in intensive outpatient treatment, you no longer have to attend AA or NA. So AA twice a week until an intensive outpatient. Once you get in, you can stop AA. You do the IOP with aftercare. You're also to attend the Victims Impact Panel. Again, I want to just reiterate, just so you're clear, weekly testing for 3 months. If you're clean, I'll make it bi-weekly for 2. If you're clean, I'll make it monthly. You know that. Now, you just have too much going on. This is concerning me. 4 days jail credit, 1 serve 3. I'll let you serve those by way of the court work program. There's a $35 a day court work program fee. So you have 105. All of those fines, the common fines I'm going to attribute to file A. So 3 days court work program in lieu of jail. On file A, pay fines $300, cost $200, 75, victim's rights fee $50, justice assessment 6 1/4, screening fees 60 for 685, probation fees are $260 for 945. You have court work program fees of $105 for a total of $1,050. You also have cost of recovery of $225. Your total's $1,275. I'm going to assess $40 in attorney fees, $1,315. That is on the drunk or operating while impaired due to the consumption of controlled substance. On the other file, I will simply go 100 fines. This is on the drug charge, 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4. If you violate, you could get 93 days on the impaired charge. You could get 90 days on the drug charge. I'm taking that under 7411. Review hearing day, okay? Review hearing day, okay? So I'm going to write that down here. And that will be just on file B, June 3rd of 26 at 9 a.m. Can you pay all these fines?
I was hoping I could do some kind of payment plan.
How much do you have today?
My paycheck, comes into my direct deposit about 1 o'clock this afternoon. I could probably give you $200 today.
Okay, so.
Can we do that by Friday, Judge?
Yeah, I don't have a problem. I'm just questioning this. I want you to think about what I'm telling you. It's your life. You got a fiance that you live with. You got a grandmother you live with. You got a child you live with. I realize that's a lot, but still, you're making $32 an hour. The fact that you're telling me you need time to pay is a little frightening to me. It should be to you. I'll be happy to do that for you. You pay $200. I'm going to just make it by Friday, which will be the 9th. And then I'm going to set you up $150 bi-weekly. Can you do that?
Yes, Your Honor.
Beginning May the 16th. And you pay all that. I'm simply going to give them, you want to just add that in, Lisa, on the file? Pardon?
I'll combine them.
She'll combine them by 150 bi-weekly on B after fines costs paid on A. So she'll give you a printout. You're going to meet with probation. Do you understand everything?
Yes, Your Honor.
All right. I wish you well. I really do. Good luck. Thank you. Thanks.
Thank you, Judge.
Do you have any more? Pardon?
Maybe not in that stack.
Okay. Robert Thomas Boyd. 2582557. Boyd, come here. Your name?
Robert Thomas Wood.
Good morning again. They want an adjournment. Is May 21 good, Lisa? Oh, no, they want until June 2nd. You want to adjourn this to June 2nd. Is that my day again? I'm sorry.
Yes, June 2nd at 1 o'clock.
June 2nd at 1 p.m. Okay, sir?
Yes, sir.
It's in the afternoon. So you go down the hall and get your notice, and then you come back that day. Thank you.
When do I have to close my phone?
There is no bond. I give you a personal bond. You don't have to post any money.
Okay,
Okay?
thank you.
Personal bond. All right? Good luck.
Do I go down and,
Get your paper notice. Put it on your refrigerator.
okay.
All right. Good luck. Talise Noel Jackson, 25B148. 486 A and B and 25B 148-570 A and B and 119-633-606A. What do you think I'm thinking?
What do I think you're thinking?
Where you been? Tell me your name first.
My name is Talise Jackson.
First of all, on 8486B, that's driving on a suspended. The A files disobey stop sign. That emanates from an April 18th incident as the.
Yes, both of them same.
You got two different incident dates, one at 9/11 in the morning and one at 2:14 in the morning. So they wrote you at 9/11 and then 5 hours later, they wrote you again.
Yes.
And then I have a case from 2019, believe it or not. I was young, not young, but not as old as I am. Where you been?
I've been around, I used to live over here in Woodhead, but I live in Brownstown now.
Oh, geez, okay. Well, that's,
Not saying it like I'm,
well, that's a long.
I didn't know that, I went to the
Be careful what you're telling me. You didn't know what? You're not gonna tell me you didn't think the case was, you're not gonna tell me you thought the case, hang on, hang on.
Okay.
You're not gonna tell me you think the case was over, are you? Please don't tell me that.
No, I thought that if I were to pay the tickets.
Ma'am, I'm gonna give you a lawyer. Grow up. How old are you? You seem like a very pleasant person, but you're acting like a fugitive. Come on.
I'm 36 years old.
Well, I know, but you're acting like a fugitive. Stop it. You got red marks. Every time I see one of these, it's because a warrant was issued. Are you kidding? Come on. Come on. You gotta grow up. I'm gonna say.
I feel like I have. I feel like I did what I was
right.
supposed to do. I tried to get my license last year.
Listen, go talk to your lawyer.
I tried to get my license together last year and I contacted the driving authority. I paid a bunch of money to get my tickets and stuff taken care of. I've been on top of my stuff. I've been on top of my stuff. I did mess up and I'm human. I'm just saying like you like throwing that and acting like
Acting like
you're a butt. Right, I'm saying, but like I don't like the way that you're responding.
Listen, I don't care what you like.
Okay.
You haven't been here in 6 years.
And
Ma'am.
I thought I
Ma'am, you better watch yourself. Don't start raising your voice and getting this hoity-toity attitude with me.
Your Honor.
Go out in the hallway and get your lawyer and come back in and do a 360 with your attitude. I don't want to sit here and listen to you lecture me. Did you hear what I said? Go out in the hallway. Unbelievable. Hey, come here. Did you do that on purpose?
No, I just apologized to you. No, I didn't do
You
it.
just slammed that door.
I did slam it. It's a swing door, Your Honor. I'm not trying to be disrespectful. I'm not upset at all.
Go out in the hallway. Demetrius Richard. Do you have a case in here? Which case do you have?
I guess you're here for sentencing on Stafford.
So that's,
I substituted in for MIDC this morning.
okay, I'm sorry. We'll pull that one out and take it next. Demetrius Antoine Richard, 25B1479738 and B. Good morning.
Good morning, Your Honor. Attorney Joe Irby, appearing on behalf of Mr. Demetrius Richard, who is to my right. State your name for the record.
Demetrius Antoine Richard. All right, so he pled to operating while impaired. He pled to possession, let's see here. Possession of concealed weapon under 771.1, correct?
That's correct, Your Honor.
And is that what you, so he was referred for a screening and assessment. So I got an operating while impaired from March 2nd, 25, and that same pretrial date of April 9th, he pled under 771.1. Have you had a chance to review this report with your client, and are there any material additions, corrections, or deletions?
Yes, I have had the opportunity to review the report with my client. There are no additions or corrections or deletions to be made at this time.
Okay, anything that you would like to say on his behalf?
Yes, Your Honor, just that my client has been compliant with not possessing or using any alcohol during this time. He wants to apologize to the court. He is gainfully employed. His mother is present with him in court today, so he has a lot of family support. And this is not something that he does on a regular basis and will not do in the future. And I'm hoping that the court takes the recommendation that's been in the file. And the last time that it was here, if the court remembers, my client did advise that he had a license. He did have a valid license at that time. And it was in his, the weapon was in his console. It wasn't on his person. But I'm just hoping that the court takes it into consideration that he was not attempting to be any disrespect to the police officers that stopped him at that time.
All right. I need another proof. I know I got it. Give me 1 second, if you would, Ms. Irby, okay?
Yes, Judge.
He's got a clean record, it looks like, right?
Yes, Your Honor.
Good. All right.
And Your Honor, I'd like to add one more thing. I noticed in the recommendation that there was a 12-month probation time. I'm asking that the court will consider reducing that for a short period of time because my client does have a valid license that will expire in April, and I'm hoping that the probation will stop prior to that time, because if it doesn't stop prior to that, he won't have a license at the 12-month period.
How will he not have a license?
Because it'll expire. And I don't want it to expire because.
Yeah, but remember, he's only gonna get a 90-day suspension. And he's gonna have it restricted. Why can't he?
I mean, his, I'm sorry, Your Honor, I meant his concealed weapon license.
I see.
I apologize.
What did you guys agree on the 771? Did you have a period of time?
I did, no, Your Honor, I did speak to Prosecutor Foley, and we just left it up to the court. But I'm just hoping, as I indicated, that the court will take into consideration my client does have a, clean record. He has been compliant.
Okay, I'm not sure that all that's gonna apply like that, but I'll do that for you. Anything you'd like to say? Yes, sir.
I just want to say I learned my lesson. I haven't had a history of, any crimes, any criminal history. I do a lot in the community. Coaching, I got 3 kids. I coach a lot of sports, coach teams that they're on and not on. And I truly learned my lesson. I really do not go out that often, and it just was a one-off. I lost my car, had to spend a lot of money repairing an old car. So I truly learned my lesson. I'm truly sorry.
All right, you sound sincere. It's nice to see.
I work right up the street too.
I know you do. I saw that on you got a good job, right?
Yes, sir.
All right, let me see here. All right. Anything else, counsel?
No, Your Honor.
Let me just check something here real quick. I'll tell you what, you cannot leave the state, 11 months probation, that's the best thing to do. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation after the court is directed. No alcohol, no illegal drugs, no marijuana. You're not to purchase, possess, or consume any one of those things. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing of PBTs and ETGs. I'm gonna make it bi-weekly for 2 months. If you're clean, I'll then make it monthly, okay? So bi-weekly for 2 months. If you're clean, I'll make it monthly. And then you're to attend the Victims Impact Panel. Okay? That's one night put on by Mothers Against Drunk Drivers. I'm gonna have you do an alcohol education program, level 1, alcohol education program, level 1. And you're also to attend a rights and responsibilities weapons program through Class A Training Center, okay? So I want you to attend that and complete that as well, all right?
Yes, sir.
All right. I have to fill out two of these. That's why it's taking me a little longer. My apologies. I'm going to give you, all right. 3 days jail credit, 1 serve 2. I'll let you serve those by way of the court work program. There's a $35 a day charge for that, for a total of $70 in court work program fees. Okay? So 2 days court work program, $70 in court work program fees. I'm charging all the fines on council on file A for the most part, except for the ones I'm going to move that are not common, I should say. So 2 days court work program. And that really is it. 300 fines. This is on the drunk driving now. 300 fines or impaired driving. 300 fines, 200 costs, 75 victims' rights, $50 justice assessment, 6 1/4 screening fees, 60 for 685. Probation fees are 220, bringing your total to 905. Court work program fees are 70 for 975. And then you have cost of recovery of 218. For a total of 1,193. On the other file, on the everything else will run concurrent. Okay, all these terms will run concurrent. I'll repeat that: 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. So 3 1/4 on that one. You'll get this one dismissed if you're compliant with everything else. Lisa, I need a prosecutorial review date, probably in April, I suppose.
April 1st of 26 at 9 o'clock.
So you can be off probation then, that day, as long as you're compliant with everything, okay? Again, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Missouri, be nice to have you here. Does your client need time to pay?
Yes, Your Honor.
Does he have anything today or not?
Could be Friday. I spent a lot of money getting my old car fixed because
All right.
I lost my way.
You guys you're making good money down there. You gotta take care of this, okay? I don't have a problem. You get paid weekly or bi-weekly? Weekly, right?
Yes, sir.
How much you get every week? How much can you pay every week?
Yeah, around 150.
I'll make it 100 a week. We'll start on Monday, which will be on May the, what's today, 7th? May the 12th, okay?
Yes, sir.
Can you do that?
Yes, sir.
And then you pay 100 a week on the other charge. If you have a problem with paying, life gets in the way sometimes, I get it. Just call the court, we'll go on Zoom, or you can come up here. I'll be more than happy.
Thank you.
More than happy to give you an extension. I don't care how many times we have to do it, just don't ignore me, okay? So you go down the hall and you'll meet with probation, and I wish you well. Anything else?
No, Your Honor. Thank you.
Have a great day. You're gonna get your notice too for your review hearing date. Make sure you don't lose that, okay?
Yes, sir.
For next April. Thank you. Have a good day. Jones, Anthony Lavelle Jones, 25B148545. Where is that Fafford file, guys? Do we have the Fafford file?
That is with Mr. Dillo, Your Honor.
Well, we gotta get it for, or do you know, Ms. Patillo? Go get that. I don't know how this happened. My apologies to you. Your name?
Anthony Jones.
You're charged with improper plate. You have the right to a lawyer. You want a lawyer? On April 17 to 25, the police think that you were operating a motor vehicle with an improper plate on civilian or telegraphic grounds down at 2:52 p.m. That is a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial of any kind. Do you understand that? You still wish to waive your right to a lawyer? I'm entering a not guilty. I'm giving you a $100 personal bond. You cannot leave the state without the consent of the court or violate law. You must appear in court as directed. Do you understand all that?
Yeah.
So go meet with the prosecutor, and then you're going to come back in here and talk to me, okay?
Okay.
Thank you. G. Brown Trucking Company. G. Brown Trucking Company, 25B148543. Sir, your name?
Gregory Brown.
This is a corporation though, isn't it?
Pardon me?
This is a corporation that you own, right?
I'm just one guy with one semi truck that's incorporated.
I just can't let you appear on behalf of the corporation, sir. I'm sorry, I can't do it. This isn't my rule. I'm just telling you, I cannot let you appear on behalf of the corporation. I'm gonna have to you go get a lawyer. I really am sorry.
Okay.
My apologies, but I can't let you do that. We'll give you another arraignment pre-trial date. That'll give you time to get a lawyer, okay?
Appreciate it.
No problem. How about May 21? Lisa,
Yep, May 21, 10:15.
at 10:15, okay?
One thing, I'm scheduled to have surgery on May 19th.
Oh geez, I'm sorry. We'll make it, you don't need to talk about it. Is June 2nd the next day, Lisa?
Yes, 1:15.
Be okay then, you think? I don't need to know what kind of surgery.
Yes, sir.
Okay, we're gonna do it June the 2nd at 1 o'clock,
Appreciate it.
okay?
Do I need to get any documents?
Yes, you go down the hall and get your notice from her, all right?
Appreciate
All
it.
right, have a good day. Thank you. Gilbert Nelson Fafford, 25B148428. Man, I am really sorry about this. I don't know.
That's okay.
All right, thanks.
Really. Where is Mr. Fafford?
He's coming.
You can sit right here. You can walk here too, just closer. Yeah, you're gonna have to wear these again. Remember how to wear these right now.
You're low loud.
Sir, just have to put them on and this is up on.
All right. How you doing? Mr. Fafford, can you hear me? Mr. Fafford, can you hear me, sir? Can you hear me?
Yes,
Good. Tell me your name.
Gilbert Stafford.
This is file 25D148428. Ms. Acock, your appearance.
Good morning, Your Honor. Leslie Acock, on behalf of Mr. Fafford, who's present.
Sir, your name? You, sir.
Gilbert Nelson Fafford, beside.
Gilbert Nelson Stafford.
I know. I'm talking to your son now. You're his son.
Yes.
Are you gonna promise me you're not gonna let him drive?
I promise.
Listen. Has he been driving?
No, not one time.
Is anybody from McDonald's here? Anybody from Burger King here? He drove into things over at 2 different restaurants or fast food restaurants, whatever. I want to make sure he's not driving.
He is not, and we're selling the car.
Pardon?
And, sorry, and we are selling the car.
All right, counsel, have you had a chance to review this report with your client? And are there any material additions, corrections, or deletions?
I have reviewed it with my client. He indicates to me it's factually accurate. I would point out for the court, Fafford family, I know them personally, and I have had ongoing conversations with them this morning about the car being sold, and I have discussed with my client that he consents to the car being sold and he will not be driving. Mr. Fafford's had some family tragedy since he was here last. Unfortunately, his wife passed away.
Oh, sorry, sir. I'm really sorry.
And we would note that the pre-sentence report does just ask for fines and costs. Given the nature of his circumstances, we would ask that the court adopt that.
And I have your word, you're not gonna let him drive.
Correct.
Mr. Fafford, anything you would like to tell me, sir? Do you want to say anything, sir?
No.
$300 in fines. 500 costs. 75 if the dry fee, $50 justice assessment, $60 screening fee, $985 or 93 days with credit for one. $985 or 93 days with credit for one.
Your Honor, my client can take care of that today by the end of business.
Okay, you just make sure he pays that by 4 p.m. today, okay, sir?
Thank you, Your Honor.
Thank you very much. Mr. Fafford, I wish you well. Good luck to you, sir.
Thank you.
He's, for the record, he's 77. He's never been in trouble before, it appears. No driving though, Mr. Fafford, please.
No driving.
Okay, thank you.
Thank you, Your Honor.
Thanks. I'm so sorry about that, Ms. Aycock. Jared Cohen. 2-5-I-414-929. I find myself talking. How you doing, Mr. Shemke?
Good to see you, Judge. Mr. Shemke, can get my client stands to my knee right now.
Your name, sir?
Jared Cohen.
He's going to plead to no ops, to suspend to be dismissed, true?
Correct, Your Honor.
Is that what you want to do?
Yes, Your Honor.
If you plead to that, possible penalties are up to hard fines, 90 days jail, costs of all those. You understand that?
Yes, Your Honor.
You guys gotta get these signed. I gotta have signed the advice of rights.
He already signed a previous one.
Yeah, well, the corporal doesn't allow that. Here, Tabitha. Mr. Gates, will you please remind the prosecutors to, if you're going in and seeing any of them today, make sure that they remind everybody to sign the advice of rights. Will you do that for me?
I will let them know.
So, sir, did you sign, read, and understand that advice of rights?
Yes, Your Honor.
You understand you plead guilty, you'll be giving up all those rights?
Yes, Your Honor.
You understand then we won't have a trial?
Yes, Your
To
Honor.
the charge, no valid operator's license in person, how do you plead?
Guilty.
On the 18th of March of 25 at 1:43 in the morning, were you operating a vehicle on West River near Ferry and Grosia?
Yes, Your
Did
Honor.
you have a valid operator's license with you on your person?
No, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody in the world force you to plead guilty?
No, Your Honor.
Boy, they're getting a lot nicer than when I practiced law. They're taking the revoked to no ops, right?
I did do some uphill battles to get there, Judge.
I'll accept plea. What do you want to say? This is not,
Your Honor, we're in the process of getting my client his license back. We're gonna go through the full process. He's accumulated his letters. He's been going to A on a regular basis. He is gainfully employed, strong family support system. I've instructed him that every time something like this happens, it does delay our process. It's my hope that he will take it seriously and ask for costs and fines and pay.
anything, sir?
No, Your Honor.
Don't come back in front of me on a revoked. Let's reduce to no ops or anything else, okay?
Yes,
You
Your
gotta get a license.
Honor.
You've
Absolutely.
had 2 drunk drivers. You cannot drive. 100 fines, 260 costs. 75 at Detroit's $50 justice assessment, 485 or 90 days. Stop driving. Get your license. Otherwise, you're gonna be pushing the car when you're 80. Good luck, thanks. He can pay that now, right?
I was gonna ask for, what's the balance, Judge?
480, or did I say 85? 485.
Your Honor, you can make a payment on Friday. I asked for 30 days to be paid in full.
Where does he work?
Corrigan, well.
All right, you pay 150 by May the 9th, balance by, can you pay the rest, which would consist of 335 by May the 23rd?
Yes, sir.
You sure?
Yes, sir.
If you don't have the money, come talk to me. That's what I'm ordering. 150 by Friday, May the 9th, balance by May 23. Need more time, no problem. Come talk to me, okay? Thank you very much. Good luck. Thanks. Levels Trucking LLC, 25B14845 for A and B.
Your Honor, respectfully, Sam Richardala, P62186, appearing on behalf of Levels Trucking.
Good morning. For purposes of arraignment, they stand mute, waive formal reading. True?
Correct, Your Honor.
All right. So now what did you work out? Just a no registration plea with, that's on file A, pleading the civil infraction, no registration. And then file B will be dismissed, as well as the original charge on file A, which is exceeding gross vehicle weight. So, right, so one civil infraction, file A will be dismissed. The original charge on file A and file B will be dismissed, right?
That is correct, Your Honor. I have the authority to enter into the responsible plea for no registration.
All right, to that charge on behalf of the company, to no registration on person,
Responsible, Your Honor.
responsible or not responsible?
Responsible, Judge.
I'll accept the plea, 225, paid by me the 21, okay?
Thank you, Judge. May you and your staff have a wonderful day.
And I'm dismissing the original charge on A and dismissing B. Thank you, you too. Story, David Allen Story, 25B709142. Are they out there?
Is that the silent record?
Yeah.
They were just out there 10 seconds, so I don't know where he went. He was literally just out there.
It should be Ms. Tulas, I think.
It was the target out there.
Counsel, do you have a case?
Kind of 11 o'clock, Your Honor, formal hearing.
Okay. Okay.
Just want to let somebody know I see
What's
that Paloma Trucking is the respondent's name.
Oh, that file's.
Brewer. Andrea Lynn Brewer, 25B148214. Where's your lawyer? Didn't you have a lawyer?
Yes, he was just in here.
Mazengate.
That's supposed to be Carol.
Oh,
Yeah. Just wait.
yeah, have a seat.
Okay. Right here.
That's good.
Okay.
Detective Tulaz is here now.
All right. Call Mr. Permanent. People against David Allen Story, 25B709142. Detective, your name?
Good morning, Your Honor. Crystal Tulaz, Detective, Rhinestone Police
You
Department.
have to start your video. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Your Honor, initially, I would note on the complaint that it lists count 1, count 2, and then it goes right to count 4 and count 5. So I would move to amend count 4 to count 3 and count 5 to count 4. There should have only been 4 counts, Your Honor.
I got it. Go ahead.
Okay. On December 24th of 2025 at approximately 7:45 p.m., Officer Bernard and Officer Waterworth were dispatched to the area of Sibley Road and Donshire Drive in reference to a vehicle that had driven off of the road and into the ditch. Upon arrival, officers located the vehicle in 1994 white and black Ford F-150 in the ditch of 19001 Sibley Road in Brownstown Township and observed that there was a single male occupant identified as David Allen Story sitting in the driver's seat of the vehicle. Officer requested that the defendant Story exit the vehicle, and as he did so, he was unsteady on his feet and pulled an open bottle of Jack Daniels from his pocket and placed it on the seat of the suspect vehicle through an open window. Officers interviewed Mr. Story, who stated that the suspect vehicle had been crashed by his niece, witness Lisa Story, and that she had called him to assist her. Mr. Story stated that he had been dropped off at the 7-Eleven store located at Allen and Sibley and had walked to the vehicle. Mr. Story admitted that he had been inside the suspect vehicle and that he thought he was going to be able to back it up and pull forward and get out of here, but it didn't work. When Officer Waterworth asked Mr. Story why he was trying to drive the vehicle, Mr. Story stated, I'm just trying to get the vehicle out of the ditch. Officer Waterworth asked Mr. Story to show him the phone call that he received from his niece, witness Lisa Story, after she had crashed the vehicle, and Mr. Story gave officers his phone. Upon checking the call history, Officer Waterworth observed that no phone call had been received by Mr. Story from witness Lisa Story, as Mr. Story alleged. Mr. Story allowed the officers to use his cell phone to contact Miss Lisa Story to interview her regarding the incident. They spoke to Miss Story over the phone and again in person when she arrived on scene. She denied driving the vehicle or knowing anything about the incident. She reported that the suspect vehicle had been parked at a friend's house for over 2 months, had not been driven because it was not running and had defective brakes. She did not know where the keys were or that the vehicle was being driven by anyone. During the officers' interactions with Mr. Story, they observed that the odor of intoxicants was coming from his breath in person and that he had slurred speech, bloodshot, glassy eyes, difficulty with coordination, and was unsteady on his feet. Officer Bernard also asked Mr. Story if he had consumed any alcohol, and Mr. Story admitted to consuming 2 drinks tonight. Based on these observations, the crash, and Mr. Story's admission to consuming alcohol, Officer Bernard requested that Mr. Story perform 3 standardized field sobriety tests. The first test was the horizontal gaze nystagmus, and Officer Bernard observed a lack of smooth pursuit, distinct and sustained nystagmus at maximum deviation, and the onset of nystagmus prior to 45 degrees. in both of Mr. Story's eyes. The second test is the walk and turn, and while attempting the test, Mr. Story could not maintain the starting position, started the test before instructed to do so, used his arms for balance, and failed to touch heel to toe. The final test was the one leg stand, which Mr. Story stated that he was unable to perform due to breaking both of his ankles. Mr. Story consented to a preliminary breath test with a result of 0.203 and was placed under arrest for operating while intoxicated. He refused a chemical blood draw. However, after obtaining a search warrant, which was reviewed by a Wayne County prosecutor and signed by the Honorable Judge Jennifer Coleman Hudson of the 33rd District Court, Mr. Story's blood was drawn by a nurse at Henry Ford Hospital in Brownstown using an MSP blood kit, and it was sent to the lab for analysis. The MSP forensic laboratory testing completed by forensic scientist Perez showed that Mr. Story had a blood alcohol content of 0.185. A lean CCH check for Mr. Story shows that he has 3 prior convictions for alcohol-related driving offenses on his CCH. However, a check of his driving history with Michigan Secretary of State shows that he has 2 additional prior convictions, so 5 in total, including August 16th of 1993. He was convicted of operating while impaired by liquor out of the 33rd District Court. March 14th of 2000, he was convicted of operating while impaired by liquor out of the 24th District Court. December 17th of 2003, he was convicted of operating while intoxicated out of the 82nd District Court. On November 30th of 2011, he was convicted of operating while intoxicated out of the 25th District Court.
Slow down a second. Stop a second. I know they only have to put 2 prior convictions, but these are the ones that I'm showing. Operating while impaired 8/16/93, this court. Operating while impaired March 14, 2000 out of the 24th in Allen Park. December 1703 in the 82nd District Court. Operating while intoxicated November 13 of 11 out of Lincoln Park, the 25th. Is that all accurate?
Those are, and then there's a 5th conviction that was a felony conviction. All the rest are misdemeanors. And the felony conviction was on July 25th of 2012 out of the 34th Circuit Court.
So he's got 5 prior convictions, huh?
Yes, Your Honor.
Not very good. Based on your sworn testimony, I think you've covered everything. His license was suspended or revoked at the time, true?
Yes, Your Honor.
All right, I don't know when you signed this and sent it over, but I swore you in today. I'm changing that, crossing out the May 6th date, putting on May 7th for the day that we did this. I'm authorizing the issuance of the complaint and warrant on all of the charges contained therein, including drive while suspended, open intox, super drunk third, and OWI third. And I will authorize the issuance of the complaint. And that will be it, unless you have something else. Anything else?
No, Your Honor. Thank you for your time today.
Have a good day. Thank you.
You too. Thank you.
Is Mr. Carmen, did somebody call Mr.
I've
Carmen?
called him 3 times. I tried to stall him. He's not answering anything. Oh, he just said he'll be in shortly. He's in courtroom.
People Against Messer, Austin Tyler Messer, 25R704143. Do I have Rockwood out there?
I thought it was a Rockwood County. It's a Trenton case. I admitted Trenton. I don't know where they went.
Well, this is Lieutenant Mercure.
I understand that. I called Rockwood and they told me it was Trenton. So Trenton zoomed in. I don't know what's going on.
Okay, bring Trenton in. I don't know.
Is it your, just have a seat. I did bring them in, Your Honor, but they disappeared. I don't know where they went.
Do you know anything about this, Lisa? Looks like it on Pingree Street in Rockwood. How can Trenton be?
The name on that one?
Austin Messer. Austin Tyler Messer. Matthew James Cho Kazmarek, 25I-414-924. Did you represent yourself, sir?
No, I spoke to the attorney. It's Mr. Carmen's will, Your Honor.
Who's our docket lawyer today, Lisa? Whoever has.
Take that phone out of here.
It's going out, sir. Who's our docket lawyer today, Lisa?
Patillo, she's getting slammed, so we'll close her down.
I got it. You're gonna have to have a seat, I'm sorry. Roseanne Martinez, 25B1479337A and B.
Ready, Your Honor. Your Honor, may I unfortunately have another document?
Yeah, but she's got a problem here with me. She better get into sobriety court.
She didn't.
State your appearance.
Greg Boulhanis on behalf of Rosa Martinez. Your Honor, she does have,
Your name, ma'am?
What was that?
What's that?
I'm sorry.
your name.
Oh, Rosa Martinez.
She does have 2 ETGs that she took because she was late on a sober card. And I do have,
I got a problem here.
okay.
She's on probation in Taylor and now she goes out and picks up, I'm not in Taylor, in Toledo, and she goes out and picks up another one.
Yes, sir. I understand.
Where does she live at?
She lives in Toledo, you know. I don't know if it helps you, Honor, but if you look at the pre-sentence report, the BAC on this one is 0.113.
I see that. She's also got THC in her system, right?
Yeah, I understand, Your Honor. But as you know, Your Honor, the scientific evidence, there's no correlation between the THC level and
Except she admitted that she was smoking marijuana. I thought this was the one earlier in the day. Now, I could be confusing this.
Yeah,
And
earlier in the day, I don't know when. No, it's
I mean,
I understand, Your Honor.
you better get into sobriety court. You better talk to her about sobriety court. She can't do this.
Okay, she has, I just want to let the court know, can I say a few things on her behalf first?
Yeah, but I'm not likely to go through the sentence today unless.
Okay. I just want to let you know that, I did look at, she has been doing she has stopped drinking since the day that he had stopped.
Everybody tells me that. I'm not saying she did, but I've never heard.
We have sober leave since the last court hearing. And, we do also, I don't think she has any positives from the sober leave. And we also have the AA meetings, and she's been doing 2 a week, Your Honor. And I just handed you a document that indicates that she voluntarily did this
Driver intervention
program in Ohio. So.
You don't think this is gonna help much, do you? I mean, she needs.
I think.
What is she doing?
Well, the recommendation is intensive outpatient.
Right, this is a 3-day program.
The intensive outpatient system?
No, this.
Oh, no, I know, it's just something to show that she's making the effort. Your Honor.
Well, I'm not saying she's not making an effort.
So she's
Reporting her marijuana use is daily. She's got it done with that.
She quit smoking, when did you quit smoking marijuana?
I can't.
The first court date she had here, Your Honor, when you ordered not to smoke marijuana, she quit smoking marijuana.
She drove into the back of a semi. She just got another one back in November, right? And that's when she was convicted. And then 1 month, right after 3 months after she's convicted, if that, she gets another one.
Yeah, there's no question she has alcohol.
She's either gonna have to get sobriety court or she's going to jail, period. That's it. I'll give you a week to talk about it with her. I mean.
So, okay.
I'll adjourn. Here's what I'm gonna suggest we do.
Hold on a second. Can I look at my?
Yeah, but while you're doing that, I'm gonna adjourn the sentence and we're gonna pick a date. And I'm gonna encourage her to go over to probation and talk to them and see if she can do this.
Okay, she does, I just want to let you know, I understand where you're coming from. But you understand, she has 4 children.
I get it. But what's she gonna do? She's gonna leave them without a mother? I mean, she just
No,
drove in the back of a semi 3 months after she was in another court being convicted, probably 6 weeks after she was sentenced there. What day was she sentenced there?
I don't know, Your Honor.
What day were you sentenced there, man?
From the
What month were you sentenced in Toledo?
first.
Probably in January, right? And in February, 5, 6 weeks later, you went out and drove in the back of the semi. I'm not trying to be mean.
No, I know.
I'm just telling you, I'll adjourn the sentence. How long do you want? And here's what I'm gonna suggest. She go over there and hopefully you sit her, and she can,
I'll explain to her.
talk to them and see but I want her to talk to them. And you can sit in on it. It shouldn't take long. Tell them I want them to talk. Tell Emily or somebody over there, if you would. I'd like her to, would you do that today? Call Emily and tell her I'd like her to talk to Ms. Martinez and Mr. Boulahanis. We'll adjourn the sentence. They'll explain the whole program to you. Why don't you give me another date, Lisa, in a week or two, a couple weeks, I guess.
May 21st at 8:30.
Is that good?
No, the 36th District Court hearing in person at 8:30, and then 10 o'clock I have a Zoom hearing.
Is there a Donald Cruz here, either on Zoom or in person? That has to be the trucker.
No, not on Zoom.
All right, so
28th at 8:30.
I don't want to go that long on this, Mr. Boulahanis. Hang on one second. Listen to me very carefully. I don't have to do it. The victim failed to appear, so there's no restitution.
Can we do the 28th there?
I don't want to go that far. I mean, I really want to get her in here or tell her yes or no, and I think we should do it the next week. Like on the,
Hold on. Okay, let me just see what.
Can you do next Wednesday?
Hold on. Can we do it in the afternoon?
Yeah, I'll do it in the afternoon.
Yeah, that's.
Oh, wait a minute, I can't do it on Wednesday afternoon. Thursday morning. How about Thursday morning?
Hold on. So the 15th?
Yes.
Okay, hold on. I have a Zoom with you at 8:30.
Who?
You.
Well, then you can just,
Zoom with you at 8:30.
well, then you can just come in and do it in person.
Okay.
And you can Zoom, you can do that one in person. We'll do this one in person on the 15th at 8:30.
Yeah, I think I can squeeze that because I got another.
I'll be out here at 8:30.
Okay.
Okay?
8:30 on the 15th.
8:30 on the 15th.
Okay.
And
then I have a probation violation with Judge Hudson too.
today?
Right now.
Okay. Well,
So I'll go.
yeah, check in over there and they'll work it out with you over in front of probation, in probation, where you can.
And so you want her.
I want her just to have the whole program explained to her.
Okay.
And then she can make a determination as to whether or not she can do it. I don't want to get her in the program if she just can't do it.
Right.
But she might not like what I do if she doesn't get into
Well,
it.
can you do cops?
No, I don't do cops. You know I don't do cops. You know I don't do cops.
Okay, thank you.
All right, thanks. Austin, Tyler, Master, 5R704143. Lieutenant, your name?
Second Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you give in these proceedings will be the whole truth self you got.
I do, Your Honor.
All right, go ahead.
Your Honor, on October 22nd at 24 at approximately 12:30 p.m., Officer Steve Corn was dispatched to the Rockwood Police Department lobby, referenced a larceny from a building complaint, and he met with the victim, Zachary Laforda. Laforda stated he owns a Gibraltar Investment Group Incorporated located at 32117 4th Street in the city of Rockwood, and his business buys and sells household goods from this location. Zachary recently had some items stolen from the business, and he thinks a former employee, Austin Messer, took the items. Zachary had fired Austin on 10/21 at 24 on suspicion of he may be stealing items from the business. Zachary stated he and fellow employees locked up the building at 6:30 p.m. on 10/21 of 24, and when they returned on the morning of 10/22 of 24, they noticed multiple items were missing from the building. They also noticed that there was no forced entry, no damage, and no indication of a breaking and entering. Zachary stated that when he fired Austin, he has failed to get the keys back from the building at that point. Austin provided a list of stolen items: an Acer gaming monitor valued at $300, a Razer gaming laptop valued at $2,700, a Asus gaming laptop $1,500, Milwaukee tool kits, variety plus batteries, total of $400, Oscillating Quest $1,516, gold watch, cologne for men $400, JBL speaker $800, Sony speaker $80, Samsung SD cards, several of those $140, iPhone 11 PM $400, several trading cards, Belgian Premium First Edition glasses, and so approximately an hour later, Zachary came back in the station and said that Brad Messer, who is Austin Messer's grandfather, who lives on Pingree Street right behind the business, stated that he believes in Austin's bedroom there's several items that may have been stolen from his business. Brad invited Zach over to his house. They went into Austin's bedroom, and indeed there was several items that were stolen from the business. At that point, Officer Korn went over there, stood on the front porch, and Brad and Zach removed the stolen items from Austin's bedroom and turned them over to Officer Korn. The items that were removed from the bedroom were the Calvin Klein cologne, Samsung cam cards, SD cards, several trading sports cards, holographic Premier First Edition glasses, iPhone 11 box, which was empty, and an iPhone cereal with a box. All the items were brought to the station, photographed, and returned. While speaking with Zachary, Zachary told myself that Austin made comments to him that he likes to pawn a lot of his items at the Taylor Exchange on Telegraph Road in the city of Taylor. On 10/25 of 24, I went to the Taylor Exchange and spoke to Paul Fruman, who is the owner. Paul, who provided two bills of sale, number 44141 and 44072. They both were in the name of Austin Messer, customer ID of 49250001. On the 44072 was on 10/12 of 24 Milwaukee drill, a quarter impact driver, multiple tools and multiple hand tools. And the pawn was a total of $125. Number 44141 was on 10/17 of 24, the laptop electric Razer RZ090485, number BY2402N30600510 for a total of $400. Both items and the had a tag on them with Austin Messer's name, and as well as the pawn slip was in the name of Austin Messer. The stolen items that were recovered from Brad Messer's house, and as well as the Taylor Exchange, were matched up with the list of stolen items from the location on 4th Street and Hearn River Drive. In reference to the habitual offender, Your Honor.
Let me just get one thing. Do you have a total value on all of the property?
Total value of property that was stolen was $12,095.
Good enough. And do you have these prior convictions? I'm just going to run through them real quick. July 26, 24, all out of the Livingston County Circuit Court. Organized retail crime, assault, resist, and obstruct an officer, and another count of assault and resist and obstruct an officer. True?
Correct, Your Honor.
Based on your sworn testimony, I find that the crime of RNC 1,000 or more, but less than 20,000 was committed. There's probable cause to believe the crime was committed by the defendant. I'm going to authorize the issuance of the complaint and the warrant. And I'm going to note that there's sufficient evidence on the record to give rise to the habitual fourth offender notice. And that's it. We can go from there. Thank you very much. I'm signing the warrant. Have a good day.
I did not date it. I thought the court was going to date that, so.
Wait, say that again?
I did not date the,
I dated it.
Okay, thank you, sir.
All right, have a good one.
Thanks, you too.
Did you guys resolve that? Is that a formal hearing? I know- Did you guys resolve it or not? Okay. Mr. Lechner, Ms. Hamame, I see you guys out there. Do you have anything for me?
We're asking for a 2-week adjournment to continue
Is that with Ms.
negotiations.
Hamame or who's it with?
Ms. Hamame,
It's-
yes, Your Honor.
Can you bring
Judge,
that
Miss-
in? Go ahead.
Detective Secretaris is on his way in with it. I'm sorry, we thought it already went in.
That's all right, no problem. Just make sure they sign the advice of rights. Will you do that for me? I'm getting them, the defendants.
It's an ordinance violation, Your Honor.
I'm
It's
not
not a,
talking about that. I'm talking about in general.
oh,
Whenever you have a plea on something, I gotta have that rights form signed, okay? Then I-
Sorry about that.
That's okay. What are we adjourning this for again, you guys? Loma Oh,
This is actually the first time up.
That's Loma Trucking. No, that's not yours. All right.
Strong's.
Yeah, I got it. I'm getting files thrown at me. People against Alicia Strong, 25I-76086.
good morning, Your Honor. Attorney David Lechner, P number 67994, on behalf of Alicia Strong, who is present in the courtroom.
Ma'am, where are you? Come on up here and state your name at the podium if you would.
Alicia Strong.
So, guys, I don't want to be the bearer of bad news, but I don't want to keep adjourning these civil infractions. I mean, I know that this is just, the ticket was written April 2nd. I'll give you till March 21 or May 21, but that's going to be the formal hearing date. May 21 at 8:30, at what time, Lisa?
9 o'clock.
She can get these items out of there by then, right, Mr. Lechner?
Well, it's more than I'd be talking with the prosecutor about this, but there's other issues that aren't the items, Your Honor. So that's what needs to be discussed.
What do you mean? Tell me.
Well, there's two line items on the ticket. One is waterfront provisions, and that one relates to items being stored allegedly improperly, and the other one is a clear vision triangle violation that we would probably be disputing based on the language of the ordinance. And the other is Chapter 103, is a white panel fencing, which is what the ticket says, and orange construction fencing. The orange construction fencing has already been removed. The white panel fencing is not fencing. It's
all right. Okay, here's the deal. All I'm reading on the ticket is the notices were sent beginning February 26th. And it says municipal civil infraction issued April 4. Payable to Brozile by April 13 has gone unpaid and violations remain. And that's fine. People don't think they did anything wrong. I've got no problem. But we're going to formal hearing on May 21. At 9 o'clock, did you say, Lisa, or did I just write that down?
Yes, 9 o'clock.
May 21 at 9 o'clock. We're going to have the formal hearing. Ma'am, you go down and get your notice. We'll see you back here.
Thank you, Your Honor.
Thank you. Do I have somebody else here in another case? You're all set. What, Ms. Foley Carter? She's not out there, is she?
In the breakout room.
I don't have Mr. Kazmarik's lawyer's in another courtroom. The lawyer for Loma's here. I got nothing else. Is there anything else down there I can call? Sir, in the front row here, what is your name? In the front row, yes.
Anthony Johnson.
Do you have a case in here?
Yeah.
Did you ask for a lawyer?
I talked to him.
He talked to Ms. Patillo, Your Honor. I don't know what's going on.
Sir, in the back, what's your name?
Robert Isaac.
That's Priscilla's as well.
Well, she's got
I don't know
it.
why she's not reading files in front.
It's all right.
I'll find out. Oh, boy.
Are you ready on these?
Yes.
All right, let's take Kazmarek. Matthew James Cho Kazmarek, 25I-414-924. Mr. Carmen, your appearance.
Michael Lee Carmen, you said 324 on behalf of the defendant.
Sir, your name? For purposes of arraignment? Nobody is having anybody sign these. I'm telling you, I'm gonna get really agitated. I don't wanna have to keep asking everybody. This is like, I gotta have these guys sign these advice of rights. I'm not gonna go through them every time orally. I have
Separate advice of rights in there.
today.
I saw one.
Maybe there is. There is. Okay, good enough. So this can be a plea to failure to report. Is that what you want to do?
Excuse me?
Do you want to plead guilty to failure to report a property damage accident?
Yes, Your Honor.
Okay, that is a misdemeanor punishable by up to $100 fines, 90 days jail, costs are all those. Do you understand that?
Yes, I do.
And did you sign, read, and understand an advice of rights form here this morning?
Yes, I do.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
I understand.
To the charge, failure to report a property damage accident, how do you plead?
Guilty.
On April 17 of 25 at 7:37 PM, were you operating a motor vehicle on the lake near East River in Groseal?
Yes, I was.
Were you involved in an accident?
Yes.
Was it with a car that was being operated or a parked car?
It was a mailbox.
You drove into a mailbox?
No.
Are you on probation or parole?
No.
You left the scene after that?
Yeah, I didn't
You-
realize there was any damage to it.
You didn't call the police?
No.
You knew you hit something, right?
Yeah.
And
I
you-
didn't know if it was just a damage on the car or
Hang on. Was your car damaged?
a little bit.
Yeah. Did you get out and look at the mailbox?
No, I did not.
But you knew you struck the mailbox.
I knew I did something. I was hoping it was probably like trash there.
All right, then you left the scene?
I'll have to say that.
Anybody force you to plead guilty?
No, Your
All
Honor.
right, I'm gonna accept your plea. Let me just do this. Okay. I still think I need to notify the victim. I'm gonna do that. I mean, I don't know about the restitution. They could have charged something else maybe, but they didn't. I'm gonna set a sentence date. We're gonna notify the victim. Are we gonna do the 21st, Lisa?
Yes, 8:30.
So your sentence date will be May 21 at 8:30. There's nothing to be real concerned. You're not going to jail or anything, okay? But you can't be doing this. We'll notify the victim. We'll set it for May the 21st at 8:30, all right? Anything else? And I'm giving you a personal bond, by the way, of $100. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. Do you understand all that?
Yes, I do, Your Honor.
Okay. Wish you well. Go down the hall, get your notice, and then you come back on that date, okay? Thank you. Anthony Jones. Anthony Lavelle Jones, 25B-148-545. Mr. Carmen.
Michael Lee Carmen, you said 324 on behalf of the defendant.
How you doing, Mr. Jones? Your name? All right, so you got an improper plate, and it's gonna be pled to no registration. True, Mr. Carmen?
Yes, Your Honor.
Is that what you want to do, sir?
Yes, sir.
If you plead responsible here, I'm just gonna fine you. That'll be a civil infraction. A misdemeanor will be dismissed. Do you understand that? Just keep your voice up nice and loud.
Yes, sir.
To the charge, no registration, responsible or not responsible. Plea is accepted, the misdemeanor is dismissed, 125 is your total. You can go down the hall and pay that, you're all set. Good luck. How much do you have? Anything today or not? When can you pay it?
A week, give me about a week.
Where are you working at?
Self-employed.
Okay. Can you pay by next Friday, the 16th?
Yes.
I'll set it then. If you don't have the money, no worries. Come on in and talk to me on or before the due date, or call the court. We'll go on Zoom like this, and you can request an extension, and I will grant it. I promise you. No reason to ignore the court, okay? Good luck. You too. Thank you.
Thank you, Your Honor.
you have anything else? Don't you have one more, or am I wrong?
Not at the moment.
Okay, thanks.
Oh, no, I'm sorry, I got one more.
That's, yeah, what happened to her file? What's your name again, ma'am?
Andrea Brewer.
Should have your own.
I know, it was up here, and I think I must have taken it down. Do you have that, Lisa? Must have accidentally
If
put
you
it.
threw it in there, I assume.
Probably.
I'm checking right now. No, I don't see it.
Thought I had it. Oh, here it is. I'm so sorry. Andrea Lynn Brewer, 25B148214. Come on up, ma'am.
Michael Lee Carmen, 27324, on behalf of the defendant, Your Honor.
All right, ma'am, your name?
Andrea Lynn Brewer.
She stands mute, waives formal reading,
Yes, Your Honor.
and now she's going to plead as charged to possession of a controlled substance, true?
Yes, sir.
Is that what you want to do, ma'am?
Yes.
If you plead to that, the possible penalties are up to 500 fines, 90 days jail, costs or all of those. Do you understand that?
Yes, sir.
And did you sign, read, and understand it? There's a rights form here today.
Yes, sir.
If you plead guilty, you're giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes, sir.
All right, so you're gonna plead to possession of cocaine, right? That's what she's gonna do, Mr. Carmen?
Correct, Your Honor.
To the charge possession of cocaine, how do you plead?
Guilty.
Were you on Western Telegraph in Brownstown, April 17 of 25 at 8:25 PM?
Yes,
Were
sir.
you in possession of crack cocaine?
Yes.
Where was it? Where was it?
In my car.
Okay, was it yours?
Yes.
Where was it in your car?
It was by the emergency brake.
And you put it there?
Yes.
Are you on probation or parole?
No.
Anybody forced you to plead guilty?
No.
Please accept to that charge, possession of cocaine. Yeah, she already had one of these years ago, right? Screening and assessment. I'm gonna order a screening and assessment. We gotta get you off of that.
Yes, sir.
How long you been doing that? Don't lie to me. Give me a front sheet. Don't lie to me. How long you been using cocaine?
Quite a while.
What is that?
On and off.
I don't know. Quite a while. What is that?
6 years.
And how often is off?
Maybe twice a month. Not serious.
Personal bond, $2,500. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I want you going to AA, NA 3 times a week. You are also going to test legally. I assume that you haven't been using since April 17th. So when I send you for this and you test positive, are you gonna come back in here and tell me it happened before I set the bond? I just want an honest answer.
No. I'm gonna be clean.
When's the last time you used cocaine? Just be honest with
It would be the 16th.
me. Okay, so you've not used since then?
No.
So there's no reason for a test if we send you today to come up positive?
No.
Okay, good.
And I do have my prescription.
I know, I read that you had a prescription for the Xanax?
Yes.
How old is that, Mr. Carmen?
From April 16th?
Of 25?
Yes.
Okay, good enough. Screening and assessment, sentence date. When are we doing this, Lisa?
May 21st at 8:30.
May 21st at 8:30. Ma'am, I want you to understand something. You have to start going to AA, NA 3 times a week. Every time you go, you have to be in person, and you have to have the form signed to evidence your attendance. You're also to go over to probation, and they're gonna set you up for weekly testing, okay? You need to get off of that, all right?
Yep.
Wish you well. Anything else, Mr. Carmen?
Not at the moment.
Ma'am, any questions?
No.
So you're going down the hall to get your date, you're going over across the hall to be screened and assessed. You've got your AA form, true?
Yes.
Good luck. Thanks.
Thank you.
Call in Ms. Caitlin Foley Carter, please. $249. Should be. People against, I just want to ask you two a question. Loma Trucking and Landscape, you guys can stay right there. 25B148349, your appearance? Thomas?
Good morning, Your Honor. Tracy Thomas, being here for respondent.
So you guys have a dispute here. We're going to a formal?
Yeah, Your Honor, the people did offer a reduction in the price of the overweight.
What's your defense? I'm curious.
Well, can we approach?
Yeah? Come on up real quick. You can come up right that way or around that way, whatever you want.
You know what, I'll just talk from here. It's something called a Class A restricted road, which is a special version of Class A that's only applicable during the frost laws. It's Huron River Drive.
Come on up here, you two, please, come here. Go off the record. Hi. I'm going to promise to speak to the deal with this, and I'm so sorry. How long do you think this hearing's going to take? If you've got an argument like that, I'd really rather you put it, or I'm sorry, a little response. And then, I hate to make you come back. Where's your office? I've just got something this afternoon. I just can't get tied up on.
I think doing it on briefs would be fine.
I have no objection to.
It'll be a couple pages of brief and a map.
So can you guys stipulate to some facts here?
Sure, we can stipulate to a lot of facts.
Well,
Stipulate that he was on the road. in
Huron River Drive.
Can we be a little bit more convenient if your client or his employees, its employees come to the office and then like they come back? In a perfect world.
They're closer to here than they are by office.
Can y'all come back on the 21st and you file something by the 14th?
That's what you're on.
Thank you. Let's do that. People against Loma Trucking and Landscape, 25B148349. All right, Mr. Thomas, your appearance.
Yes, Your Honor. Tracy Thomas, appearing again on behalf of the respondent.
Caitlin Foley Carter on behalf of Brownstown Township.
Look, I'm going to adjourn this and I'm going to let him brief it. And then you can file a response. He says he's got a defense. I got to be honest with you. I haven't seen a defense on an overweight case that went to hearing. I don't even, maybe one in my 30 years here. We're going to adjourn it to May 21. I'm sorry. Lisa, give me a time. Set it later in the morning so nobody's waiting around. I'm thinking like 11 o'clock again. Is that okay with everybody?
Fine with us.
Lisa?
Yep, that's fine.
Can I go get the officer real quick?
Yeah, absolutely. Bring them out.
Thank you, Your
Your Honor, may everybody appear by Zoom if that's more convenient?
I could care less. You guys can do what you want. If it's the officer, your name.
Officer Paul Brownstown Township.
I'm gonna move this to May 21st at 11. I'm gonna let him brief it. Are you available?
Yes, Your Honor.
Let's make it May 21 at 11. If they're close here, I'd rather they be here. Or at least when I read it, I could give you an idea as to where I'm leaning and we can decide then whether or not they need to come in. And if they do, if they could just kind of be on call. You said they're closer to here, to the courthouse, right? I mean, they could be here in 20 minutes is what I'm saying, if you call them, right? 25, half an hour?
Yeah.
Let's do that. So they can appear, I'm either going to have them appear by Zoom or in person, probably in person. Stay in touch with them. And I'll let you know when we call this case. I'll meet with you and Ms. Foley Carter on May the 21st at Chambers at 11. And same with him. If you want to have him on call, I have no problem, okay?
Sounds good, Your Honor.
All right, thanks a lot, everybody. May 21 at 11, thank you. Thanks.
Brief, just email it, just call and find an email for you.
Well, you're going to email it to my judicial clerk. She'll tell you. It's lisa@33court.com.
Thank you.
Thank you.
Thanks, Jeff. Have a good one.
You too. Thanks a lot. Mr. Keough, do you have anything ready for me?
Yes, it should be Robert Isaac and, Lucero.
Okay, people against Robert, or Jose Maria Lucero. 258-48414, A and B. All right, Ms. Patillo, your name?
Good morning, Judge Dion Patillo on behalf of Jose Lucero. Can you say the full name of the court?
Jose Maria Lucero.
All right, so does he stand me away formal reading?
Yes, Your Honor.
He's got 2 charges here. I'm gonna give him a $500 personal bond. You cannot leave the state, sir, without the consent of the court or violate the law. You must appear in court as directed. I'm gonna set another pre-trial and then a bench trial if that's what he wants. Is that what he wants?
Yes, Your Honor.
You have the constitutional right to a jury trial. At a jury trial, 6 people would be impaneled. All 6 would have to agree that you're guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes, Your Honor.
Anybody force you to give up your right to a jury trial?
No, Your Honor.
I'll accept the waiver. We'll set it for a final pretrial, May 21, Lisa, at
10:30.
bench trial date will be
Hold on. June 18th at 1 o'clock.
June 18th at 1 o'clock. Okay, so I'll let you think about it. You and your lawyer will confer again on the 21st. If you still want a bench trial, no problem. We're giving you that date now, and that will be on June the 18th.
Okay, Your Honor, like the last guy, I also have to go out of state for work.
No problem.
June 18th is that bench trial, right, Judge?
Correct. No problem. Can leave state for employment. Okay? You can leave state for employment without consent. All right?
Yes, Your Honor, thank you.
What time is that bench trial set, Judge?
That is going to be at 1 o'clock. May 21st will be at 10:30.
Okay.
Thanks a lot. Isaac, thank you very much. Sir, go down the hall, get your notices. I wish you well. Robert, Dijon Isaac, 21B138927, A and B.
Dion Patillo on behalf of Robert Isaac, can you state your full name for the court?
Robert Dion.
He's going to plead to riding on a suspended, true?
Yes, Your
That
Honor.
is a misdemeanor, punishable by up to 500 fines, 93 days jail. Costs are all those in 2 points. Do you understand that?
Yes, sir.
And he also has here another contempt charge I have to take a plea on unless you're telling me he can pay that this morning.
How much is that?
282. Well, plus a clearance fee.
You can pay it to
Is that what it is now, you guys? Lisa, will you double check that? I believe it's 282. You still have to pay a clearance fee, not the 2, okay? $45 clearance fee to get that suspension lifted from your record. If you plead on the suspend charge, it's punishable by up to 500 fines, 93 days jail. Costs are all 2 points. Do you understand that? And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you're giving up all those rights, and there will not be a trial. Do you understand that? Okay. To the charge driving on a suspended, how do you plead?
Okay.
On March 7th of 21, were you operating a motor vehicle on Telegraph facility in Brownstown?
Yes, Your Honor.
Was your license suspended?
Yes, Your
Are you on probation or parole?
Honor. No.
Anybody force you to plead guilty?
No.
Please accept it to that charge. You're aware that you got 1, 2. I think I covered that with you. You got at least 3 warrants out for your arrest. You got to go take care of those. You're going to pay the civil infraction. Is that 280? No, it's now 317. Can you pay that?
Yeah, I can, yes, Your Honor.
Plus your clearance fee. You have a bond of 2,010% that's in your name, so 180 of that will apply to this suspend charge. Okay? Counsel, what would you like to say?
Your Honor, Mr. Isaac has been employed for 5 years at Yap Automotive. The reason that it took him so long to get to court, he did have some bad financial issues. I understand these tickets are, looks like from 2021. At that time, I'm not sure what his work hours were, but I know a lot of people have reduced work due to the pandemic. And he's just been paying bills. He has a child on the way.
Congratulations. Next time, if you don't have the money, you still go to court. You can't do that,
Yes,
okay?
Your Honor. Yes, Your Honor.
Anything else you'd like to say?
Your Honor, just having a child is good.
Good for you, boy or girl?
Boy.
Good? First one?
Yep.
Good for you. 100 fines, 150 costs, 75 victim rights, $50 justice assessment, 40 in attorney fees. 415 or 93 days plus the 317. Your total here is 732. You have a 2,010% bond, of which we keep 10%. So you'd have 180 there. So you'd need 552 to take care of all of these, plus hopefully a clearance fee that will lift the suspension on this no proof. Do you have all that?
I'll have, I can have that, my next step,
What's that?
my next step in 2 weeks, yeah.
How much do you have today?
He has 200
I
hours.
had 200, but yeah.
You gotta take care, I thought you said you were gonna take care of
I
that.
can take it, I'll read some, I'll do what I gotta do. I'll take
Listen,
it.
wait. I thought you said you were gonna take care of the no proof of insurance today. Did you not tell me that?
Yes, sir.
He is, Judge.
Okay, you're pay that now, and then I'm gonna give you until May 21 to pay the rest. And if you don't have the money, no problem at all. Just call the court, we'll go on Zoom. I'll be glad to give you an extension, or you can tell me in your honor before the due date, 8:30. Okay? Thanks a lot. You have any more for me?
I do, I have 2.
Okay, just let us know. Thank you.
Thank you.
It's a little warm in here, John.
Yeah. You gotta talk to Shane. I can't figure that thing out.
No, actually, it's cold. Why don't we?
He's got it set manually through the building, so he's gotta turn it up on that side. It's like a master set.
Can you help us monitor this better in temperature? It's freezing in here right now. Whatever. Okay. Thanks. All right, I'll take whatever you got. Thanks. Okay. All right. Amanda Christine Emerson, 24B146879, 25B147836, 24B146354, 24B146880, and then I have others assigned to Judge Hessen here, it looks like. I've got,
The 800 judge is with Judge Hessen, and then the 213 A and B is also with Judge Hessen.
okay, so those are going to her?
We're gonna do everything here because it's part of the global resolution, Judge. As far as the case.
All right, so 8213A, she's going to plead to, but she's going to be sentenced by Judge Hessen?
We're gonna enter the pleas here, and I believe, yes, that I don't know how we're gonna do it as far as the sentencing, but as far as the pleas, yeah, we're gonna take all the pleas in front of you, Judge.
That's Ms. Emerson, your name?
Amanda Christine Emerson.
All right.
Good morning, Judge. Matt, Ms. Emerson.
All right, let's start with my cases here. So 24B146879, there's going to be a plea to attempted entering without authority. And then 25B147836, that'll be dismissed. 24B146354, that'll be dismissed. 24B146880, those will all be dismissed. And then she's also going to plead on the case in front of Judge Hessen on the drug charge, 25B48213A.
The A and B, she'll be that.
All right, so you're going to go back to Judge Hessen for those sentencings. Do you understand that, ma'am?
On the sentence, you'll be in front of Judge Hessen on these.
On these two, do you understand that?
Yes.
On the attempted entering without authority, I'm going to sentence you. Do you understand that?
Yes.
If you plead on that charge, this is 46879. The possible penalties are up to 250 fines, 45 days jail costs, or all those. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
You plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge attempted entering without authority, how do you plead?
Guilty.
Were you at 23601 Hickory Lane in Brownstown, July 8 of 24?
Yes.
What did you do? Whose house is that?
That's Julie Frisbee's.
And what did you do? You went into the house?
No, I didn't go in the house. I knocked on the window and the screen fell.
Ms. Emerson, did you try to gain entry into that property on that day?
I knocked on the window and the screen fell. Yes.
Wait a minute, I only want you to tell me the truth. I don't want you to lie to me. I didn't hear what you said.
Yes, I tried to enter.
Ma'am, listen to me very carefully. I don't want you to lie to me. If you didn't intend to enter or try to enter, tell me that. If you did, then tell me that. If you didn't, we'll just set them off for trial. It's okay. I don't have any problem You do not have to apologize if you're telling me the truth. I'm gonna ask you again, and I want an honest answer. Did you try to enter that residence?
Yes.
How?
I knocked on the window and the screen fell.
Okay. When you knocked on the window, did you knock hard enough where the screen would fall so you could gain access to the property or not?
No.
So you tell me you knocked on the window, the screen accidentally fell, and you want to plead guilty to something?
No, I don't. I just want to get this stuff done and over with. And like.
Ms. Emerson?
Yeah.
Ms. Emerson, the judge is not gonna have you plead to something that you believe you did not do. Unless there's a factual basis for these pleas, we can't have these entered today. So the judge is gonna ask you, do you believe that you did anything wrong on that day? Did you try to enter that property without knowing?
And that's fine, if you didn't. Man, it's fine. I just want honest answers here.
I mean, I'm like.
You knocked
Yes, okay, so this is what happened. I knocked on the window,
what window?
on Julie's window.
Wait a minute. To her bedroom, to her living room, to her dining room?
Okay, she has a door, her storm door was locked. When I knocked on that, like, the screen door was locked, so I knocked on her window. And her dog was inside. Her dog jumped up on the window. And her screen is on the inside of the house. Usually the screens are on the outside. Like the screens of my house, they're on the outside. But her screens are on the inside. She's got 3 tiered windows that you can unscrew from the inside. That's how the windows are open.
Well, this is complicated.
I understand that, but I'm gonna be honest.
Well, I want you to.
Like this is.
Wait a minute. I don't want to hear this nonsense. Just go on. Tell me. So the screen's on the kind of the inside of the window is what you're telling me.
Yes.
So it would easily fall.
Yes, the dog jumped up on the window on the inside.
Okay.
The dog. And the screen fell. And her neighbor was across the street.
What happened when the screen fell? Did you try to go in?
No.
Was Ms. Frisbee in the residence?
She was in Florida, I guess. I didn't know that because I had just seen her that morning. I didn't know that she had already left.
She left the dog in the house?
Yeah, and like the whole reason why I even knocked on the window is because her cat was on the front of the porch with like 6 kittens, and it's like in the middle of July, and they're all covered in fleas.
Did you
And I'm
go,
like, Julie, like knock on the window.
is she your friend?
Yes.
Did you go into the residence?
No. Mm-mm.
She didn't check what we have over there.
I don't know what you want me to do here.
Let's just set a trial date.
I will. We'll set a trial date on all of these. And do you want a jury or a bench trial?
We'll ask for a jury trial. Ms. Emerson, would you like a jury or what?
I don't know, like, I know the jury.
The jury is ready, the jury makes a decision, the bench trial, we had her just before the election.
Yeah, I know that.
You want just a bench trial?
Yeah.
We're requesting a bench trial, but.
All right. can you fill out that form for me, Ms. Foley Carter? Can you fill out that form, the waiver form, and have them, she can sign it? All right, can you get that now real quick, please?
Everything, but I was on all then.
Ms. Emerson, you want a bench trial on all of the charges? But that includes the two that are from bench as well.
I'll work on those.
All right, so I'll cover this with you. I'm not going to take your plea. You have the constitutional right to a trial by jury. If the trial by jury, 6 people would be impaneled, all 6 would have to agree that you're guilty. Beyond a reasonable doubt, in order for you to be convicted, by waiving the right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand that?
Yes.
Did anybody force you to give up your right to a jury trial?
No.
Do you want to give up your right to a jury trial on all these cases that are mine here?
Yeah, the 3 cases, the 2 trespass and the entry without authority for a guilty plea.
Yeah.
You want bench trial on all 3 of these?
I don't know what the difference is.
The difference is.
We have a July 8, 24. That's this one I just covered with her.
Yes, I want them all.
And then March 5 of 25, I'm going to set for bench trial.
Yes.
Is that what you want?
Yes.
And how about Lisa 146354? That September 4, 24, do you want a bench trial on that?
Yes.
And then I've got, hang on one second. And then on 24B146880, that emanates from a incident that occurred September 10 of 24. Do you want a bench trial on that as well?
That's going to be from Judge Heston.
Oh, yes. Yes. So I'm going to accept the waiver to the 4 of mine.
The 3 you have, Judge?
I only have 3?
Yes.
Okay. I'll accept those waivers. Now, if you want me to, Ms. Emerson, take, so you guys go back to the drawing board on this other one, too.
Correct. Because these were supposed to be all part of global resolution.
All right. She's going to ask for the bench trial on all these in front of me. I don't know what she's going to do in front of Judge Hessen. Is she in custody on anything right now?
She is, Judge. You had sentenced her to 60 days on a probation violation. Her update, Judge, is May 20th.
Ms. Emerson. At what point are we going to grow up?
That's what I'm trying to do, but I can't say.
I don't want you to lie.
Right.
If do not go there. That is not what I'm saying here at all.
Right.
I just I've had you in front of me so many times.
I know, and I want to get this over with.
Whatever. I don't want to hear about it. We're going to set a bench trial, but you got to stop coming in front of me.
Oh, I know.
All right. So she's on personal bonds on all mine, right? I think she is. So I personal bonds on these others, and I'm going to continue to have her on personal bonds. And Lisa, you can tell me when we're going to set this for.
Did we decide on a bench trial?
Yeah, she's setting all these bench trials.
Okay, May 21st at 1.
We're going to set them all for that date. Is that what you?
You want Judge Hessen's that day also?
Well, I don't know what's going to happen. They're going back to the drawing board. Oh, wait a minute. Remember, Wednesdays are not good in the afternoon.
It's the only day the prosecutor's here.
I know. Well, I can't do it that day. How about on, is the docket light at all on that day or not?
No.
Well, I mean, I guess I could set it for May 21 at noon. I'm going to encourage everybody to continue to talk.
But
I do have these, though, I mean, all these are personal bonds in front of,
Judge Hessens do have bonds on her.
Judge, I have a settlement conference in Wayne Circuit at 11:15 on the 21st.
well, that isn't going to work then.
I can do,
Is there a way we could do one of these on the Monday? How about what's the date I'm doing on a Monday again, June 2nd?
June 2nd, but we're going to have a docket that afternoon.
How about June 2nd at 2 o'clock? How do I look? How about that? We're not going to have a ton of cases, are we?
Well, Brownstown is very heavy, so I'm moving your Wednesday to Monday.
I know. We're going to make it June 2nd at 2. And I'm hoping you guys can continue to work on this and resolve it. And if you can't, you can't. I'll have a trial. That's all. And she might have to wait a little bit. So you still have personal bonds on these, ma'am. So if you can post the $500 on Judge Hessen's case, you're going to be out in 2 weeks. Okay?
in the interim, can you have one final pretrial date on me to resolve the reports in a second?
I can do it May 21. You want to do May 21 in the morning at 8:30? Can we do that, Lisa?
Sure, 10:45.
Well, he's got to be downtown for a settle.
It's a Zoom, it's a Zoom meeting, Judge, but those usually will take a minute because this is a final.
Let's make it 10 o'clock on May 21. And then you can hopefully get this one done and that you won't be late. Let's try that. So final pretrial, May 21 on these at 10. And I don't know what else to tell you. I want you to know how sorry I am to hear about your mom.
No, like 5 minutes.
I don't want to see the same thing happen to you. I begged you to get into drug court, haven't I?
Yeah, I want to be tethered to a rehab.
I know, but I'm serious. I really would like to help you, but you won't let me. You don't show up, Emerson. You understand? All right, good luck. What am I gonna do on these? What do you guys want me to do on these?
On Judge Hessen's?
Just adjourn them all?
Yeah.
That's fine, we can put them back on the 21st and then do them all at one time for the final pretrial.
Will you tell Judge Hessen then?
Yes.
That I took these and
What about a trial date for her?
Pardon?
Do you want to set a trial date for her cases?
I have a feeling they're gonna resolve these. Let's just adjourn it to May 21. Right? At 10 a.m. At 10 a.m. And we'll go from there, okay?
Thank you, Judge.
Ma'am, I wish you well.
Thank you. Thank you, Judge.
Why are you so upset right now?
Because I mean, my mom just asked for it. This is over with. I just want my life to be different.
I know, but you won't let me help you. I think you'd be turned around if you would have come back and shown up on these. I really do.
I'm messed up, you know, messed up in the past. Okay.
Lisa, I'm just putting all these waivers on these files here, okay? Thanks. Wells, Sheena Wells, 2 5, B148012A and B. Good morning, counsel.
Ma'am,
Ma'am, your name?
Sheila Wells.
All right. So Ms. Polk, she's charged with fear to prop. She's got a careless driving and a failure to report. She stands mute, waives formal reading.
That is correct, Judge.
And then she's going to plead guilty to failure to report and responsible to careless driving.
That's correct.
Is that what you want to do, ma'am?
Yes,
If you plead to failure to report, the possible penalties are up to 100 fines, 90 days jail, costs are all those. If you plead to careless, that's a 3-point civil infraction. Understand that?
yes,
And did you sign, read, and understand an advice of rights form here today?
yes, Your Honor.
If you plead guilty to the misdemeanor, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes,
To the charge failure to report a property damage accident, how do you plead?
guilty,
We operated a motor vehicle on Sapphire near Birch in Brownstown, March 30th, 25 at 2:34 in the morning.
yes,
Were you involved in an accident?
yes,
Was it with another car or what?
yes.
What happened?
I hit another vehicle.
All right, you were driving on Sapphire, right?
Yes,
What happened? Were you careless in the operation of the vehicle that caused the accident?
yes.
Tell me what happened.
I hit a vehicle. I blanked out.
I,
Got distracted. And I hit a vehicle. A parked vehicle.
okay, you struck a parked vehicle. All right, and then you left the scene.
Yes,
And you left the scene without notifying the police or exchanging information with the owner of the vehicle.
yes.
Are you on probation or parole?
No,
Anybody forced you to plead guilty?
no.
All right. And again, to the charge careless driving, responsible or not responsible? I'll accept the plea to careless, accept the plea to failure to report. I don't need a pre-sentence report. I am going to order a sentence date. We need to notify the victim. Where's your office at, Mr. Polk?
I'm in Detroit, 500 Griswold, Detroit.
Well, you don't mind coming down and seeing us here, do you? Okay. We'll set a sentence date. We'll notify the victim of their right to appear. I mean, what date do you have for me, Lisa?
May 21st at 8:30.
May 21st at 8:30. Does that look good for you, counsel? You haven't been in front of me a lot, have you, Mr. Polk?
I've been here quite a few times, but not regular.
Okay. Well, good to have you again. All right, I just want to try to set it on a Woodhaven day. Can we do that one day in the afternoon on Monday, Lisa, or?
You mean a Brownstown day?
That's what I meant.
We can do June 2nd at 1.
How you look that day? All right, we're gonna set it June the 2nd at 1 p.m. June, wow, I made a mess out of this. June the 2nd at 1 p.m. Okay?
Thank you, Judge.
Thank you very much. Can you just take this, you can just take your client right down and they'll give her the notice and you're all set. Have a good day. Good luck, ma'am. Personal bond, $500. You cannot leave the state, cannot violate law and appear in court as directed. Those are just general bond conditions, and we'll see you here again in a couple weeks. Thank you. Tala Diawande Law. I think it's Tala Diawande Law, 25B 146-844-5A and B. And then I also have 25F 243345A and B and C. Good morning. And I also have, let me just double check it. 148-445, yes, A and B. Go ahead, counsel. I'm sorry.
No worries, Judge Dion Patillo on behalf of Mr. Law. Can you state your full name for the court?
Deontay Law.
So on this one, on the 445A, he's pleading to no ops. They're dismissing the suspend, and they're also dismissing the no proof insurance. True?
Yes, Your Honor.
But does he have the money to pay these other cases, I hope?
So he does not, Your Honor. He will.
All right, we'll talk about that. Sir, if you plead to no ops, I'm going to dismiss the suspend. I'm going to dismiss the no insurance. from that incident date of April 1. The possible penalties on this are up to 100 fines, 90 days jail costs, or all of those. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes, sir.
To the charge of no valid operator's license on person, how do you plead?
Good.
Were you operating a motor vehicle April 1 of 25 in the township of Brownstown on King near Telegraph at 10:04 in the evening?
Yes, sir.
Did you have a valid license on your person?
No, sir.
Are you on probation or parole?
Yes, sir.
Anybody forced you to plead guilty?
No, sir.
You're still suspended, right?
Yes, sir. Yes, sir.
Counsel, I'll accept plea to no ops, dismiss the no insurance, dismiss the suspend. I'm gonna sentence him on this. We can go from there. How's that? Anything?
Yes, Your Honor, Mr. Law just lost his job, and that is the reason that I was saying that he wouldn't be able to make any type of payment until this Friday. He has 3 minor children. He is engaged. She drove him here today, so he didn't drive.
Where's the lucky woman at? Okay, go ahead. What's that?
Nothing, Judge. So I was just asking if the court would take all that in consideration, before ordering extra fines and costs.
You can't drive unsuspended, okay?
Yes, sir.
Anything you want to say? You're still suspended, so it bothers me here, but I'm gonna go light. I'm just gonna fine you. I'll give you time to pay, but
Well, currently, I can take care of the ticket and the Secretary of State said to lift the suspension.
okay. Anything else?
No, sir.
100 fines, 100 costs. I'll tell you what, I'll make it 70 costs. 75 victims' rights fee, $50 justice assessment, 40 in attorney fees, $335, or 90 days on that one. You owe 327 on 25F243345C. On the B file of that, you owe 213. On the A file of that, you owe 225. Let's talk about this one. When can he pay this one?
So he does have a job interview, and he's gonna go to Michigan Works to see about unemployment, Judge, so he would need some time to make payments. And you're talking about the January 2025 tickets, right? I think that was.
Well, he's got, the one I just handled was from April 1. This one, the other ones are from January 21.
Right, so those are obviously default. I was just asking the court, we willing to give him time to.
75 a week you pay, sir. I'm gonna start this beginning on May the 30th. Can you do that, you think?
Yes, sir. What day?
May 30th.
Yes, sir.
75 a week.
And then, Lisa, set them up on payment plans on the rest of these at 75 a week, starting on June the 6th. Okay? If you don't have the money, it's not a problem. Just come talk to me.
Yes, sir.
Just be respectful. The stuff about not showing up and not doing anything. All right? Good luck to you. I sincerely wish you well. Any questions at all? So I mean what I'm telling you. If you don't have the money, it's not a problem. You come in and talk to me. I'll give you an extension. If we have to do it, I don't care how many times. Do we understand that?
Yes, sir.
Alright.
May 31st, May 30th, you said 75 a week?
Correct.
Yes, sir.
Okay?
Yes, sir.
Best of luck. Police, Noel Jackson, 25E48486. A and B, 25E1485570, A and B, 19T633606A. Your appearance?
Yeah, you only have Talise Jackson, state your name for the court. Talise Jackson.
I hope you adjusted your attitude. You adjusted your attitude since you were back up here before?
I adjusted my emotion.
Okay.
She's had some things happen.
All right, let's go through one file at a time. All right, let me start on the notes. 25E1485570, A and B. We've got a defense date of April 18th. They're going to dismiss those if she pleads on 25E14846A and B. That driveway suspend and the disobey stop sign. And then we have to deal with the warrant on the 19 case. So is that, first of all, for purposes of arraignment on all of these, does she stand mute, wait, formal reading?
Yes, Your Honor.
So I'm entering not guilty, please, 4 on those. Now, if the other 2 are from the incident date of April 18 of 25. If you plead to disobey stop sign, that is a 3-point civil infraction. If you plead, excuse me, to driving on a suspended, the possible penalties are up to 500 fines, 93 days jail, costs, or all those. Do you understand that?
Yes, I understand.
And there's 2 points that would be added to your traffic record. Do you understand that?
Yes.
All right, did you sign? Well, actually, on suspended, you 2. On the disobey stop sign, there's 3. You only get the higher 2-point total, so you get 3, not 5. Do you understand that?
Yes.
Did you sign, read, and understand the advice or rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
All right. To the charge driving on a suspended, how do you plead? How do you plead, man?
Plead guilty.
On April 18 of 25 at 2:14 p.m., were you operating a motor vehicle on Mills Drive near Valley in Brownstown?
Yes.
Was your license suspended?
Yes.
To the charge of disobey stop sign, responsible or not responsible? Right now, you are on probation still to me on this other, wait a minute, let me just double check. Well, I didn't. Yes. Only did was place on probation. You're on probation to me on this 19 case, right?
Yes.
You understand by pleading guilty to this suspend, that would be deemed a violation of this probation. This probation could be revoked. You could be incarcerated on this charge. I'm talking about in the 19 case as a result of the plea and conviction from the 25 case. You understand that? And if you still wish to plead guilty? I can't hear you, man. I can't, I'm sorry.
Yes. Sorry.
Anybody force you to plead guilty?
No.
Please accept it to that charge of driving on a suspended. Please accept it to disobey a traffic signal. Now we've got this 2019 case. All I did was put her on probation on this only because I wanted to clear if she must have had a ton of warrants. And I said all suspensions to be lifted by March 1 of 20. How ironic. Just so you know, even though she got real testy with me, as though I'm incorrect by questioning why she hasn't been here since 2019. She goes out on these cases. I don't have an answer for this because I haven't looked at her record, but my strong belief is she probably never has had a valid license, even though I told her to have the valid license by March 1 of 20. And then, not only didn't she have a valid license on this date, she also picked up one 4 hours earlier, and she's in here acting like she's oppressed. Go ahead, what are we doing on this one? Is she pleading guilty, or does she want a hearing on failure to attend her scheduled probation visit? It looks like on, I can't tell, it's a typo, it says 68/9/19, so I don't know if it's June 8th or August 9th, 19th, so that's.
I think it was May 30th, 2019.
That's what I sent.
That's what you sent.
But I'm talking about, there's a 3-count warrant here, show cause that she didn't show up on, failure to attend her scheduled probation visit, failure to pay fines and costs as directed, and failure to clear all warrants as directed. So how's she going to proceed on that?
So, Your Honor, did you want the explanation? Okay, so.
She either needs to have a hearing or she needs to plead guilty to those counts.
She will be guilty with an explanation.
Okay, let's call in somebody from probation. I don't know what day. All right, if you plead guilty here, I want you to understand you could be incarcerated for up to 93 days. Your probation revoked. Do you understand that?
Yes.
And you understand all your rights.
Yes.
And you understand you have the right to a hearing.
Yes.
And you understand if you plead guilty, you're giving up your right to a contested hearing, you're giving up your right to remain silent at that hearing, you're giving up your right to cross-examine any probation witnesses at that hearing. If you plead guilty, you're giving up all those rights. We won't have a hearing, and you could, again, have your probation revoked. Do you understand that?
Yes.
All right, so the charge of failed to attend your scheduled probation visit, which I'm just gonna say, it was the first visit, it appears. After sentencing, how do you plead?
Guilty.
Did you fail to appear at that probation visit?
Yes.
Got to keep your voice up. Is the count two? Did you fail to pay your fines and costs as ordered? How do you plead?
Guilty.
Did you fail to pay your fines and costs as ordered?
Yes,
Is the count three that you failed to clear all warrants as directed? How do you plead?
Guilty.
Did you fail to clear all your warrants as directed?
No.
You cleared your warrants?
I'm sorry, yes.
I'm going to ask you again, the charge of failed to clear all warrants specifically by June 4 of 19. How do you plead?
Guilty.
Did you fail to do that?
Yes.
Anybody force you to plead guilty?
No.
I'll accept the plead all three counts. Ms. Wiles, I'm going to ask you in a moment to tell me what day the probation visit was supposed to be. There's a typo in this show cause that was generated back on August 15 of 19. All right, Ms. Patillo, what do you have to say? Give me something good here, because not only did she blow this off, not only did she drive twice on a suspended license within 4 hours, she came in here like brimming with, like, who do you think you are questioning me? And that just tells me she doesn't see anything wrong with what she did. And that spells bad news for her. So first of all, you tell me, and you can gather your thoughts as to what day that was.
Yes, Your Honor, Elizabeth Laws Probation Department, it was August 9, 2009. Yes.
I don't know if I need leaving in here, to be honest. I just wanted to clarify that. So the failure to report was on August 9th of 19, right?
That is correct, Your Honor.
Okay.
All right, thank you.
So thank you very much. You're all set. So Ms. Patillo, what would you like to say? And by the way, just for the record, I am dismissing pursuant to the agreement the two other cases that the prosecutor agreed to dismiss, 25B1485708A and B. All right, so what would you like to say?
So, Your Honor, Ms. Jackson does apologize for how she entered the court. Back in 2019, Ms. Jackson indicated to me that she had some very bad family issues. She was in an abusive relationship, and I believe the abuser's case was in this court. She had to come and testify, not against him, but for him. It was very upsetting. She has 3 minor children. She is currently employed at Ford, but back then what happened, it was a mix of, one, the pandemic hit right around March 20th. She did fail to attend that first hearing.
Well, but wait a minute, but this was, the pandemic didn't hit till 20.
Right, but on March 1st, 2020, she was also supposed to, she failed to attend the meeting on that date, it looks like. That's what I have on my notes. The reason that she failed to attend the hearings, one is that, and you can tell me if I misspeak, did you think it was non-reporting probation?
That's what I do to understand, is that it was non-reporting probation.
I might have given you non-reporting probation, but they still got to explain that order initially, so.
I was pregnant at the time.
Why?
She had a lot.
Okay. The good news for her is I'm not one of these to hold anything against her, even though she acted juvenile. We're going to work through this as long as she understands she made a mistake and acknowledges it. And it goes so much further with me than somebody comes in and acts like we're inconveniencing them. She needs to figure out what she's going to do. She didn't clear her warrant. She didn't pay the fines. How's she going to pay the fines?
She could have a payment plan for the fines.
Where does she work now?
Ford.
She's making $32 an hour?
All right, so
I mean, I think that's great. Do you have, how many kids do you have?
I have 3 sons,
How old are they?
14, 5, and 8 months.
Are you collecting any child support?
No, he's dead.
Oh, geez, I'm sorry. I really am. Okay, I'll tell you what I'm gonna do. All right. Let me see something here. counsel, I'm gonna set this for sentencing. I'm gonna set all these for sentencing. If she's gonna get her act together and she's gonna get her money together, she's gonna try and go and clear warrants. That's what she's gonna try to do. I don't remember where they all are. We're gonna give her a sentence date. I'm just gonna make a note, defendant to save money. Clear warrants. We're gonna give her about 5-6 weeks to come back, so hopefully she'll at least be able to pay this one, and then I will set a sentence date on the other two.
Okay.
So how long do you think it'll take you to save about $400 on this suspense charge, ma'am? Oh, wait, she's got a bond. She posted a bond? Oh, that's in your name. You got 4,010%. Okay, so we keep by law, how much is that? $455. Now I'm gonna continue the bond. You save money on these others. You go over and try and clear your warrants. Let me just check. Did you see where she's got warrants outstanding now?
Judge, some of them you cleared, right? Your license is.
All right, here's what I'll do. We'll just continue your bond. We'll give you a sentence date. Lisa, give me one about 5-6 weeks when Ms. Patillo is here. Will you please?
June 18th at 8:30.
June 18th at 8:30, okay?
Okay.
So that'll give you time to save some money and do whatever else. Stop driving though. Please don't let me see.
My license is valid.
Oh, it is? Good. Good.
I just want to apologize.
You're fine. Let me tell you something. I believe you. I believe you. It's all right. I'm not going to hold those kinds of things against somebody. I'm a horrible judge if I do that. You're gonna be fine. We're gonna help you through. Just show some humility and go so far.
Yeah, but I'm not trying to act like a victim. I was
All right, you're fine. Let it go. It's okay. You're fine, honestly. Good luck. I really wish you well. Go down the hall, get your notice, and we'll see you back here, okay?
Thank you, Judge.
Thank you very much. Do I have another one with you, or is there something else?
Sure, Judge, I need to try to go back on the record. My client has traveled already.
Oh.
One of the last days of.
Okay, where's the file at? Do we have the file?
Might have taken it out.
No, just wait one second. He's here. We're gonna take this one to Mr. Polk. I'm Mr. Polk, I didn't figure you wanted to just sit here and watch.
I haven't been here long, so.
That went down long ago.
Okay, we'll get you out of here. Do we have,
That went down, and I gotta go get it.
oh, we gotta go down and get it. I'm gonna take this other one real quick. Give me that tab.
It went to probation, John.
Oh.
Yep, thank you. Wow. I had no idea. Sure.
Is that the party?
He's just leaving it set.
There's no stuff.
Oh, yeah.
People against, Lynch, Berlin Lynch Jr., 25B148216.
Yeah, Patillo on behalf of Mr. Berlin.
Is this really going to trial? Your name, sir?
Berlin Lynch Jr.
Is this going to trial?
Yes, Judge.
It's a revoked charge.
Yeah. Well, you know, Your Honor, I was just at my point to be able to.
I can't, listen to me. I'll give you the jury trial if you want a jury trial.
It's already set for a bench trial on the 21st at 1.
Oh, yeah.
I was just eligible to be able to.
I don't, listen, I'm not unsympathetic, but I'm not the Secretary of State either. I mean, I don't know how you're gonna win this. If she wins this, I'm gonna write to the American Bar Journal and tell her you better put her face on the cover. I mean, it's a drywall revoked, you know what I mean? It's about as easy. A 9-year-old I could coach and they could win that case. It's fine with me if you want to go to trial. It just seems to me that this should resolve. I'm setting a, oh boy. That's Judge Hessen's docket, is it, or is it mine, Lisa?
No, it's ours.
And I said it. Yeah,
1 o'clock.
Yeah.
1 o'clock on 5/21.
Yeah, that's the latest. I'm gonna set a final pretrial on that, May the 21 at 10 o'clock. Okay? Okay?
Thank you, Judge.
Thank you very much, Mr. Tio. I appreciate it. Sir, go down the hall and get your notice. You have to show up at 10 o'clock on that day. Recalling Sheena Nikita Wells, 25B1480128A. And I also have the B file. Mr. Polk, your name again?
Once again, please sound recorded very quickly.
Ma'am, your name?
Sheena Wells.
When does she need to leave the state?
13.
Yes.
For how long?
Through the 17th.
Can leave state between May 13 and May 17, 25. Good luck. Anything else, counsel?
Nothing else.
Have a great day. Thank you. Okay. Is that it?
I don't know, I think Matilda still has more.
What's that?
I think she has a couple more.
All right. Let's go. Yeah. Wilson, Jessica Janine Wilson, 25B1485188. Defendant failed to appear, we're going to issue a show cause, file B. Default judgment is entered for failure to appear. People against Godbout. Daniel Michael Godbout, file 25B148549. A and B and C. Now, the B and C files, we're issuing show causes, and on the A file, there's a default judgment. I need her in here, please.
She's pending, Ms. Roper's gonna be administrative there.
What's that?
There's a plea on Ms. Roper.
Tell him I need her in here. Joe D. Oliver Jr. Alvaro Jr. 25B148232A, B, and C. First of all, on the A file, that's a drunk driving. I have to issue a show cause. On the B file, I have to issue a show cause instead of issuing a warrant. C file, open intox, issue show cause. Default judgment on 25B148233. Default judgment, that's a PBT refusal. People against Respinder Singh, file number 25B148177A and B and C, and then 25B148178. So on the A file, B file, and C file, I'm issuing show causes. Default judgment on the other file. People against Thompson, Joshua Richard Williams Thompson, 25B148082. Defendant failed to appear and issue a show cause on that case. People against.
Your Honor, if I may, Mr. Thompson is in Wayne County.
Yeah, this is the one. Okay.
I just found out yesterday.
But he's in Wayne County Jail. This might be the one that Lisa was talking about. Is it, Lisa? Do you know?
Yes.
So he's in Wayne County Jail. So let's just reset it, reschedule it. He's not on bond on our file. People against, defense. This is Perlene Susan Doucette Hammond, 25U561767. A and B and C. I ordered, I believe, a competency exam on this one. And I'm going to go ahead there. She's there today. Rescheduled this. I'm just going to indicate C letter. She was supposed to show up at the forensic center. So we're going to reschedule this one, Lisa, for May 21. An competency exam was ordered, so on that one, I'll reschedule that. Jonathan Ryan Mukastan, 2523144450. Do you have the file, please? And then enter. All right, he failed to appear. This was scheduled for testing or for sentencing. 75, 10%. People against Roper. Alasia Sean Roper, 25B256867. This could be a plea to disorderly with the assault to be dismissed. Correct, counsel?
The opportunity on behalf of Ms. Alasia Roper.
Your name, ma'am?
Alasia Roper.
If she pleads, this is a plea to your name? She's going to plead to this charge. Disorderly with the understanding the A and B be dismissed and it's going to be taken under section 771.1, true?
Yes, sir.
Is that what you want to do, ma'am?
Yes.
If you plead guilty to that, the possible penalties are up to 500 fines, 90 days jail, costs or all those. I'll take it under 771.1. I'll set terms and conditions. If you're compliant from the sentence date during the period of probation, the case will be dismissed. Do you understand that?
Yes.
And did you sign, read, and understand the advice of rights?
Yes.
You plead guilty of giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes.
To the charge, the disorderly person, how do you plead? How do you plead, ma'am?
You plead guilty or not guilty?
On April 1 of 25, were you in Brownstown Township?
Yes.
What happened?
Me and my sister were arguing.
Did you strike?
No.
Did you threaten to strike her?
No.
What do you mean arguing loud? I get so tired of this. Is the problem. I'm just telling you guys. I try to not get involved, but pleaded disorderly. I got people stealing things and assaulting people, and then I got loud. Well, you know what? Maybe I just don't want to take the plea. Got loud where? Inside the house? No, that's not good enough. Come on. That is just not good enough. It's not going to be good enough for me. I got loud. Okay, I'm loud right now. Am I disorderly? Can they charge me with disorderly? Nope. We're going to reschedule it, May 21, 8 o'clock, 8:15 in the morning. And you're going to have to figure out something else. If not, if it doesn't resolve, I'm setting it for trial, okay? 8:15 in the morning. But really, I don't mind disorderly if that's what prosecutors want to do, but they better coach these guys because I'm not going to be taking this garbage anymore. I got loud. Okay. I mean, there were $917 worth of property taken, and somebody wants to come in and tell me they got loud and did nothing else. That's what I'm doing. Rescheduling Lori Sue Potter. Is she here?
She's not, Your Honor, just custody and time.
25B14787-9A and B, reschedule pretrial, defendant not put in front of camera. Okay, I don't mean to quarrel with people, but I get tired of hearing this disorderly all the time. Disorderly, I don't know, it's not right. That's what I'm doing, thank you guys. We'll reschedule this one.
You too, thank you.
Bye.
Thank you.